Self-defense or murder? That is the question in the toxic relationship trial for Daisy Link. Prosecutors say the Florida woman allegedly murdered her boyfriend. Link says she was acting in self-defense. Scripps News Group Miami reporter Leanne Morejon has a look back at what happened in day one of this trial.
Daisy Link cringes at the sights and sounds from a sergeant's body-worn camera captured during the wee hours of June 25, 2022, when Homestead police responded to a call about a man bleeding out. The state says Link made that call herself moments after she fired the single shot that killed Pedro Jimenez, her on and off partner and father to two of her children.
In a fit of rage, she pulled out the gun, and the facts will show he had turned around and was running away in fear.
The state and defense both agree Link's relationship with Jimenez was tumultuous.
Arguments, anger, and even jealousy.
But the defense paints Jimenez as downright abusive. They say Link shot Jimenez during an argument in fear for her life.
The evidence will show this man was out of control. He was unhinged and he was dangerous. And she fired a shot to get him to go away.
A Homestead sergeant testified to Link's behavior at the scene, where she implied she didn't know what happened to the victim.
She was screaming. I believe at one point she stated she was asking him what happened.
Contrast that with what she's caught saying with the gun still in her hand.
A gun was located inside an areca palm.
Link made headlines for other reasons last year when she was impregnated by another inmate while behind bars. But jurors are not expected to hear those details during her murder trial.
Yes, but we want to talk about those details because well, you got to hear it. So the jury's not going to hear it. According to multiple reports, Daisy Link becomes pregnant while in jail from another inmate. All right, well, somehow they got together, you think? Well, no, this is what apparently happened. Reports say that the dad, who is also on trial for murder, sent his semen through the old air conditioning vent using string and saran wrap. She would later say this was a miracle, this conception. How would this evidence have tipped the scales if the jury was able to hear about it? Let's bring in Dr. Debbie Goodman, criminal defense attorney David Bruno. This is a lot to get your head around. You receive a package through the air conditioning unit, and you can do a lot of things with that. She apparently decided to do something with it. What's your take, Dr. Goodman, on why you would? What's your take on this?
Thank you, Ted and David. You know, we've talked about so many cases, and we think we've heard it all, seen it all. But wow, this one I've never heard of, and admittedly, I had to read this one twice. So, we just talk about the crime itself, and I don't think it's self-defense. I think it was, she's guilty of murder, perhaps the second degree. And secondarily, this issue about the becoming impregnated, my first thought is always, okay, some type of inappropriate liaison or relationship with an inmate and a prison staff member, a corrections officer, and that didn't happen. And then when we got the details of what did happen, it is quite astounding and quite alarming. So I am certain that as we're speaking about it, so are corrections administrators and command staff throughout the country at prisons and jails. And historically, we know about contraband, that it's drugs, it's weapons, it's money and phones. And I think this now has to be added to the list, and that would include bodily fluids.
David, if the jury's not going to hear about this, clearly, if the jury did know about it, would it help or hurt her?
Hurt her. I mean, it goes against credibility. It goes against, the right to follow the rules. And that's what our criminal justice system is for, to keep it out. All right. In this state and in most states, there's a rule of evidence, 404B. Generally speaking, we don't want to bring in the bad character evidence, the other acts evidence, the things that have no bearing on the allegations in the courtroom. And this is a great example of that. It does not come in. It's not there to prove plan, purpose, identity, lack of mistake, motive, opportunity, none of those things that would be otherwise permissible reasons to bring in other acts. So she's lucky because it's prohibited in her criminal trial, and I don't think it's going well anyway. But if it was admitted in addition to the video and the statements that she made in her criminal trial, it wouldn't help her either.
Dr. Debbie, this relationship, everybody agreed, was very toxic between the victim in the case and the defendant. They would fight a lot. And the defense here is self-defense, that she was scared because he was in her face, and even though he was running away, she shot him. Is there a scenario in a toxic relationship where it seems to be a give and take? Both are at it. It's not a battered partner syndrome scenario. Is there an opening for her in terms of a defense that I was scared for my life, even though it's well documented they fought a lot?
Not based on the facts of this case. That certainly in other circumstances, yes. But again, Mr. Jimenez was running away. He's the father of her children. Her conduct displayed on the body cam, the testimony in terms of what she said, just this lack of remorse and carefree attitude, and, oh, you'll be okay, as if he got a little, he stubbed his toe or something. So I don't see it at all. I think she is going to be found guilty of a second-degree murder.
Yeah, when she's walking away, gun in hand, you'll be all right, I didn't hit an artery. I mean, and just so callous, and she's not displaying this, at all, and the jury has seen that video, so one would tend to agree with you. Dr. Debbie, David, Dr. Debbie, thank you very much for your time on this Friday. Enjoy your weekend. We are going to slip in a commercial break. Up next, it is Court TV Live, and we are headed to Ohio. Unaired testimony that we were prohibited from airing yesterday. It's basically yesterday's testimony. Well, now we can air it, and we're going to do just that when we return. It's the defense case and the expert on the stand in the Bionca Ellis case. Stay with us.
MAOIs. Tell your doctor about all medicines you take to avoid a life-threatening condition. Increased risk of bleeding may occur, especially if taken with aspirin, NSAID pain relievers, or blood thinners. Manic episodes, eye problems, low sodium levels, and sexual problems can occur. Suddenly stopping Trintellix may cause serious side effects. Common side effects include nausea, constipation, and vomiting.
I'm going to talk to my doctor again about Trintellix.
Ready when you are. Ask your doctor if Trintellix could be right for you.
Have a great trip.
Do you think they'll be okay?
Nothing's gonna happen. And if it did, your parents will take care of the kids.
Doesn't count. What you need is a will. Something you can sign and make official. Get started at trustandwill.com and make it count.
Need better sleep? We can help. Upgrade now to a queen mattress and adjustable base for just $499.99. Mattress Firm. We make sleep easy.
Backgrounder on this case, and for that we will turn to Court TV's Julie Grant.
I'm at North Olmsted, Ohio, Giant Eagle. Someone just stabbed a kid and a lady in the parking lot.
Chaos breaks out in the parking lot of a Giant Eagle grocery store just outside of Cleveland, Ohio on June 3rd, 2024.
There was a child. He's bleeding all over the place. We're at North Olmsted Giant Eagle.
Margot Wood was shopping with her 3-year-old son, Julian, when they were attacked by a knife-wielding stranger.
The young child suffered 2 stab wounds, one to the face and one to the back, and then she suffered one to her shoulder area.
Julian died of his injuries, but his mother, Margot, survived.
I need a car to go help the kid. He's in the first couple aisles.
Where's your cuffs? Get custody? Who's got cuffs?
33-year-old Bionca Ellis was arrested on the edge of the parking lot where the stabbings happened. A long blade knife was found on the ground near where she was cuffed.
Did she say anything?
No, I didn't hear anything. I had my windows down. I didn't hear anything. All I heard was just screaming, and the lady grabbed her child up out the cart, and that's when it fell over, and they collapsed over here, and the lady just continued to walk off.
Police say Bionca Ellis stole a knife from a nearby thrift store. Surveillance video shows Ellis walking into the grocery store with the knife in plain view.
It was very, very upsetting that someone would do that to a child and their mother.
As Margot Wood swerved her grocery cart to avoid running into Bionca Ellis, Ellis turned around to follow Margot and Julian out of the store, the whole time swinging the knife by her side.
As a mother, I cannot even begin to fathom the sense of loss that this family is going through.
Ellis is facing multiple charges, including murder, attempted murder, and felonious assault.
Have you received and read your indictment?
I don't know.
You don't know if you've received it?
She was found competent to stand trial after her defense team requested a mental health evaluation. This after her behavior in the courtroom raised questions about her ability to assist in her own defense. For the family of Julian Wood, they'll never get over the loss of their child.
She took everything from us. There's nothing that could ever replace my son.
It's just heartbreaking that family lost their son because of this. It's hard to get your head around. The defense case is trying to convince this jury that she was insane at the time of this so that they should find her not guilty by reason of insanities. They're putting on the defense case. Yesterday, their first witness out of the gate was a woman by the name of Dr. Megan Testa. Let's go in and watch that testimony together. This is direct.
From November 2015.
Yes.
And December 2015, February 2016, October 2018, up to June of 2021. Do you know if she was hospitalized further?
Yes, 3 additional hospitalizations due to presenting to the emergency room off medications.
Okay. And then in September of 2023, on page 6 of 14,
yes.
Was she hospitalized again?
Can you repeat the date?
September 2023.
Yes.
Okay. And can you tell us about that?
Yes. She had been taken to the Fairview Emergency Department. She had called 911 at that time. She stated that she didn't feel safe. She had been out of medications for about a month. She was unable to obtain refills in the community. She was seeing visions of people coming out of her walls to try to kill her at night. She was talking about Albert Einstein and a bowl of ants. She had been able to sleep. This record stated that she was visibly hallucinating at that time. They admitted her to Marymount Hospital, and she required an 11-day hospitalization and was stabilized on antipsychotic medication at that time.
Okay. And then it looks like, again, in October 2023, there was some issue with her medications. Is that correct?
That's correct. She had run out of the medications that she received through hospitalization and was hearing voices. The voices were telling her to kill herself. She developed some suicidal thinking. She had cut her arm with a razor. She was taken to the emergency room. She, in the emergency room, was talking about paranoia of food. She hadn't been eating. She was also talking about seeing visions of whales and fish, voices telling her to go to war. She was talking about martial law, airborne disease. Disorganized thinking was noted in the medical record. She was hospitalized and stabilized again on antipsychotic medication. It was a 7-day hospitalization.
Let me take you into 2024. In February 2024,
Yes.
Was she again at the hospital?
She was.
And tell us about that.
Yes. She was pink slipped at that time. What that is that's like an emergency order that police can write stating that someone should be evaluated in an emergency room due to a mental health crisis. So
I'll jump in again. So just
slow you down.
Yeah, just you're fast too, so I want to make sure Rob's able to do it. I know he's going at a high rate with you, so
yes.
I'll just ask you to be mindful, if you can, of just slowing down.
Yes.
Okay. So go ahead. Your question again was about that last hospitalization?
Yeah. In February 2024, was she hospitalized again?
Yes, she was.
Okay. Tell us about that.
She had been taken to an emergency room by police. They had ordered that she be admitted, evaluated in the emergency room. So when she got to the emergency room, police told the professionals there that she had called and asked to be arrested for murder and conspiracy. There was no evidence for arrest for that. She was agitated in the emergency room. She was engaging in threatening behavior, bizarre behavior, screaming. She threatened self-harm. She was evaluated and stated to be hallucinating. She had delusional beliefs talking about the murder of El Chapo, and she was hearing voices of mafia individuals talking. And she was recommended for hospitalization, noted to have acute decompensation of chronic psychotic disorder. They evaluated her and they set for a transfer to an outside hospital. There were no beds at Metro.
All right. Let me take you to the date of the incident.
Yes.
June 6th of 2024, while Ms. Ellis was in jail, do you know if she was evaluated by a psychiatrist? And I'm referring to the top of page 7 of 14.
Yes. So she was jailed in the Cuyahoga County Jail shortly after the offense, and that was on June 6th. She saw the psychiatrist who works in the jail. His name is Dr. Baskin, and he evaluated her. He noted that she was limited in her willingness to engage with him. She spoke to him in a curt manner. He described her as being bizarre in many of her answers, disjointed, and paranoid. And he, on that day, he diagnosed her with schizoaffective disorder, and he prescribed her Haldol, an antipsychotic medication, and he prescribed Cogentin for side effects, but she refused to take the medication. She said it was unnecessary and did not take it.
So let me stop you there. I misspoke. That's not the date of the incident. That's 3 days after the incident.
Correct.
Is that when she met Dr. Baskin in the
That's
county jail?
correct.
Okay. Ms. Ellis also was seen by a Ms. Stevenson, a social worker. Can you tell us the observations that were part of your evaluation?
Yes. So Ms. Stevenson, she's a social worker who works in the Cuyahoga County Jail. She noted that Ms. Ellis was seen sitting on the floor in her jail cell with no clothes on whatsoever. She was fixated on an investigation. She was eating her food with her hands instead of the silverware. She was making illogical statements, talking about dinosaurs, things that made no sense.
All right, let's get a break. That's a portion of the defense expert, the first witness that the defense put on the stand. They have another one on the stand this morning. Let's get a break. We'll have more when we return. Stay with us.
My two best friends were just murdered. Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dave Martell ever walked on.
It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands. New episodes Saturday night, 8 Eastern and Pacific.
Only on Court TV.
I moved, and she stabbed him in the side of his face. And then she stabbed me.
Take a minute and ask a question.
Margot Wood talking, testifying about losing her little boy to Bionca Ellis, who's on trial for murder. Everybody agrees, even the defense, that she's the reason the boy is dead. Why? Because she stabbed him in the parking lot of a grocery store. There are court restrictions in this case. They're back at it live in Ohio. We can't show anything until tomorrow. That's by court order. Right now, the defense has put on their second expert witness. They expect to finish their case today. We'll have a rebuttal expert, I'm sure, from the state, and then closing arguments on Tuesday. We have been told that we can air those closing arguments in the verdict live. So that will be on tap for Tuesday. Right now, we're going back and listening to this unaired testimony from yesterday. And this is a big part of the case. This is the defense. The defense is she was mentally insane, legally insane at the time of the murders. And their first witness is Dr. Megan Testa. We'll pick it up where we left off before the break.
I want to take you back to the questions that we were discussing before we got into your report. And there's some history of non-compliance with her medication. Is that correct?
That's correct.
All right. And is that something that's typical with this population? And when I say this population, I'm talking about people who suffer from psychosis, schizophrenia, and other disorders?
Yes, it's typical. It's estimated that about 50% of people with schizophrenia are non-compliant with medications at some point in time. So it's very typical.
Okay. And can you speak to the voluntariness of it, or the voluntariness of it? Is that something that, why is it a part of that population? Why so high, 50%?
There are a lot of reasons for medication non-compliance. So in the population of individuals with schizophrenia, one symptom of schizophrenia is a lack of insight. So as we were talking about earlier, it feels real to the person with schizophrenia. What they are thinking feels real, what they're experiencing feels real. If you or I were told to take a medication and we did not think we had the disorder that we were being told to take the medication for, we would probably not take it. So for a lot of individuals with schizophrenia, that's how it feels. They think what they're going through is real. They're not going to take a medication for a disorder that they don't believe they have. And so poor insight, it's very common in psychosis and in schizophrenia, and that can lead to medication non-compliance. There are other reasons too, difficulty accessing care in the community, running out, missing your appointment, and then if you get off your meds a little bit, you can backslide very quickly and then you're in a state where you don't want to take your meds. So that's why it happens, and it's very common.
Okay. Be fair to say that based on your review of the records and your experience with her, that she generally improved when she would take medication?
There's very clear evidence of that.
Okay. And was there some point in time that you had, or someone had discussion about the number of children that she had?
Yes, she was expressing, the first time that I interviewed her at North Coast, she expressed that she had 23 children. She stated that she had these 23 children when she was in the kindergarten.
Okay. When she was in kindergarten?
Yes, sir.
And was that part of her schizoaffective thinking or schizophrenic thinking?
Yes, that was part of her thought disorder. When I met her in September or late August for the September report, she did not believe it was part of her thought disorder. She believed it was true. She believed this interfered with her schooling. She was crying at night at North Coast, wanting to find these children that she believed were taken from her. So she believed that was true. When I saw her in January on medications, she said that that was part of her schizoaffective thinking, was the word that she used. But she had gained insight on medications that that was not true.
Okay. She also described delusions involving NASA, Queen Elizabeth, the FBI. Can you tell us about those?
Yes, when I met with her in August, she expressed a number of very bizarre ideas. She talked about the FBI, conspiracies. She talked about espionage. She talked about Jesus Christ in the Bible, Matthew from the Bible, and him in taxes, related with taxes. She talked about people walking on water. She spoke of noise pollution, having these 23 children. And she also did speak about Queen Elizabeth and...
Okay. And those thoughts are consistent with psychotic illness rather than rational thinking. Is that fair to say?
That's correct.
Let's talk a little bit about her course of treatment at North Coast Behavioral. When Ms. Ellis was first admitted at North Coast in August of 2024, I saw the term she was floridly psychotic. Is that correct?
That's correct.
Can you tell the jurors what that means?
The word floridly psychotic or also grossly psychotic is a term that means that they are displaying symptoms of severe psychosis.
Okay. Was she disorganized in thought and speech?
She was very disorganized. Her thoughts were one to the next, FBI, Queen Elizabeth. None of it was linking together or linking with reality.
Okay. And initially, did she refuse or did she comply with taking medication?
She refused medications. So she refused medications in the jail. That continued until she got to North Coast. She refused medications at North Coast. She told me she would not take any medications prescribed to her by her treating psychiatrist. The reason was she said she didn't need it. She also had some delusions about the pharmaceutical industry, and she believed that her disorder could be treated with bananas, riboflavin, and apples.
Okay. And a forced medication order was eventually obtained in September 2024, is that correct?
That is correct.
Okay, and what is that? What happens with that?
A forced medication order can be issued by courts. So it can be issued by a probate court or a criminal court. In this case, when I saw Miss Ellis, my opinion was that she was ill and that she required medications. It would be in her best interest to take medications, that medications would be the least restrictive manner to relieve her suffering and alleviate her symptoms, and that it was the only way to restore her competence to stand trial would be through medications. That was my opinion at the time. Her treating psychiatrist, Dr. Vanderkar, had opined the same, that she lacked the capacity to really understand the benefit of medications, that medications would help her, and that it was the only way to restore her competency. So based on an opinion of two different doctors, two independent doctors, the court can issue an order to say that that patient must take medications whether they choose to or not, because it is in their best interest and they deserve a chance at that treatment. So that was issued in this case, a forced medication order to provide Ms. Ellis with treatment.
All right, Dr. Megan Testa, testifying on behalf of the defense. Joe Tamburino is with us. He's a former prosecutor, currently a criminal defense attorney in St. Paul, Minnesota, Twin Cities. Joe, this is a very good witness. She's compelling, intelligent, and is telling us a story of mental illness in terms of the defendant's behavior and some of the things she's done and that this doctor witnessed. How does the state then combat this? If you have a juror or two who are listening to this testimony and thinking, oh my gosh, this lady is out there, Queen Elizabeth, NASA, taxes, and a bowl of ants. How does the state then combat it to focus on the law and not the obviously mental illness of this defendant?
Sure. I mean, what they're going to do is point out specific facts. When this doctor, who I agree, she's doing a very good job for the defense, but when she's saying things about schizophrenic, the number one thing that the prosecutor could raise is just because you're a schizophrenic does not mean you are legally insane. That is, everyone agrees with that. That's number one. Number two, what are the acts that Ms. Ellis did which show that she was thinking about what she was doing? Well, when she was picking out a knife that she was going to steal, when she deliberately went to pick this victim who was very, very vulnerable, when supposedly after that she tried to hide the knife, when she was encountered by the gentleman who testified already in the trial, she shrugged her shoulders and said, "So what that I stabbed him," to point out these specific things. Next,
isn't that last point isn't the last point the witness who says she just shrugged her shoulders? Doesn't that help the defendant on some level? If she was sitting there going, "Oh, I can't believe I did this. I'm sorry," then I mean, she seemed to be in character in terms of over the hump of Nutville by saying, "Oh, sorry," to a dead kid.
No, the way I would attack it is the following. When she was confronted by that gentleman who said, "Do you know you just stabbed the kid?" Think about what she did not say. She did not say, "Oh, I just got rid of a demon. I executed somebody who's evil. I just had to kill a wild dog," like she was in some type of hallucination. She was leaving the scene at the time that this was happening. All of that can be used to show her state of mind, that she knew what she was doing. In many of these mental illness cases, these insanity cases, the ones that have been successful, and there's very few, there's evidence that a person didn't even know they were harming a fellow human being. They thought they were killing a demon, something that was evil, or some type of wild animal. They had no idea of the nature of their acts. In this one, I think it works against the defense when she said, "So what, I stabbed a kid."
Great point. All right, let's get a break. And when we come back, more of the unaired testimony in the murder trial against Bionca Ellis. Stay with us.
saw a woman stabbing a mother and child. I saw the knife covered in blood. I saw violent motions towards a mother and her child.
Happening now, the final defense witness is on the stand, a medical expert. Closing argument set for Tuesday in this case. The courthouse is closed on Monday for Columbus Day. Today, we're airing unaired testimony because of the judge's order in this case. We can't air live testimony. So what's happening today will air once they are done for the day. Right now, we're listening to this doctor, Dr. Megan Testa, and she's telling the jury what she observed by analyzing this defendant and basically saying she was schizophrenic. It's going to be up to the jury to decide to what level was she mentally impaired at the time of the murder. Let's go back in and listen to more from Dr. Testa.
And after that order, she began taking Haldol, and is it clozapine or clozapine?
Clozapine.
Okay.
Is
that correct?
She did. Dr. Vanderkar initially prescribed Haldol. That's an antipsychotic medication. She tried to bring that medication to a therapeutic dose, but Miss Ellis had some side effects, some anxiety, and some motor effects. She tried to treat that side effect with the medication Ativan, but she didn't respond well to Haldol. At that point, she offered Miss Ellis the medication clozapine. The medication clozapine is reserved for treatment-resistant schizophrenia or treatment-resistant psychosis. So as a psychiatrist, I can only prescribe clozapine to people whose illness is what we call treatment-resistant. So if they have failed to fully respond to other medications, at least 2, then I can try them on this medication clozapine. So because her illness was deemed to be treatment-resistant, Dr. Vanderkar started clozapine for her.
Okay. And once the clozapine was introduced, was there gradual and sustained improvement observed?
Yes, there was. So her course with clozapine, the reason why it's reserved is because there are a lot of side effects to monitor for. And Miss Ellis has some physical health issues as well. So balancing the medication, the side effects, monitoring her other health conditions, that made the process of treating her complicated for Dr. Vanderkar. So there were some ups and some downs where she would do better and then they'd have to hold off on raising the dose, or they'd even have to lower the dose. At a point they had to stop the medications and obtain a consult from a cardiologist to ensure it was safe for Miss Ellis's heart to continue to take that medication. So it was a gradual course with some ups and downs, but what was clear in the North Coast chart was that she continuously improved on clozapine to the point where her thoughts became organized, her thoughts became reality-based, she stopped hallucinating, and she was able to engage in competency restoration groups and stabilize on that medication.
Would it be fair to say her competency was restored through consistent antipsychotic medication over time?
Yes.
Okay. Your January 2025 evaluation, was Ms. Ellis alert and oriented?
She was.
Okay. Again, you attribute that to the medication?
Yes.
Okay. She was able to identify her charges and understood that they were very serious, even mentioning the death penalty. Is that correct?
That's correct.
Okay. Was she able to identify various plea options, including not guilty by reason of insanity?
Yes.
Okay. Does she understand the courtroom roles of each person involved?
She did.
Judge, prosecutor, defense lawyer?
Yes.
Okay. And before, she never had the ability to do that until she started taking the medication. Is that correct?
That's correct.
Okay. Is it true that she still carries an active diagnosis of schizophrenia?
Yes, schizophrenia is a brain disorder. So once you have it, it's a lifelong brain disorder. It does not go away. It's chronic illness.
Without medication, would her symptoms likely return?
Absolutely. I mean, we know it for most people, that's true. But we know it as a fact for Miss Ellis because we have her records. It's very clear from her records when she stops medication or when she runs out, her symptoms return.
Okay. Even with medication, individuals with schizophrenia can experience intermittent relapses. Is that correct?
Yes, that's true. That's why, as psychiatrists, I see my patients with schizophrenia at least once a month. If once they were on meds, their symptoms would be gone forever, we would have no need for follow-up. You know, we would just put them on those medications, and that would be that. But it's not how it is. That's why we need ongoing visits. We might need to titrate medications or change them.
Okay. In your February 2025 report, did you opine and make certain findings?
Yes.
And can you tell the jurors what those are?
Yes. So my first role, as we talked about, was competency evaluation. My second role was, again, competency evaluation. So when I saw her on January 15th, I was evaluating, does she have a present mental condition? Can she understand the proceedings she faced? And can she assist in her defense? I did opine with reasonable medical certainty that she had schizophrenia. That was my diagnosis of her. That I based upon her long, well-established history of delusions. So those are the fixed false beliefs, as well as her disorganized thinking and her auditory hallucinations. So that established a diagnosis of schizophrenia. So my first opinion was that she did have a present mental condition. My second opinion was that she, despite her mental condition, was able to understand the nature and the objectives of the proceedings she faced. And that was because she was on the antipsychotic medications. Okay? And then my third opinion was the same, that she could, in fact, assist her defense because she was stabilized on the medication.
All right, let's get a break. More from this doctor. When we return, a reminder in real time, there is another defense witness on the stand, the final witness for the defense before the state presents a rebuttal case, and then closing arguments on Tuesday. Monday, court is dark for Columbus Day. Stay with us.
I'm Vinny Politan. Welcome to Closing Arguments.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
A wife accused of murdering her prominent attorney husband, and the defense involves blaming her own sons?
Victim to Verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
head back to Ohio now for more testimony in the Bionca Ellis trial. On the stand, defense witness Dr. Megan Testa.
Agree that if she discontinued her medication, her symptoms could return?
Her symptoms would return, so it's not even a could. Her symptoms, yes, they would return.
And if that occurred, she would again become incompetent to stand trial. Is that correct?
She could. She would require a reevaluation.
All right. And in your report, again, you note she still has schizophrenia, has a present mental condition right now. Is that correct?
That's correct, yes.
Okay. And is it your contention that that condition existed at the time of your evaluation and likely existed long before her arrest?
Yes, it existed since 2015 per the records.
Okay. All right. In her prior psychotic hospitalizations or psychiatric hospitalizations and delusional thinking predates the charged offense. Is that correct?
That's correct.
Okay. And those records that you have reviewed reflect a pattern of losing touch with reality when she's off of her medication. Is that correct?
Yes, that's very clear in the records.
Okay. Now, let's be clear. Your evaluation focused on competency to stand trial. Is that correct?
That's right.
Okay. Not Ms. Ellis's mental state at the time of the alleged offense. Is that correct?
I did not evaluate sanity. That was not my role.
Okay. So you were not asked to give the opinion of whether or not she knew the wrongfulness or not of her conduct in this case. Is that correct?
That's correct.
Okay. So your report does not address her sanity at the time of the offense.
It does not. I wasn't assigned to do that, and so I did not even ask the questions one would ask to perform a sanity evaluation.
Okay. But you are able to say that her same mental illness would have been present at the time of the offense. Is that
yes, she had schizophrenia. She was ill at the time, but I don't have an opinion on legal sanity because I did not do that evaluation.
Okay. Even though you didn't do the evaluation, have you ever done an evaluation for sanity?
Yes.
And can you explain to the jurors what goes into doing that kind of evaluation as opposed to something for competency?
Sure. Competency is, when I do a competency evaluation, what I do is I meet with the person that I am assigned to evaluate, and it's an evaluation of them at the moment that I'm seeing them. What is their mental state at that moment? And then do they have what's called adjudicative capacity? So can they understand their charges, how the courtroom works, and can they assist their lawyer at that moment in time? That's what I was assigned to do, and that's what I did twice. A sanity evaluation is very different. What a person who is doing a sanity evaluation will do is they will go back. Once a person is competent, they will sit with them. They will gather from them their account of the days preceding the offense, their account of their mental condition around the time of the offense. They'll get their account of the offense itself, and then they'll review extensive records from collateral sources, hospital records, maybe emergency room records, police records, anything from the time of the crime. The role of someone who's evaluating sanity is to look at the time of the crime and make some determinations about how the person was then, why they did what they did, and whether their illness interfered with their ability to know it was wrong. That's a sanity evaluation. That I did not do.
Is mental illness limited to a particular group?
No, it is not.
Okay. Doesn't matter how much money you have, what color you are, what your age is.
No, we all have brains. It's a brain disorder, so it doesn't discriminate.
Okay. When someone, whether they're on medication or not, you can have a psychotic episode. Is that fair to say?
That's correct.
Okay. And we talk about psychotic episodes. What are we talking about?
To talk about a psychotic episode, it's not something that's in the diagnostic manual. So, but how we use that term is the person is having active symptoms. So I could have a patient who has psychosis, but they're on their meds and they are not having a psychotic episode at that time. The psychotic episode would be when the symptoms are present and those symptoms are active.
She's a good witness, boy. She knows her stuff. You can tell she has many patients with schizophrenia. Joe Tamburino watching along with us, prosecutor, former prosecutor. Now he's a defense attorney up in Minneapolis, St. Paul. One would have to think if this doctor had Bionca Ellis as a patient, that this wouldn't have happened. But that is assuming that the schizophrenia is the reason that it happened. What's your take on, first of all, how well this doctor is doing, and then also whether the mental illness is a component of this murder?
Well, I think the doctor is doing very well. However, there's one big gap in what she's saying. She didn't do a sanity evaluation. I mean, that's why we're here. This is an insanity defense. The defense has raised the affirmative defense saying, look, my client did it, but she didn't know the nature of her acts at the time because she was legally insane. And we just heard this expert, though she's an excellent expert, there's no doubt about it, say that she didn't do a sanity evaluation. That's going to be a problem, and the prosecutor is going to jump on that.
Well, we do know that, I mean, she's the setup. Today, the second expert who, I assume, did the sanity evaluation is on the stand as we speak. Can't air that till they're done for the day. But you're right. I mean, she was very upfront with that. That wasn't her purview, and that's why we're here, and that's what jurors need. So the rest of it is a setup, and that is the key portion. Bottom line, for us, what's your take before we go to break? Is she going? Is this going to be guilty? Because a lot of people watching this might be nervous. Oh, she's going to get away with it.
Well, I think it will be a guilty verdict. I don't think the insanity defense is going to work here. And what you mentioned before, Ted, is very important. When you said, if this doctor would have been Ms. Ellis's doctor, would this have happened? And, you know, that's hard to answer, but we could think about this, which is, in Ohio, they could have civilly committed Ms. Ellis before and forced her to
civilly
take
committed,
medication.
yeah. Got to
That
go.
didn't happen.
Back after this. Thanks, Joe. Welcome back to Court TV Live. I'm Ted Rowlands in for Julie Grant on this Friday morning. Good to have you along with us as we round out a very busy week here at Court TV. This hour, we're in Ohio, the toddler stab murder trial for Bionca Ellis. She's accused of stabbing 3-year-old Julian Wood to death in the parking lot of a grocery store last year. Julian's mother, Margot, was stabbed as well in the shoulder. She survived. She testified. Court restrictions tell us that we can't show testimony until the end of the day, so today we're getting you caught up on what happened yesterday. And what happened yesterday was that the defense began its case in chief. They have a couple witnesses. The first witness that took the stand was Dr. Megan Testa, and she evaluated the defendant and looked at her past history and saw her after the incident happened, and she's testifying on behalf of the defendant and the defense. Well, we've heard the direct. Now let's go back in and pick up more of her testimony.
When active, can a person follow simple instructions?
Yes, a person with active psychosis can indeed follow a simple instruction, absolutely.
For example, get down on the ground, drop whatever you have in your hand. Is that something, hypothetically, that a person would still be able to follow that instruction even if it's active?
Yes, a person in psychosis could follow an instruction such as that.
Okay. And can they cooperate and be compliant even while their illness is active?
Yes.
Okay. Does the brain completely shut down, or do you still have some intelligence to communicate with other individuals?
You can communicate with other individuals with schizophrenia and with an active psychosis.
And information that you've learned over the course of time, can you still retain that information and articulate that information during communications with anyone?
Yes.
Okay. I hope that was a good question. I believe that you also opined at the time in your September 2024 report, you had some opinions then, is that correct?
Yes.
And by the way, are each of your opinions in the January report and February report with a medical degree of scientific certainty?
Yes, all opinions that I'm offering today are to a reasonable degree of medical certainty.
Okay. Tell us about your January 2024 opinion.
Are you asking me about the January opinion?
I'm sorry, January 2024.
Or the September?
September 2024. I got my dates mixed up.
Yes, sir. September 2024, that was when I initially saw Miss Ellis. My opinion at that time, she was presenting at that time with florid psychosis. Her thoughts were all over the place. When I did her competency evaluation, she was making a number of bizarre statements. I'm going to reference my report.
Okay.
One second. So, on page 11 of that report, she was able to tell me that she was facing charges, but she was not able to name them. She was not able to say why she was arrested. What she was saying was really neither here nor there. She did know that her charges were serious, but was very blasé about it. She wasn't really, she didn't seem affected by it. She had a very, very unusual affect, which is her emotional expression. So she was smiling and smirking and laughing for no reason, with no, type of event happening that should elicit that type of a response. That's common in schizophrenia as well. And then she talked about Jim Crow, Albert Einstein, relativity, NASA, and she was not able to give any information relevant to court. She also kind of was disengaged, so she was not able to really engage with me like the way that I would expect. She didn't really have much eye contact. She lowered her forearms to the table at one point and laid her head down on her forearms. Slow down?
Just a little fast.
Yes. She would derail in conversation. I tried to screen her long-term memory by asking her like past presidents. She started talking about LeBron James and Jesus Christ. She talked to me about medications and that those would not be anything she would take. Talked about bananas being needed for her mental illness, riboflavin. I opined that she had an unspecified schizophrenia spectrum disorder at that time. I could see that she was disorganized and she was hallucinating. But what I couldn't tell was if there was a mood component to her illness or not at that time. So I gave her a diagnosis of unspecified schizophrenia spectrum disorder at that time. So I opined that that was a present mental condition. I opined that she could not assist in her defense due to that mental condition. I also opined that there would be no way to restore her competency without medications. I opined that she lacked the capacity to make those decisions about medications in her best interest, and that a forced medication order would be necessary.
Over what period of time while she was at North Coast did you have the opportunity to observe her behavior?
I observed her on those directly on the two occasions that I evaluated her. I reviewed her full medical chart with 24/7 nursing observations and all the notes from all the medical professionals.
Okay. And the first date that you saw her was when?
August 28th, 2024.
Is it your opinion that her mental illness or schizophrenia was active at that time?
Yes.
Did you have the occasion to watch any video of Ms. Ellis at her arraignment for her legal proceedings?
Yes, I saw that.
And the observations that you made when you first met her in person and what you saw in those videos, is that consistent with your observations at North Coast?
Yes, her presentation in the arraignments is similar to her presentation at North Coast with the disengaging, leaning down, the bizarre affect. That is all consistent.
Would you recognize that video if I showed it to you?
Yes.
And can I ask you some questions about that video?
Yes.
Identify what's been marked as Defense Exhibit E for the record.
Thank you.
Is there audio on this one? We're going to also play Defense Exhibit C. I believe that one has audio. And if it doesn't, we'll go to a small mini laptop.
You go to the right on the bottom. Is it unmuted? It was muted at the time, so now it'll.
Date was 10/29/2020 as a proximate result of the offender committing or attempting to commit an offense of violence. It was a felony of the first or second degree to which felonious assault, Paragraphs Code Section 2903.11A1 and or endangering children in violation of Paragraphs Code Section 2919.22B2. Count 4 alleges that on or about June 3rd, 2024, the defendant did knowingly cause serious physical harm to J.W. on date of birth 10/29/2020. Count 5 alleges that on or about June 3rd, 2024,
exhausted, but she responds to that. Dr. Testa, to the ordinary person, she looks like she's laughing.
Correct.
While the judge is identifying the most serious of charges. Is there an explanation for that? Well,
As a psychiatrist looking at that behavior does not fit the setting. That does not fit the occasion. It's what we would call an incongruent affect or an incongruent emotional expression. The behavior is just not appropriate for the setting. She also looks to the side at points or looks up. That could indicate that she's perceiving something that none of us can perceive, that is in fact funny or is in fact amusing, but we cannot perceive that. That's another explanation for that behavior. What I can say is that is the behavior that we observed at North Coast while she was off medications. When she got onto medications, that behavior stopped.
Does she have the ability to control her actions if her illness is active?
One can control their actions.
How?
It's a broad question, but people with schizophrenia, they don't lose the ability to do like simple things. So it would really depend. It's a very broad question, but just having schizophrenia doesn't eliminate all your ability to control your actions.
Okay. Could she have stopped what she was doing there if her illness is active?
That symptom is not controllable. So if that indeed is a symptom of schizophrenia, that affective inappropriateness, that is not controllable.
All right. I'm going to take one moment to confer with Mr. Johnson.
All right, that was the end of direct examination of this expert on the stand, the first of two for the defense. Before we hit a break, let's bring in law enforcement expert Sonny Slaughter. Sonny, what's your overall take on this case? I mean, we all know it's just horrific. What about the defense, what we've seen so far from the defense? Your thoughts?
Good morning, Ted. Great to be with you. I always love how you put these things together, particularly these complicated, nuanced cases. And I think in this particular case, Bionca, we know she does have not only disease, but diagnosis. However, her being a schizophrenic person or a person that has this disease or diagnosis does not preclude her from understanding her actions at the time that she committed those actions. Law enforcement has done a great job at putting together her footsteps, analyzing the videos that we have been seeing, and she clearly was confident in that moment. And while she may have been triggered because she didn't get what she wanted at the police station earlier, which I think was the basis for all of this to begin, she didn't get what she wanted, but I do believe that she acted very intentionally. I think this poor baby and his mother were the victims of her having a moment where she felt like she could control the situation, even control her emotions, because she understood what she did.
As a member of law enforcement, the interaction with the mentally ill is a daily occurrence in the streets of our cities or across the country. Is there a proper, or does it, in your opinion, should things change to enable first responders who see someone who is clearly in crisis, get them help to the point of civil commitment? Joe Tamburino brought it up last hour, at the end of last hour. Had this defendant been a patient of this doctor, who seems very, Megan Testa, very accomplished, then she could have been possibly civilly committed, and then there would be a little boy that is enjoying life had that happened. What's your take from a law enforcement standpoint? We, as a country, sort of just the cops can handle it. How taxing is it, and what do you think is a potential solution to the obvious problem?
That's a great question. I agree with Joe in his last segment. And what I want to tell you is I have been doing work with one of the organizations, the Epilepsy Foundation, around people that have illnesses that are mental health illnesses or medical illnesses, and doing the training. I think if law enforcement had the proper training and had the expertise around more than just one issue, including mental health, including schizophrenia, where they could potentially Baker's Act someone, and that is putting someone in a facility for an extended period of time, usually 72 hours, to get them observed, evaluated, and to make the case. I think we would see less of these incidents. They would never completely go away because it's hard to do the cross training for them to understand. But I do think that we need more resources because families as individuals are not able to do this. And it begins to get hard for them to keep a person under control. So we do need to pull all the levers of our society to ensure that individuals like Bionca are not in our society and able to do the heinous crime that she committed. I have family members that have mental health issues, and it was a lot of work, but we did keep track of them. And as a young girl, I didn't understand mental health, but I do now, and I understand that we do need to pull every resource, every lever of our society to stop these type of incidents from happening.
Well said. Let's get a break. We'll get the cross-examination of the defense expert, Dr. Megan Testa, when we return.
Are you ready?
Game on. Let's go! This is huge for women's sports.
Keep on winning, keep winning, come on. Lay it on the line, all in. It is on tonight. 'Cause I'm ready for the win. Electric.
It's on ION. Find on your channel guide or favorite streaming service.
Back to Court TV Live. A look at some of the cases we're tracking across the country on this Friday morning. In Florida, convicted killer Jose Soto Escalera will find out if he is indeed getting the death penalty today. The final phase of his sentencing begins 1:30 Eastern Time. Also in Florida, the state's case resumes this hour in the toxic relationship murder trial for Daisy Link. She's accused of shooting and killing her boyfriend Pedro. In Ohio, the Toddler Stabbed murder trial is underway this morning. The defense presenting its last witness to the jury before the state presents a rebuttal case. And then, after a day off Monday for Columbus Day, they'll have closing arguments on Tuesday. And this hour, we're replaying some of the on-air testimony from yesterday. The judge in this case is preventing the broadcasting of the testimony until court is done for the day. So we're going back and we're looking at the first witness that the defense put forward for this jury, Dr. Megan Testa. We watched the direct examination. Now let's go back into the courtroom where she's on cross.
Ma'am, you have not only worked at North Coast Behavioral, but were you not also part of the court psychiatric clinic here in Cuyahoga County?
I worked here during my fellowship training. So I did do evaluations here from 2010 to 2011.
And at that time, who was the head of your department?
Dr. Phil Resnick.
And you worked under Dr. Phil Resnick, and you studied under Dr. Phil Resnick.
That's correct.
All right. Mr. Mack asked you several questions with regards to competency.
Yes.
And that is the only thing that you were asked to do in this case.
That's correct.
And you did it as kind of an adjunct at North Coast because though you are employed by them, you also see other patients.
Well, my employment at North Coast is part-time.
Okay.
Yes.
All right.
So I'm a part-time. I go there about once a week as a part-time employee.
All right. So you're not there full-time.
No, no.
All right. So when you rely on those 20-day stays in order for you to make your determination, you are relying on the other folks that are doing the actual observations.
So I would do my own mental status evaluation and a chart review. I would only be doing the evaluation, not the treatment.
Okay. So if we start with Defense Exhibit I,
yes,
that you've authored and testified to, you indicate here, do you not, that you also reviewed Dr. Hatters-Friedman's information?
Correct, yes.
All right. And can you tell me what you learned from that information?
Yes, like describe, do you want me to describe her opinion?
Yes. And what
Yes.
page were you on?
I'm going to find it right now. I think it is on, it's on page 8.
All right. And with regards to Dr. Hatters-Friedman, where was that evaluation done?
Dr. Hatters-Friedman evaluated Ms. Ellis at the Cuyahoga County Court Psychiatric Clinic.
Okay. And what were her interactions with her?
So she interviewed Ms. Ellis on July 30th, 2024. She was court appointed and independent.
Okay. And so what were her observations with regards to Ms. Ellis?
When she saw Ms. Ellis was poorly cooperative throughout the evaluation. She presented as irritable. She said that she thrust forward her psychotic ideas. So that's when you throw them out there.
Okay.
For lack of a better word. She observed that she tried to ask the competency questions to Ms. Ellis, and she made the statement, "I'm coherent."
I'm sorry, what did she say?
She said, I'm incoherent.
Incoherent. Okay, go ahead. And those were the words of Miss Ellis.
These are the words that Dr. Hatters-Friedman reported that Miss Ellis said.
Correct. Go
yes. To her.
And what else did she say?
She asked She told Dr. Hatters-Friedman that she needed to find an investigator and start an investigation.
All right. And then with regards to Dr. Hatters-Friedman making a determination as to competency at that particular time, was she able to?
She was not.
And why not?
She deferred to provide a diagnosis. So Dr. Hatters-Friedman noted in her report that she had insufficient information to make a diagnosis with a reasonable degree of medical certainty. So she could not opine whether or not she had a mental illness at that time. She didn't have enough information to make that decision.
Okay. And what were her observations of Miss Ellis's behavior at the time?
She noted that per jail records, she had been able to maintain some behavioral control despite refusing medications. She noted that she could not answer some simple questions, which was atypical. That means it's not a usual thing that we would see. She noted that for Miss Ellis to say she was incoherent, that was unusual. And Dr. Hatters-Friedman's words were, she could not determine if Miss Ellis's behavior during the time she saw her in the court clinic was behavioral or related to a mental illness. She could not make a decision.
Okay. So therefore, she was sent then to North Coast.
Yes.
So explain to us, to the ladies and gentlemen of the jury, when they first come to North Coast, where are they placed and what kind of observation units are they in?
When Miss Ellis came to North Coast, this is typical of individuals who are coming in for competency evaluation. She is placed on what's called a competency restoration unit. It's a psychiatric unit. It is staffed with the typical types of professionals that you would see on a psychiatric unit, and it also has forensic experts as well. So she was placed on a unit with nursing staff, behavioral health staff, psychiatrists, medical doctors, and forensic evaluators that would monitor her 24/7. They'll document her behavior in the medical chart on a 24/7 basis.
And doctor, does the patient...
All right, let's get a break. We'll get more of this cross-examination of the defense expert when we return.
it's hard to go help the kid. He's in the first couple aisles.
Where's your cuffs? You got cuffs? Who's got cuffs?
Slow down, slow down.
Hold on. We're good.
All right. Yep. Okay. Ted, you want me to go to the female or triangle?
Go to the female.
The Bionca Ellis trial is happening in Ohio in real time. The final medical expert is on the stand for the defense. Prosecution will have a rebuttal, and then they'll have closing arguments on Tuesday after the Columbus Day holiday on Monday. Right now, we're going back and watching yesterday's testimony, the first witness that the defense provided for this jury, trying to convince them that their client, or the defendant, was mentally ill at the time that this happened, and she should be found not guilty by reason of insanity. Dr. Megan Testa is the witness's name. Let's go back in, pick up the cross-examination where we left off.
And doctor, does the patient know that they are being monitored 24/7?
Yes.
And are they in their own isolated rooms, or do they have their own isolated rooms? Excuse me. And is there also a common area where peers meet and there's conversation and stuff of that sort?
Yes, that's exactly how it is. They will have rooms, and then there will be common areas as well.
And do they have access to the outside public?
People for 20-day evaluations would not have those types of privileges. Those come with levels.
Okay, thank you. And Mr. Mack asked you a series of questions about all the medical and psychiatric care that she's had in the past.
Yes.
And there were several hospitalizations that you indicated that she was hospitalized for psychiatric treatment for failing to take meds.
That's
Is that
correct.
fair?
That's correct.
All right. Now, I just want to turn your attention to page 6, which all the way down at the bottom of the page is the second paragraph up, talking about the Metro Hospital ED that we've spoken about in this case. Can you tell us why she went there and what were their observations of her?
She went there after falling off a bus, and they addressed her leg pain. They noted that she was cooperative with the treatment of her leg pain. They did not notice anything abnormal about her emotional expression, and they noted that she made eye contact with them.
And doctor, what ED for the jury?
Emergency department.
And that was at Metro Hospital?
Yes.
All right. And that was on May 26th of 2024?
That's correct.
All right. So because she has this diagnosis, it follows her where she goes, correct?
That's correct.
And so back on May 26th of 2024, it appears that normal affect and good eye contact.
That's what's documented, yes.
All right. Now, there comes a point in time where she's at North Coast.
Yes.
And the doctor, based on his evaluation of her, wants to prescribe medications, right?
Yes.
And she refuses. I believe it's Dr. Baskin who is the prescriber of the medication.
Dr. Baskin was prescribing medication in the jail. Dr. Vanderkar was prescribing medication at North Coast.
Thank you.
Yes.
Let's go to your report, Defense Exhibit I, page 17.
17, yes.
Okay. And at that point, on June 6th, Dr. Baskin diagnosed her with schizoaffective disorder and prescribed Haldol.
That's correct. He wrote a prescription for it, yes.
All right. She, Miss Ellis, refused to take the medication.
Yes.
Okay. Is that a volitional act, refusing to take medication?
It's a choice, yes.
So it's a choice that someone makes. Now, during the time, Dr. Testa, that you met her the very first time,
Yes.
what was the setting?
North Coast Behavioral Health Care. I met her on the inpatient unit in a conference room.
And are there pleasantries that are exchanged? And do you tell her why you're there?
Always. I would always tell her why I'm there, what my purpose is, what I do and do not do, and that it's non-confidential.
And when you were doing that, what were your observations of Miss Ellis? Was she paying attention to you?
She was making eye contact at that time during the initial part of the interview.
Okay. So during the initial part, when you're kind of laying the ground rules, the foundation, you're going to be asking questions, fair? She's paying attention to you. She's making eye contact.
Yes.
Did you ask any questions during that particular period of time?
I asked her whether she understood what I had told her.
Okay. And did she understand?
Initially, her responses were bizarre. I was not satisfied that she understood. So I went back through the statements again to ensure that she was paying attention, and she indicated that she understood.
Okay. All right. So she had, I believe you told Mr. Mack, very unusual affect, yes. Affect.
Yes.
Okay.
All right, we'll hit a break, but first, Sonny Slaughter. The prosecution here, Sonny, using this witness to sort of set up where they're going, that a different person came in evaluated, couldn't determine because there's a concern that she was maybe acting or projecting intentionally, hey, I'm nuts, you better get me evaluated, and that is probably a theme for the state's rebuttal, which we expect later today. Would you agree?
I absolutely agree. I think it was really clear when she went to the doctors because she hurt herself in the bus accident and she had no problem there. That is because that was something that she wanted, something that she needed. When she doesn't get her way, when there's something that she is trying to trick, that's when she does this. It's over exaggerated, I think. I do believe she does have disease and mental health disease and diagnosis, but I also believe that in some instances she uses that as a way to control other people in the room and to control the situation, which is what I think she did in the murder.
Yeah, it does seem that that's a possibility, and that's what the state's going to grab onto. Because these juries, the jury at the end of the day, they're really tasked to make a difficult decision. You have to be an expert in, mental health as a juror at the end of this trial. And boy, this is one of those cases you wouldn't want to be on as a juror.
But Ted, we all have someone. We all know and have someone in our families that may not have the diagnosis, but they have the disease. They may have the disease and ignore the diagnosis. We all know someone who is struggling with their mental health, which is why I have told elected officials all the way to the Senate, I have spoken to them directly and said, stop using mental health as a caveat when it comes to violence because it becomes an excuse. We have got to understand that our words matter and that these actions, there are plenty of people that have mental health disease and diagnosis who have not committed heinous crimes, which is why we have to do better as a society and we have to do better as leaders, as commentators, and particularly as elected officials, that we do not overlook and forget about what we are seeing in crimes like this. This is heinous. Oh. And whether she had a disease or not, or diagnosis, she needs to never be around anyone else again, and particularly those who are vulnerable. She needs to be incarcerated.
Yeah, absolutely. Now you could argue maybe in a hospital setting or a prison, but you're right. This is someone who is very dangerous and committed the ultimate act. And to your point, we all have people in our lives that suffer from mental illness, and it's heartbreaking. And that's why when you do, I have experience with it as well, and specifically with schizophrenia. It's scary, and no matter who you are, if you're diagnosed with this, you are going to interact with law enforcement because there are events of seeing things that aren't there, et cetera, and it starts this downward spiral, and collectively we got to figure it out. Otherwise, the little boy is going to be dead like we saw in this case. So, Sonny, thank you. As always, enjoy your weekend. Appreciate your time on the program on this Friday as we look at the victims of this case. Before we go to break, more testimony when we return.
I'm Vinny Politan. Welcome to Closing Arguments.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
A wife accused of murdering her prominent attorney husband, and the defense involves blaming her own sons?
Victim to Verdict with Ted Rollins. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
head back to Ohio now for more of the cross-examination of the defense expert, Dr. Megan Testa.
So when she is giving you these unusual things or saying these unusual things, do you question her about those things and how they apply or don't apply?
If I will redirect. So if I'm asking her, where she was born, and she starts to talk about Jesus or the FBI, I will redirect. I will ask her again where she was born. Sometimes you can get an individual on track in conversation in that way. Sometimes, if the psychosis is heavy, they will continue to talk about those things. During the competency part, I will ask how that's related to the charges. Sometimes you can pull people back. Sometimes they will continue on the psychotic thought process.
But just because they pull back doesn't mean they don't understand the question you're asking.
That's fair. It could be that they don't understand and they don't want to answer, or it could be that they're unable to.
Unable to, or they choose not to.
It could be either or.
So a person can have psychosis. No one is disputing that someone has schizophrenia or schizoaffective disorder. But just because a person has those mental illnesses, that does not equate with not understanding or not appreciating something, correct?
That's correct. It's not a definite.
Now, when you made your diagnostic impressions back in September 3rd of 2024, you make some unspecified diagnoses, ma'am, correct?
That's correct.
All right. And so can you tell me those unspecified diagnoses that you make?
I made the psychiatric diagnoses of unspecified schizophrenia spectrum and other psychotic disorder. That diagnosis, it referred to her history of delusional and disorganized thinking, auditory hallucinations, and mood disturbances with insomnia, suicidal thoughts, acts of cutting, and I could not tell whether this was schizophrenia or schizoaffective disorder.
And ma'am, is it fair to say that that diagnosis is made based on corroborating evidence that you had evaluated? You had evaluated medical records, you had done your own interview. That was based on corroborating evidence.
That's correct.
And then your other unspecified diagnosis was?
Unspecified cannabis-related disorder.
All right, and how did you come to that conclusion?
That diagnosis was given because there was demonstrated a history of cannabis use in the medical records. It appeared to have been a potential clinical issue for her, but the details of it were not there. It wasn't enough detail in the records to say whether it fit into a cannabis use disorder diagnosis.
But again, based on all the documents you had reviewed, corroboration that would bring you or lead you to that potential diagnosis.
Correct. That was from the records.
And then back on September 3rd, your final was that she was incompetent but restorable.
Correct.
Okay. And so then we're going to move right along to the, I believe it's dated February 1st, which is Defense Exhibit H.
That's correct.
All right. So in Defense Exhibit H, you also provide the same information that you had initially relied upon. All those records, they're all the same. They don't change.
Exactly.
Right?
Yes, the historical information did not change.
And so then, but now it's a little bit different because she has been afforded medications.
Correct.
And now she's at a different level.
Correct.
Of understanding.
Yes.
And cooperating.
Correct. Correct.
Now, on page 4 of your report, I believe you had a conversation with Miss Ellis about her own psychiatric history at the very bottom.
Yes.
And what does she tell you during that interview?
She told me that she had been a client of Murtis Taylor, and she said that she was treated at the agency for schizoaffective disorder. She said that she described her illness as manifesting with illogical thinking and mood swings.
All right. And so did she know what Murtis Taylor was?
Yes.
And that she had attended Murtis Taylor?
Yes.
So she's able to tell you where she was seeking her medical care?
Yes.
Or psychiatric care, I should say, to be clear. So let's go on to page 5 here. I believe you and Mr. Mack talked about January of 2015 when she went to, I believe that one was, it's a little confusing here. It says January 2015 through October 2023. The reports.
All right, we're going to slip in a commercial break. We'll have more from Ohio, the cross-examination of the defense expert, next.
Good morning. This is Court TV Live. I'm Kelly Craft in today for Ted Rollins. We are in Ohio this morning for the Toddler Stabbed murder trial. Back in June of last year, Margot Wood and her 3-year-old son Julian had just checked out at a grocery store, and they were headed to their car when they were attacked and stabbed. Prosecutors say this all began when the defendant, Bionca Ellis, became agitated earlier that day after not being able to collect all of her belongings at a police station. She then proceeded to obtain a knife from a thrift store and made her way to the grocery store where the attack took place. The defense does not deny Ellis's actions, but says she has a history of schizophrenia and was off of her medication that day. Let's get you back into the courtroom now. We are getting you caught up on unaired testimony from yesterday, so let's pick it up right where we left off with the defense's first witness, a forensic psychiatrist who evaluated Ellis, now on cross-examination by the state.
I believe you and Mr. Mack talked about January of 2015 when she went to, I believe, that one was, it's a little confusing here. It says January 2015 through October 2023. The reports were summarized for you with regards to the emergency department at Lutheran and then Fairview Hospital. And then I would like to talk about in January of 2015, Ms. Ellis's case manager took her to the emergency department at Lutheran Hospital.
That's correct.
All right. So if we just go back to, well, I guess in January of 2015, why did her manager take her to the emergency department?
Her case manager took her to the emergency department because she had not slept for 5 days. She was hearing voices and she was seeing visions. So the case manager brought her in seeking help for her.
Okay. And what happened?
She sneaked out of the ED on that day. She did not end up being evaluated. She was able to elope from that emergency department.
Okay. And then in December of that year, Ms. Ellis went back to the Lutheran Emergency Department. Can you tell us about that?
Yes, she was there for treatment of a wound. There's no description of her mental health state at that day. They didn't discuss it.
Okay. On February 2016, did she again go to the Lutheran ED?
Yes.
And why did she go there?
She went there with the physical health complaints. She said she was feeling faint and dizzy. She was taking medications at that time. She was taking an antipsychotic medication, Seroquel, that was noted in the medical record. She was cooperative with care and had a workup for medical issues on that day. She was noted to have normal behavior and was able to be discharged from the emergency room.
Okay. And so, and we go through the whole history from 2015 to 2024.
Yes.
Right? And so you've got inpatient psychiatric treatment and outpatient psychiatric treatment. Is that fair?
That's correct.
All right. So not every time that she went to an emergency department was it for psychiatric issues.
That's correct.
Now, turning to page 7 of your report, ma'am.
Yes.
You review the records from the Cuyahoga County Jail, the medical treatment that she was receiving there.
Yes.
Paragraph number 4, her interactions with Dr. Baskin. And
Yeah.
what were his observations of her?
He described her as initially being limited in her willingness to engage with him. He said that she spoke to him in a curt manner. She conveyed annoyance with him. He described her as bizarre in many of her answers, disjointed, and paranoid. That was on June 6th, 2024. He diagnosed her with schizoaffective disorder. He prescribed Haldol and Cogentin, but she refused to take the medication. He then did a series of follow-up visits. He saw her on June 14th, July 5th, July 26th, and August 21st. He described her as standoffish, guarded, irritable, eccentric, and he continued those prescriptions, but she declined to take them.
And why didn't she take them?
He said that she didn't give a reason, but what his exact words were was, she declined to take them without discernible reasons, apart from believing she did not require them.
All right. So, Dr. Testa, you had all this corroborating evidence during the first interview of Miss Bionca Ellis, and then the second interview of Bionca Ellis, when you deemed her to be competent to stand trial.
That's correct.
All right. Now, Mr. Mack just touched upon it, but let's talk about it a little bit. Because, ma'am, you are a forensic scientist.
Yes.
Right?
Yes, ma'am.
Forensic psychiatrist, I'm sorry.
Yes, ma'am.
And being one, you also sometimes have the opportunity to evaluate folks for insanity.
That's correct.
And insanity is a legal definition. Would you agree with me?
That's correct, yes.
All right. And so, ma'am, you started talking with Mr. Mack with regards to what are the method and mode of providing a insanity evaluation? What kinds of things do you look at?
So what you would look at, what your role would be to provide an opinion about the person's mental state at the time of the offense. So a person would do an evaluation and a diagnostic evaluation, but their main focus would not be on the day you're seeing the person. Your main focus would be to review records. You would get a lot of records from police. You would get records from any outside sources. You would review witness reports describing the person's behavior on the day of the offense. And you would review all of that. You would also do a very detailed interview with the defendant themselves. You would ask them a lot of questions about the event. What happened? Why did you do what you did? Were you taking meds at the time? You would get a history of how the preceding days leading up to the crime went. You'd get that history in great detail, and you would learn all of that from the defendant themselves. And you would have to put all that information together and synthesize all that to form an opinion.
And ma'am, is it fair to say that self-reporting is not enough?
Self-reporting is not enough. You would get their self-report. You would need that self-report because only that person knows certain things. But you have to look at a lot of extraneous information as well, contemporaneous information. You would want to look at the witness reports and look at observations from others.
And doctor, when you're assessing, you consider the symptoms of the severe mental disease or defect, correct?
That's correct.
The knowledge of the wrongfulness of the offense?
That's correct.
And then there would be a causal link between the symptoms and any unimpaired knowledge of the wrongfulness of the act.
That's correct.
Or offense.
Yes.
And then the motive for the offense, would that be considered?
We do consider that because that tells us the why, and that tells us if it's related to their mental illness and if they know it's wrong. So that's a key to look at as well, whether it's rational or irrational.
So you'd look at the rational or irrational component.
That's correct, yes.
But you didn't do it in this case.
I did not do any of that.
No. We're just talking in generalities of what a forensic scientist does.
Correct.
All right? And so you can be psychotic, yet still know the wrongfulness of your actions.
Of course.
But you can also be psychotic and not know the wrongfulness of your actions.
Absolutely.
All right? Doctor, does mental illness equate with legal insanity?
Yeah, we could.
Let's go ahead and bring in our guest for this hour to discuss from Martinez, California, criminal defense attorney Alan Kagawa. Alan, nice to see you on this Friday. Alan, listening to this doctor on the stand, she is neutral, a neutral party in a way. She was appointed by the court to take a look at the defendant here and provide some information. What do you think of the cross-examination so far? Defense obviously has said they initially just said not guilty, then they eventually changed their strategy here and said not guilty by reason of insanity. What are you taking away from the cross by the prosecutor?
I'd say the cross by the prosecutor is, as of right now, I think things are leaning quite in favor of not guilty by reason of insanity. The cross-examination really covered, Ms. Ellis's history of schizophrenia, history of hallucinations, history of psychosis, and in particular, that last line of questioning, can someone be psychotic but still know, distinguish right from wrong? I believe that is rather a weak leg to stand on when ultimately trying to find that someone is guilty of this.
Yeah, we'll have to see what else they come up with. One thing that I'm kind of thinking about in this case when we take a look at it, the one surveillance part, the surveillance video, when she is hitting the knife against that concrete column to check, according to the prosecutor, the viability of that knife. From my perspective, it appears that maybe in that moment she is able to understand what she's doing. She wants to know if the knife is working enough to do something with it, and then drops the one that clearly isn't as strong as the other one. And I just wonder what the takeaway could be from that, how the prosecutor will argue that in her closing, because if I was prosecuting this case, I would take that particular incident and talk about it.
Absolutely. I think you touched upon one of the strongest arguments for the prosecution, which is, it seems like she's understanding things. She's not in full psychosis. She's aware of potentially, just how this knife is working. I'd say definitely that goes to potentially her understanding of, what she's up to. I'd say I know the defense is going to try to focus on, some other explanation, but I think that's definitely the strongest argument for the prosecution, or at least one of them.
Yeah, one of them, definitely Alan. All right, that sidebar that was going on in court, that's over. Let's get back in now for the redirect.
Doctor, psychosis, insanity, same thing?
I'm hesitant because it was objected to before. Go ahead with it. Psychosis is a medical term.
Thank you.
And insanity is a legally defined term.
Thank you. Okay. Do you recall that Ms. Faralia had you go to, I believe it was page 6 of Defendant's Exhibit I, your September 2024 report?
Yes.
There was some mention of the May 26th, 24th interaction with one of the doctors regarding normal eye contact. You recall that? Did you learn that 3 days later, May 29th of 24, that Ms. Ellis was jailed in the North Olmsted?
Yes.
Okay. And would it surprise you to know that a corrections officer identified her appearance and mental health status as, the question was, is the inmate's conduct, appearance, and mental health status normal? And the answer was no. Would that surprise you?
It doesn't surprise me.
Okay. Again, just make sure the jurors have it. Why is it such a high rate of non-compliance with medication for this population?
Individuals with schizophrenia often have what's called a lack of insight into their illness. So the symptoms that individuals feel and perceive feel very real. They often don't agree with their diagnosis, and so they will make a choice not to take medications because they don't believe they have the illness. So just like if you or I, if someone told me to take medications for diabetes and I did not have diabetes, I would decline that medication. Is it a voluntary decline? Of course, but if my mind's not in reality, I can voluntarily decline. It's really not a good choice. I wouldn't have had the capacity to truly consider that and make a good decision for myself.
Do you have any reason to believe that Ms. Ellis was not a mentally ill schizophrenic prior to June 3rd of 2024?
No, the records disprove that. She was ill for years before.
Okay. Is there any reason to believe that she was not ill during the month of June of 2024?
No, I would not believe that. She was not taking medications, and there would be no reason to believe that she was not ill.
Okay. Judge, may I take one moment, please?
Sure.
All right, well, that concludes that testimony from the doctor on the stand. And again, this took place yesterday. The court for today has already started back up. But due to that court order, we are unable to air today's testimony until the end of the day. So in the meantime, we are going to switch gears and head to Florida, where a woman is on trial for fatally shooting her boyfriend in the leg. Testimony in the toxic relationship murder trial is coming up next. Stay with us. You're watching Court TV.
My two best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dan Marcel ever walked on.
It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands. New episodes Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Turning now to Miami, Florida, where testimony is back underway this morning in the toxic relationship murder trial. 30-year-old Daisy Link is accused of fatally shooting her on and off again boyfriend, Pedro Jimenez. This was back in June of 2022. The couple shared 2 children together and, by all accounts, had an extremely toxic relationship. The defense says Jimenez was particularly out of control that day, forcing Link to shoot in self-defense. Before we get you back into that courtroom, here's Court TV affiliate WPLG with a closer look at this case against Daisy Link.
Daisy Link cringes at the sights and sounds from a sergeant's body-worn camera captured during the wee hours of June 25, 2022, when Homestead police responded to a call about a man bleeding out. The state says Link made that call herself moments after she fired the single shot that killed Pedro Jimenez, her on and off partner and father to 2 of her children.
In a fit of rage, she pulled out the gun, and the facts will show he had turned around and was running away in fear.
The state and defense both agree Link's relationship with Jimenez was tumultuous.
Arguments, anger, and even jealousy.
But the defense paints Jimenez as downright abusive. They say Link shot Jimenez during an argument in fear for her life.
The evidence will show this man was out of control. He was unhinged and he was dangerous. And she fired a shot to get him to go away.
A Homestead sergeant testified to Link's behavior at the scene, where she implied she didn't know what happened to the victim.
She was screaming. I believe at one point she stated she was asking him what happened.
Contrast that with what she's caught saying with the gun still in her hand.
A gun was located inside an areca palm.
Link made headlines for other reasons last year when she was impregnated by another inmate while behind bars. But jurors are not expected to hear those details during her murder trial.
Let's go into the courtroom now, right where the attorneys, they are arguing over the defendant's statement to police. This is outside the jury's presence. Let's go ahead and listen to that.
Did you and Ms. Link talk about the Miranda waiver?
What is it on?
Yeah, 4001.
Yes, she wants the whole thing in, including.
I went back and I looked over the Miranda waiver in the second one. While the police say something along the lines of, so you want to talk to us, we have to go over your rights again. They use the word again a couple times.
Which, sorry not to cut the court off, that's muted.
Well, I was going to say, that doesn't indicate that she has invoked her right to remain silent. Just because they're going over the Miranda rights a second time or again, is not a comment on her silence. So, yes, the state is going to mute that. I don't think they need to mute that because this doesn't indicate that. My concern is a comment on her silence. So,
Yeah, I would just ask they play it, but no commentary, no unsolicited comments from the witness like we had yesterday with that detective.
My point is, it's not necessary for us to talk about the first Miranda.
Yes.
Because the second Miranda doesn't indicate a comment on her silence or the invocation of any rights, number one. And number two, since it's in the benefit of Ms. Link to have this statement come in, I would think that we would want to streamline it.
Yes.
Do you understand what I'm saying? Yes. So if you, as you as a lawyer, believe strategy-wise, it's better for me to have the statement come in, it looks like it's coming in with certain protections. For example, the jury's not going to know that you were arrested. Does that make sense? Okay. Yes. So what would be the logic in bringing in the first statement where we would vote?
Because they spoke to me outside of the board either way. They were speaking to me the entire time, even though they weren't supposed to. They basically coerced me into signing that second sheet when they took me to the bathroom with an entirely different investigator from the DV department.
But at this stage, you're agreeing that what's in the full interview is better for you for this trial. So why can't we just move on and not from your point of view, understand that you're getting an overall benefit, even though there's parts of it that you don't agree with, the way that they got you to speak, for example.
I can understand that.
You also understand that there wasn't a motion to suppress bio. So the court didn't have the cops come in and prove to me that your post-mortem Miranda statement was a knowing voluntary waiver. We didn't have that argument. That's a constitutional motion that could have been filed, just like a standard ground, but that wasn't in front of the court either, right?
Right.
So that, to me, that's also like a strategic point of view, strategic move by the defense, right?
Yes.
Okay, so do you want to talk, so it sounds like you don't want to talk about the first Miranda waiver.
Yes.
Okay, because if you do, you're not going to have to have an in-depth conversation about what it means for this jury to understand that you invoked your rights, and essentially it's a comment on your silence, which has all sorts of huge constitutional ramifications that need to be weighed in this courtroom for appellate purposes. Does that make sense?
Yes.
So why don't you just talk to her real quick about us now going into the first Miranda?
Because I'm just going to step outside.
Yeah, I'll step outside too. Or you off the record, so you can take a little bit more privacy.
I'll step outside as well.
All right, we're going to take a quick break, but don't go anywhere. More of this case when we return. Back to court in just a minute, but first, here's a quick look at some of the other cases that we are tracking here at Court TV. In Ohio, the fate of Bionca Ellis will soon be in the hands of a jury. The defense is currently wrapping up the final witness. Now, due to a court order, we are unable to show you that testimony until court is done for the day, but we will take you there as soon as we are able to later on today. Also, we are in Wisconsin, where the state's case continues for a teen accused of killing a young woman who got caught in his gun's crossfire while taking out the garbage. We'll keep you updated on all of these trials throughout the day, but for now, let's head back to Florida. This is for the toxic relationship murder trial for Daisy Link. Let's go back in. We are still listening to some arguments outside the presence of the jury.
The state is concerned that there may be an inference that there's a competence on their silence.
Right, so I'm waiving that specific appellate issue, yes.
Ms. Link, do you understand?
Yes.
So even though Mr. Tomas believes legally he can waive this, it really is up to you to decide if you're going to allow the state to play the full second interview, the court we were talking about now, about police going over your rights again. So you understand that no one's going to tell the jury that you revoked the first time. No one's going to tell the jury that you invoked your right to remain silent. No one is going to comment on your silence. But you're essentially agreeing that that is not going to be an issue for appellate purposes. Do you understand? Yes. You've had enough time to speak to Mr. Tomas about that? Yes. Okay, do you need any more time to speak to him? No. Okay. Do you have any questions for me about what we just went over? No, Judge. All right. Okay, so I think you have a waiver.
Yeah, so I'll talk to Wit's support about that later this afternoon when we actually publish that video and having that portion. There's a few other issues that I think are imperative to address. First and foremost, I walked outside, I made eye contact with one of the jurors, I recognized her, I said hello, I didn't realize who it was until I said that, and then there were a handful of witnesses around where the jury is, they're right outside the courtroom. I asked them all to just move away, so that way there'd be no...
That's right, well I asked them virtually today.
Yeah, they're right there. I just want to make everybody aware of that. The second issue is I want to make sure that we are not proceeding forward on any kind of suppression issue, because Ms. Link specifically said earlier that she was coerced into waiving Miranda, so she's going to be...
My understanding based on my conversation with her is she understands that no motion to suppress.
Right. I just want to make sure that that is also on the record. And then the third thing...
That's right. Yes.
And then the third thing is, I spoke to Mr. Tomas about this. I spoke to Sergeant Cremencini on my way into the office this morning. What he informed me was basically this. The phone extraction that is currently in evidence is the entirety of the phone extraction. However, that was done sometime about 2022. Sergeant Cremencini, who was working with a team at the time, now has access to better technology. And very recently, within the last week or so, he decided to plug that phone in again and do the extraction again on his computer. Additional data was able to be read at that point in time. He called me this morning and informed me of that. I sent those text messages over to defense counsel this morning. The way he explained it to me was...
That's
no,
it sounds like we're going to have to have Richardson.
Right.
Before late turning over discovery.
Well, so yes and no, and I was going to suggest to the court that we do that, and that's why I'm kind of explaining it in the way I am. The way he explained it to me was this. Technology is ever changing. It's getting better, and as the technology gets better, the actual extraction itself is able to be read more fully by better technology. We now have better technology that is able to read that data and different data. The way he described it was basically like the DNA swab. DNA swabs get better over time. It's still the same blood, it's still the same DNA, however, you're able to read more. I sent over what he sent to me today to defense counsel, which is a handful of text messages.
Please have them work with the jury all the way on the side, please. Okay. One man will communicate with me. They're too close to us, please. Okay.
Those text messages are between Ms. Link and somebody by the name or saved in her phone as, I believe, Smoke. Those text messages include references to shooting people, shooting Smoke's girlfriend, etc. As I said, and as the court indicated about the Richardson, I was going to suggest we do one. I don't think it actually.
Why is smoke's text messaging relevant?
It's not. So that's what I was going to say. It's not a discovery violation because all that data still existed and was turned over. It's just a newer program that is able to read that data more. It's inadvertent because, again, we couldn't read it when this was actually turned over. It's prejudicial because it could affect Ms. Link's cross-examination or her testimony because she says in her statement, for example, that she didn't know anything about firearms, etc., but she's saying this to shoot other people. My remedy to it, I will not use it whatsoever, and it will be excluded entirely, and I'm going to direct Detective Cremencini to discuss on his direct examination the betterment of technology over time, and if he has done anything recently, specifically about the videos on Ms. Link's phone.
So it's only relevant, the betterment of technology is only relevant about the videos on the phone?
Correct.
Have those been played?
One of them.
All right, is there something else that's going to be played?
Yes.
And do you have access to that, Mr. Tomas? Do you know what it is?
I'm not sure if there's any new information that I didn't already have.
So there's a few of them. There's the defendant and there is the defendant and the victim exiting the vehicle together, which I'm going to talk to him about the actual timestamp on Ms. Link's phone on that, which is somewhere in 10:30 time.
10:31, that the day of the shooting?
The night before. So the shooting happens at like 3 a.m. They get outside of the vehicle at 10, which is corroborated by Ms. Link's own statement. There is a video that I plan on publishing later with the children also, them acting as a family, and then the actual shooting itself. I was planning on talking to him about the timestamps.
And these are all 1 or 2 days before the shooting?
This is the shooting, the night of the shooting. These have already been turned over, and what I'm going to ask Sergeant Cremencini is, were you able to verify the 2022 extraction to whatever you did recently? Are the videos changed in any way? And he will answer no. He will actually say exactly, I believe he said it was 861 videos that were on Ms. Link's phone are the exact same from a few weeks ago to the day that it was extracted. There's no change whatsoever when it comes to the videos.
So, I guess just so the sufficiency of the investigation, they explain it that, which is why the testimony will come about recency and extraction of videos on the phone, even though they've had it for 3 years.
So it sounds like, at least with the videos, I have all the videos already. The only difference is that they were able to get timestamps from within the data.
No, so if you look at my computer, I'll show you. So if you look at, I know the court can't see it, but just for the purposes of the record, if you look on the actual Cellbrite report, which is what is furnished to me, the shooting occurs and there's a timestamp of when it was created at 6/25/2022, and there is a 6-minute and 57-second video. Part of that was published yesterday. It's created at 3:06 a.m. When Ms. Link is seen, it's about 6 minutes into the video. I'm going to have Sergeant Cremencini say, okay, if this is started at 3:06, that means that this occurred around 3:11, 3:12. Then I'm going to show him the call log of the defendant with the 911, showing that 911 was called around 3:21 a.m. All of this has already been in defense counsel's possession. Nothing with regards to the video has changed whatsoever. The only difference is that the technology changed so that we could better read information, and these text messages that were now being able to be read were now furnished to defense counsel. I do not intend to use them whatsoever. I wanted to make sure that that was on the record, that I am giving the remedy of that exclusion of that evidence, regardless of
the few that you want to play, because you already said that.
All right, these arguments are taking place while the jury is not inside the courtroom. So let's go ahead and bring in criminal defense attorney Alan Kagawa just to kind of talk about what we've been listening to so far. We heard the defendant speak in one of the clips that we played. And she really is talking about here, when we heard her speak before, that she was forced into signing the statement that she gave to police. We heard the judge asking her a bunch of questions about that. What's your takeaway, Alan, from what we've been listening to?
What I think is quite interesting about that is, yeah, she says, I think I was coerced into doing this, but from what I was able to hear, it sounds like the defense actually wants some of the interview to actually come out. And it looks like the part that actually is coming out, potentially the defense is also in favor of as well. So I think this is going to be a very interesting piece of evidence because I think it'll go both towards the prosecution case and potentially to the defense.
Yeah, they're saying that we want that whole entire thing to be played because she's saying some is going to show coercion. We'll have to see exactly what takes place there, Alan. But, you know, this is just another interesting case that we have been watching here, saying in a part that she was saying that she didn't know what happened to him, and then it turns out maybe she does. So whatever's going to happen, we'll have to see. We're going to continue to follow this. We're going to take a break, Alan. When we come back, we're going to have more of this with a witness who is taking the stand, a crime scene tech.
I'm Vinny Politan. Welcome to Closing Arguments.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
A wife accused of murdering her prominent attorney husband, and the defense involves blaming her own sons?
Victim to verdict with Ted Rollins. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Back now to Miami, where a woman is on trial for the murder of her on-again, off-again partner. Daisy Link told police that she shot Pedro Jimenez in self-defense, claiming to have been the victim of years of domestic abuse. Now, prosecutors say that Link is lying and that she fired on Jimenez in a fit of rage while he was running away. Let's head into the courtroom now for the first witness of the day, a crime scene technician with the Miami-Dade Sheriff's Office.
Okay, Detective Zapata. So the suspect blood trail, after you reviewed the report, where did the suspect blood trail first start? The blood trail appeared to have first started in front of the residence. In front of the residence, there's another set of duplex. In front of that duplex and on a concrete walk path near a tree is where I first noticed the set of apparent blood. And I'm now publishing what's been admitted to evidence at Stage 18. Now, Detective, when you say the front of the house, so is this the house, the defendant victim's house? Yes. And when you say the front of the house, are you indicating somewhere in this area where this silver car is behind this tree? Yes. So based on your report, was there a blood trail, suspect blood trail, right in front of the doorsteps of the victim and defendant's house? No. Moment to confer, Judge. Sure. Detective Zapata, was mail also found in the car when it was impounded? I'm sorry, can you repeat the question? Was mail, a piece of mail, also found in the car when it was impounded? Yes, that's correct. If I were to show you that, would you recognize it? Yes. Judge, I now move into evidence based on stipulation by the parties what's been previously marked as States 1V.
State Exhibit 1V, marked for identification, now becomes State Exhibit 19.
Permission to publish, Judge? Now, Detective, is this the piece of mail you saw? Yes. Whose names are on the piece of mail? Permission to approach the witness, Judge? The names are Pedro Jimenez and Daisy Link. And what address is there? The address is not.
Any cross-examination for officers about that?
Yes, Your Honor, just a moment. Judge, before I start with her, by way of stipulation, I would ask that what's marked as Defense Exhibit A1 be admitted into evidence.
Defense Exhibit A1, marked for identification, now becomes Defense Exhibit A.
So, ma'am, we spoke yesterday. I'm going to show you this again. I'm showing you what is already in evidence as State's Exhibit 6. Now, this is the home in question, correct?
Yes.
And you are the person who drew this red line yesterday, is that correct?
I'm sorry, can you go back to the first question?
To the first question?
Yes. Your first statement about the residence?
The home where Daisy Link lived.
Yes.
Is this the home? Would it be easier?
Yes, sorry.
Yeah. 1 minute.
Yes.
This is Daisy Link's home, right? What I'm pointing to right here.
If I'm not mistaken, this is
Oh, this one. Okay. So I'm going to show this to you real quick. But you see the line that you are the person who drew this red line, correct?
Yes.
And you would agree that it's a little hard to see because it's red, but right here, you drew a line that came all the way here, right to this area, which is where the front door of the residence would be. Is that correct?
I'm sorry. Yes, here.
Yeah, and you can see a little line going here, right?
Yes, there's a line there.
Yes. And, okay, I think I should leave this as one. So as we spoke yesterday, just by way of reminder, there was you also drew a line over here, this area here, this area over here, but there was no blood in this specific area right here. Is that
Correct. That line was to show the alleyway.
Okay. The blood was on the other side, which is over here where all this is, right?
Yes, there was blood leading up to where the victim was found collapsed.
And as far as your investigation goes and what you were able to determine, the blood trail began in this area here, in this general area here where this line starts. Is that correct?
Further, I don't recall the direction, but further, because of the trees, you can't really see the concrete walk path, but it's more so towards the front where there's a tree. You can't really see it in the picture.
Getting close to the top of the hour, we want to say goodbye to Alan Kagawa for joining us today. Coming up, a double Ivy League medical examiner takes the stand to testify about autopsy photos. We'll be back.
you a chance to win a real Vegas vacation every day. Just download Quick Hit Slots for free and play to enter.
And welcome back to Court TV Live. Happy Friday. I'm Kelly Craft in for Ted Rollins today. And we are in Miami, Florida this afternoon for the toxic relationship murder trial. This is for Daisy Link, the 30-year-old who made headlines last year for becoming pregnant while in jail. She is charged with second-degree murder and the death of her on-again, off-again boyfriend. Prosecutors say Link shot Pedro Jimenez in the leg back in June of 2022. Took place in an alleyway outside the couple's home. The defense says that Link shot, though, in self-defense. Let's get you back to the courtroom now. The medical examiner has taken the stand.
Yes, Judge. Good morning. Can you please state your name for the record?
Good morning. I'm Dr. Benjamin Mathis.
Mr. Mathis, what do you do for a living?
I am the Chief Medical Examiner of the Miami-Dade County Medical Examiner Department.
And how long have you been the Chief Medical Examiner?
10 days. Last week they promoted me to Chief Medical Examiner. I've been Deputy Chief for the prior 3 years.
Congratulations.
Thank you.
So you mentioned you've been Deputy Chief for 13 years.
I've been at the Medical Examiner Department for 13 years. The last 3 were Deputy Chief.
And can you tell the jury a little bit about your education and training in forensic pathology?
Sure. I went to Brown University in Providence, Rhode Island for my undergraduate degree in Classics Latin. And then I stayed at Brown for medical school where I graduated with a Doctor of Medicine degree. Then I went to the University of Pennsylvania in Philadelphia for my residency in pathology, anatomic pathology, and clinical pathology. After completing the residency, I came to Miami for a fellowship to subspecialize in the subspecialty of forensic pathology.
And are you board certified in forensic pathology?
I am.
About how many autopsies, Dr. Mathis, have you performed over your career?
Around 2,000.
And have you previously come to court to testify as to the cause of death of an individual?
Yes.
About how many times have you done that?
Several dozen times. I usually come about 10 times a year. 10 times a year, times 12 years, 13 years I've been here.
And were you qualified as an expert on each of those occasions that you came to testify?
I have.
In what field were you qualified as an expert?
Forensic pathology.
Now, Dr. Mathis, can you tell the jury what exactly a medical examiner does?
Sure. A medical examiner is a forensic pathologist who works for the government generally. And we're charged with investigating deaths of individuals who died either under circumstances or because of who they are that the state has an interest in. So all non-natural deaths will go to a medical examiner, accidents, suicides, potential homicides, drug overdoses, inmates from the prison, those who die in police custody. And then when we investigate their deaths, we need to determine the cause of death, what caused them to die, and the manner of death, which is how we classify their death. We'll perform whatever investigations or studies we need to do, whether it's a record review looking at their medical records, to performing a full autopsy, performing special dissections, having special tests run, studies done, also that we can determine what the cause and manner of death is.
And were you working as a medical examiner for Miami-Dade County on June 25th, 2022?
I was.
Are you the original medical examiner who did the actual autopsy on the victim, Pedro Jimenez?
Yes.
So I want to talk about your involvement in this case, Dr. Mathis. When did you perform that autopsy?
June 26, 2022.
Where did you perform it?
At our office. It's Medical Examiner Department. It's right across the street from Ryder Trauma at Jackson Medical Center next to Miami-Dade College Health Campus.
And when the body arrived for autopsy, what was its general condition?
He was in a fresh state. He had soiling from blood staining on his legs.
And did you observe any signs of medical intervention, such as bandages, anything like that on the body?
Yes, he had a tourniquet on his right thigh.
Now, can you walk us through the steps you take when performing an autopsy, Dr. Mathis?
Sure. So first, we capture the height and weight We'll take a receiving photo of the individual. Then if it's a suspected homicide, we'll get pictures of the hands. Then we'll collect fingernail clippings as evidence. The body will then be washed. We'll take photographs, overall photographs of the individual, and then if there are any tattoos or injuries, we'll take photographs of those. Once the photographs have been taken, then the doctor will take any written notes about the external appearances of the body, of the tattoos, of the injuries, and then at that point, an internal examination, or what people colloquially call the autopsy, will begin to be performed.
So you mentioned a lot of steps there.
Yes.
So I want to break that down. Can you explain to the members of the jury what an external exam is?
Sure. So external exam sounds just like that. We're taking note of the external features of the body. First is the routine, their body size, their body habitus, their height, their weight, their eye color, their hair color. And then we will, after all the regular stuff has been documented, then we'll turn toward tattoos and scars. And then then we'll move into injuries. If there are any external evidence of injuries, then we'll document those down as well.
So you mentioned that you document tattoos. Did the victim in this case have a lot of tattoos?
He did.
And was one of those tattoos the name Daisy?
Yes.
Now, you also mentioned you start with external injuries, so I want to talk about those. What external injuries did you observe on the victim's body in this case?
Yes, so he had a through-and-through gunshot wound on his right thigh and a through-and-through gunshot wound on his left foot.
Now, Dr. Mathis, you mentioned a through-and-through gunshot wound through the right thigh and left foot.
Yes.
So I want to break that down. I want to start with the left foot. Your Honor, I now move into evidence what has been previously marked as states 1W by stipulation of the parties.
State Exhibit 1W, marked for identification, now becomes State Exhibit 20.
Now, Dr. Mathis, is this the victim's left foot?
It is.
Now, you mentioned that he had a through-and-through gunshot.
Yes. Can I come down? I don't have my glasses.
Can you show to the members of the jury where the entrance wound is on this foot?
It may be hard for you to see as well, but the entrance wound is on the bottom of the left heel.
And how do you know it's the entrance wound?
So, in general, entrance wounds are round. They can have a rim of abrasion. In this case, though, his skin is different than the rest of the skin on the body. Regular skin, a lot of it has hair. Foot skin, the plantar skin, the skin on the bottom of the foot, it's thicker, it's more elastic than the rest of the body. Anybody who's done a foot rub can attest to it or had to remove a splinter. So when a bullet goes through the skin of the sole of the foot, the plantar skin, the tissue is very elastic, so it will retract, allow the bullet to come in. So when you have an entrance wound on a bottom of the foot, you're going to see more of a slit-like appearance. In this case, you can even see a halo where the bullet tunneled in, but the skin retracts after it, and it's just the nature of the skin on the bottom of the foot.
And in this picture, where is the exit wound?
The exit wound is on the Achilles tendon region on the back of the heel.
How do you know that's the exit wound?
Exit wounds are irregular. Oftentimes you can take them and push them together, the edges together. You can see that this has that kind of split-like irregularity to it, and that the pieces fit together like a puzzle.
And now, Dr. Mathis, looking at the entrance and exit wound, can you determine the path the bullet took when it entered the foot?
Yeah, so since this is the entrance wound, that's where it's entered. This is what we call a perforating wound. So it's entering through the sole of the foot, the left heel, and it is going through the soft tissue and coming out the back of the heel region by the articular tendon region.
Now, Dr. Mathis, you also mentioned that the foot is flat and it has tougher skin, is that right?
The sole of the foot, yes.
Would a person wearing a shoe, would that move the path of the bullet when it enters the person's foot?
Move the path of the bullet. So sometimes when you're wearing clothing or shoes, it can change the appearance of the entrance wound. It can add irregularity to it. It can also help us to confirm what we're seeing. So if you're looking at this or you're less experienced and you don't have a lot of experience looking at plantar wounds on the bottom of the foot, you can look at the clothing and you can, or the shoe, and you can interpret the directionality from the shoe or the clothing itself.
And what is this photo here?
That's a close-up of the exit wound on the back of the heel on the Achilles tendon region.
I'm sorry, it's an Achilles?
Achilles tendon region, the back of the heel.
And how do we know that's the exit wound?
It has all the features of an exit wound. So you can see the skin kind of fits back together with a puzzle piece. When I push the edges together, it has an irregular linear, it's kind of linear, but it's irregular. That makes the features of an exit wound.
And what about this photo?
That is a close-up of the entrance wound on the bottom of the foot.
And how do we know that?
Because of the way it looks. So, like I said, normally an entrance wound is going to be round, but because of where the location is on the sole of the foot and the nature of the skin down there, entrance wounds on a plantar surface can look linear. The bullet just kind of separates the tissue, comes in, and the tissue collapses behind it.
Now I want to go back to, you mentioned shoes, and that can change the shape or irregularity of a wound. Was the victim in this case wearing shoes, do you know?
Yes.
Did you receive those shoes?
I did.
What kind of shoes were they?
They're like a boot, casual boot.
Judge, I now move into evidence what has been previously marked as states 1X. By stipulation of the parties, Judge.
State Exhibit 1X marked for identification now becomes State Exhibit 21.
Permission to publish, Judge?
Yes.
Dr. Mathis, are these the shoes that you received from the victim, that were recovered from the victim's body?
Yes.
And what are we looking at here with the white, where the white stick is pointing?
So there is a hole next to the white stick. This is the outer edge of the left heel region of the shoe. And then below it we have red discoloration, which looks like blood to me.
Before we head to break, we do have a quick programming note. A 3-year-old boy stabbed to death outside of a grocery store. His mother stabbed as she tried to save him. In a new episode of On the Record, Court TV's Cody Thomas takes you inside that courtroom, breaking down this heartbreaking trial of Bionca Ellis day by day. Watch On the Record, the toddler stabbing trial, now streaming at CourtTV.com under the Shows tab or on Court TV YouTube's page. We'll be right back with more after this quick break.
My 2 best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Bionca Ellis hates every piece of grass that Dan Marcel ever walked on.
It's something that'll haunt all of us forever. It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
to court in just a minute, but first, we do have an update out of Ohio where the fate of Bionca Ellis will soon be in the hands of a jury. Ellis is accused of fatally stabbing a 3-year-old boy and injuring his mother. This was during what is just an awful random attack, or at least what seems to be. This happened last year inside a grocery store parking lot. And right now, the jury is hearing from the defense's final witness, a forensic psychiatrist who testified earlier today that she believed Ellis did not know her actions were wrong at the time of the incident. Due to a court order, we are unable to air testimony until the day is over, but we'll get you into that courtroom as soon as we can and as soon as testimony ends there for the day. But for now, let's head back to Florida, where testimony is underway in this other trial we've been watching. It's called the Toxic Relationship Murder Trial. The defendant is Daisy Link. The 30-year-old is accused of fatally shooting her on-again, off-again boyfriend in the leg back in June of 2022. But the defense says Pedro Jimenez was unhinged and dangerous, and that Link had to shoot in self-defense. Let's get back into that courtroom. The medical examiner is testifying to some autopsy photos of the victim.
This is just a further out photograph, so you can see the entire shoe.
What's interesting about this picture, Dr. Mathis?
So this is the back of the shoe, and if you recall, the wound I kept referring to as on the Achilles tendon on the back of the foot, this correlates with it. This is where it came out from. So it came out of the skin, and then it came out of the shoe, creating this irregular defect here.
So that's where the exit wound came out of?
Yes.
And where was this, what part, was this the entrance or exit wound entry?
This is the entrance wound. You can see the fibers of the fabric or leather are pointing inward, and it's creating a defect. So that's consistent with the entrance wound from clothing.
Now, you also mentioned that in this case, the victim had a wound to the left foot and a wound to the right thigh.
That's correct.
I want to talk about the wound to the right thigh. Judge, I now move into evidence what has been previously marked as 1Y by stipulation of the parties.
Today, Exhibit 1Y, marked for identification, now becomes today Exhibit 22, Judge.
Now, Dr. Mathis, is this the wound on the right thigh?
Yes. So what you're looking at here is a victim lying on his belly on our autopsy table. So you're looking at the back of his lower extremities, the back of his leg. His buttock would be here, right above where the picture cuts off.
And is the wound to the right thigh, did it have both an entrance and exit wound?
It has both an entrance and an exit.
And this wound is the entrance?
Is the entrance.
How do we know that for the right thigh?
Because of the way it looks. Sorry. Because of the way it looks. We interpret gunshot wounds, entrance, exit, based on their morphology, the way they look. And this one, you can even see from this view, at a closer up, but you can see from this view, it's nice, and it has around this punched out appearance to it.
Now, what are we looking at now?
Now, this you're looking, he's lying on his back now. And up here above, that would be the groin region above, and you're looking at from the top of the thighs down. And within the tattoo, there is a gunshot wound there.
Is this a better view of the front of the victim's thigh?
Yes.
And what exit wound is that?
That is the exit wound. That's on the front of the thigh, and that's the exit wound. Same thing, different orientation.
What about this picture?
So now we're back on the back of the thigh. This is an entrance wound. You can see it has a punched out appearance. You can see the yellow in the middle, that's the fat, the soft tissue underneath the skin. So that's missing, that's the gunshot wound. You can see it's got this oval, it can be round, it can be oval, it can be elliptical depending on the angle that they go in, around the wound. And then that there is what we call abrasion, some scraping of the tissue around the edges of the wound. These are all features of an entrance wound.
Now, Dr. Mathis, for his right thigh, were you able to determine the path the bullet was taking?
Yes, so this is the entrance wound, and it's on the back of the thigh, so it's going from back to front.
Is the way that the bullet entered through the back of his right thigh consistent with the victim facing his back to the person who shot him?
The back of the victim needs to be facing the barrel of the gun.
So yes.
Yes.
Would it be consistent if you were facing the person who shot him?
No, because the barrel of the gun has to be pointing toward the back of the thigh.
Now, Judge, I now move to evidence what has been previously marked as Stage 1Z by stipulation of the parties.
Stay Exhibit 1Z, marked for identification, now becomes Stay Exhibit 23, Judge.
Judge, permission to publish?
Yes.
Now, Dr. Mathis, what are we looking at here?
We're looking at the student's line flat on his back on the autopsy table, and I took plastic probes and ran them through, placed them through the pathways of the two gunshot wounds.
So this is the wound to the foot.
Correct. And that one kind of makes more sense when you saw the shoe and how it looked on him. Harder to appreciate when adjusting the hole, but with the probe, it makes it easier to visualize.
Now, Dr. Mathis, I want to take everything together, what you said. We spoke about the left foot, the path of the bullet. We spoke about the right thigh and the path of that. Judge, I now move into evidence what has been previously marked as 1K by stipulation of the parties.
Stay Exhibit 1K, marked for identification, now becomes Stay Exhibit 24, Judge.
Judge, permission for the witness and myself to stand over here? Now, Dr. Mathis, can you explain to the jury what this diagram is indicating?
Sure, so this diagram here in the middle is the notes I take during the autopsy. We call it a body diagram sheet, and that's where I'm marking down his hair color, our tattoos, and then I noted where the wounds were, what their size is.
And how did the bullet first enter the body?
How did the bullet first enter the body? So he has an entrance wound on the left foot. That's coming out the back of the left heel region, and he has an entrance wound on the right thigh in the back. That's coming out the front of the right thigh.
How is it?
Let's go ahead and bring in our guest for this hour to discuss. Joining us now from Denver, Colorado, criminal defense attorney Eric Faddis. Eric, great to see you. I've seen you all over the place talking about the Charlie Kirk situation, Sean Diddy Combs. So thank you for making some time to talk with us today as we watch this case and listening to the medical examiner on the stand. All right, well, that doesn't look so great for defense counsel here, because the prosecutor has the medical examiner on the stand talking about the path of the bullets. So, Eric, what would you do as defense counsel here on cross-examination with the medical examiner?
Well, as defense, their defense is self-defense here, right? So they've got to establish that there was a reasonable fear of imminent bodily harm that the defendant had, and that's why she discharged the firearm. One point I would highlight is that, hey, this was one shot. It is not 5 shots. It's not 6 shots. It was one single shot. And even if the alleged victim did have his back to the defendant, a person could easily turn around, especially if things were getting heated, especially if things were escalated, especially if threats were made. And so there still is fodder for cross-examination, although that is a problematic fact for the defense.
Yeah, absolutely. Eric, what did you think? We had some arguments earlier outside the presence of the jury, and the defendant wanted, the statement kind of talking about saying it was forced. When she went and she talked with the police, there was coercion and force. What do you do with that when you're a defense counsel and your client is telling you, yeah, I said things, but they forced me to say that?
What you want to try to do on the defense side is show possibly the coercive nature of this interrogation and how it can influence a person's responses. If a person feels compelled, feels like that they couldn't make the choices that they wanted to make for themselves, and instead that the police were really driving the ship and sort of forcing her to do things, that can have an influence on what those responses are and the weight of those responses. A person could get nervous, they could misstate something, they could in the moment try to fabricate something, and while that's also problematic, it's not the same as someone being guilty of murder.
Yeah, good point, Eric. Okay, we're going to squeeze in a quick break, but don't go anywhere. We're coming right back with more of this case that we have been watching out of Florida. Back now to Miami, where Daisy Link is on trial for the killing of her on-again, off-again partner, Pedro Jimenez. Link is charged with second-degree murder after Jimenez was fatally shot back in 2022. Both sides agree that their relationship was toxic. Since then, the defendant got pregnant while in jail by another inmate, but the jury is not going to be hearing, or not expected to hear, anything about that, at least during this trial. So let's head back into the courtroom now. We are listening to some testimony. This is from the chief medical examiner. His name is Dr. Benjamin Mathis.
How is it possible that the way the bullet entered, how is it possible with that angle? How would the victim have had to have been standing for the bullet to enter the way it did?
From the bottom of the foot?
Yes.
So that's bottom of the foot. So to get an entrance from the bottom of the foot, the gun has to be under the foot. So if the foot is on the ground, they'd have to be, I guess, on the upper floor and coming through the ceiling, or the foot has to be in the air in order for it to get go in. So since that scenario doesn't really make sense, the left foot needs to be up in the air in order for it to be facing the barrel of the gun.
Could that be consistent with if the victim was going to try to run, that his foot was up? Would that be consistent?
Yes.
Now, once the bullet enters the left foot and exit, where does it go?
So then it comes out the back of the left foot.
And then where does it go?
Then it's going to continue in the same trajectory along a straight line until it hits something else.
And then can you just...
Or just drops to the ground.
And then for the thigh, can you talk about how when it left the foot and it enters the thigh, how that's possible?
So, yes. So the same bullet could cause both wounds. It can go from the outer edge of the left foot, the left heel, to the back of the left heel region. And then the foot's up in the air, it can go into the back of the right thigh and out the front. So it goes through the foot and then through the back of the thigh and out the front.
And you're indicating that the record reflects that the witness had his left foot up and his front was facing the judge.
Right, so your right leg has to be forward, your left foot is up, and you could create that pathway.
And your back has to be facing the person who's shooting.
Yes, the back of the foot, yes, because that's where it has to come inside.
Now, Dr. Mathis, looking at the wound tracks, is it possible that a single projectile did this?
Yes, in the way that I just described.
And okay, we're good with this. Now, I want to talk about the internal examination. Did you perform an internal examination?
I did.
Okay. And what internal damage did you observe as a result of the gunshot wounds?
So inside the body, his organs, those were all good. I had to do a special dissection on his right thigh to document the injuries going on within the soft tissue. And he had a lot of blood and bleeding in the muscles of his right thigh in the region of that gunshot wound. And he had holes in his femoral artery and femoral vein.
You mentioned he had holes in his femoral artery and vein. Did the bullet strike or sever those major arteries?
Yes, the bullet struck those arteries.
And now, Dr. Mathis, based on your expertise and experience, would an injury to the femoral artery, such as a gunshot wound, cause rapid or severe blood loss to someone? It will cause severe blood loss. The blood comes from the heart, is pumping. The femoral artery comes off after the aorta branches into the iliacs. The femoral artery is one of the branches that comes off the iliac artery, and it supplies blood flow to the rest of the leg. So it's a very important blood vessel, and it will bleed, and you will lose a lot of blood from it. And are you able to estimate about how quickly a person can lose consciousness or die from such bleeding?
So when we're talking about a femoral artery, it will take longer than, say, if you have a hole in your aorta or a hole in your lung or a hole in your heart. It's a bit downstream, so it can take several minutes. And then there are things that can mitigate it. If you're applying pressure, or if for some reason the muscle tissue is compressed around the wound, anything that's going to apply pressure to that area can slow down the bleeding.
Now, you also mentioned that several things can mitigate that. Let's say, Dr. Mathis, that there was no mitigation. There was no covering or trying to prevent the blood loss. If pressure is not being applied correctly, how fast would the victim take to die from this type of wound?
It can still take several minutes.
And is, based on your knowledge, was that consistent with what happened to the victim in this case?
I don't think there was a long survivability period, but I wasn't aware of that at the time of the autopsy. For us, it didn't matter, but it will take. It's not going to be that you're shot and you suddenly collapse. There is a time period where it will take for the blood to come out of the body, reduce the blood volume, so that the heart no longer has enough blood to pump up to the brain to give it the oxygen it needs.
And how is it that the blood is going to come out the body? Is it going to come out rapidly? Is it going to splatter a lot?
Yes, so you have both an arterial bleed and a venous bleed. So the vein is returning blood from the bottom of the foot. That's a low pressure system. It will ooze, or it'll accumulate in the muscular tissue. The artery, on the other hand, each time the heart pumps, blood is going to be spurting out of that artery. If that artery has a clear path out the hole, the exit hole, then you will get blood coming out of that hole, and that's where you see, like in the movies, the arterial spread. If there's not a clear pathway from the hole in the artery because it's blocked by muscle or tissue, then it'll continue to spurt, but it'll come out. It may not come out as a spurt out of the hole. When it leaks, it may accumulate in the tissues and then dribble out.
Now, I want to talk about toxicology. Was a toxicology test performed on the victim?
Yes.
And what were the results of that test, Dr. Mathis?
I'm just referencing the toxicology report. So in him was detected ethanol, which is beverage alcohol like you'd find in vodka or tequila. He had cocaine. He had metabolites of cocaine, the breakdown products. And he had THC, which is the active ingredient in marijuana.
And how much cocaine was detected in his blood?
He had, according to the report, 0.274 milligrams per liter.
Would you say that's a lot of cocaine, Dr. Mathis, a little bit of cocaine?
It's a healthy amount of cocaine.
And now, based on your experience, Dr. Mathis, what is it that cocaine does to the body or blood?
So cocaine is a stimulant. So it causes your heart to increase. It will increase your blood pressure. It narrows the blood vessels. That's how it increases the blood pressure. And like I said, it makes your heart race. It keeps you. It's an upper.
Based on your exam, Dr. Mathis, did the cocaine contribute to the victim's death?
No.
Why do you say that?
Because he's got a gunshot wound that went through his femoral artery and he's bleeding out, dying from hemorrhagic shock.
Did any of the substances that he had in his blood system contribute to his death?
No.
So I want to talk about the cause and manner of death. Based on your examination, were you able to determine the cause of death?
Yes.
What was it?
That was the gunshot wound of the right thigh.
So how long would it have been, Dr. Mathis, based on your training and experience, it would take someone to bleed out or die from that injury?
Like you said, it can take several minutes.
Were you able to determine the manner of death?
Yes.
What was the manner of death?
Homicide.
Moment to confer, Judge.
All right, learning more about what the victim here had in his system with the medical examiner on the stand. Let's squeeze in a quick break. We're coming right back.
I'm Vinny Politan. Welcome to Closing Arguments.
What's happening here?
It's unreal. Let me show you exactly what happened.
Closing arguments with Vinnie Politan tonight at 8/7 Central, only on Court TV.
A wife accused of murdering her prominent attorney husband, and the defense involves blaming her own sons?
Victim to verdict with Ted Rollins. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Back now to Miami for more testimony in the murder trial for defendant Daisy Link. Prosecutors say that she murdered her on and off again partner, Pedro Jimenez, and father of 2 of her children back in June of 2022. But her defense is saying the victim was, quote, unhinged and out of control, and she had to shoot him to get away from him. Let's go back into the courtroom now. We are listening to the medical examiner.
the external injuries you observed.
Yes.
If the victim was running away, I'm doing this.
Yes.
He's running with his left foot up. If he's doing this, is that consistent with what the shot that you observed, the wounds you observed on his body?
If he's in a running position, yes. The left foot has to be in the air and the right foot has to be forward.
So if he's running away, that's consistent?
Yes.
Okay. Now, I want to talk about ricocheting. Is it possible that the person who shot the victim shot into the ground and that it went through his left foot and out through his left thigh? Is that possible what you saw here?
I find that extremely unlikely. So when you have a ricochet, when you first fire the weapon, it has all the energy in it. That's why it can make characteristic appearances of gunshot wounds. In this case, the bullet not only went through the shoe, the boot, twice, went in and went out, went through the foot, went through the thigh, in, and came out. That takes a lot of energy. So ricochet is, one, not going to be able to do that, and two, the wound on the back of the thigh would have had to have, if it managed to even get out of the left shoe, which I find very unlikely, that you would have a ricochet that actually can go through the shoe, go through the foot, come out the shoe. When it hits that right thigh, it's not going to have that nice oval wound that you saw. So I can't see this being a ricochet, no.
Now I want to talk about, again, the arteries that were damaged. Is a time delay in the time from the time that the victim was shot, if there was a time delay in calling 911 or having assistance, would that also likely contribute to his death?
So when you have a wound like that, those are devastating injuries that require immediate medical attention. The wound needs to the blood flow needs to be stopped. Basically, you need to put a tourniquet tight around the wound to stop the blood flow into the leg. And then, of course, you're on a clock because the leg's not getting the nutrients it needs, and you would have to amputate. But a femoral artery wound is a devastating injury. So yes, if you don't receive medical attention, you will die quicker.
So if there was a delay in calling 911 or getting assistance or putting a tourniquet on the victim, that's going to speed up the time he dies?
Yes.
Now I want to talk about the drugs in his system.
Yes.
I know you mentioned earlier that those didn't contribute to his death.
Correct.
Would you say, doctor, based on your training and experience, that the drugs slowed down the amount of time it took him to die?
So there are some people who would say, okay, cocaine is a stimulant. So a lot of times when people get shot, they get an adrenaline rush. They may not even feel that they were shot till they look down and they see that they are bleeding. That adrenaline rush, adrenaline is also a stimulant, also causes the heart to beat faster and the blood vessels to constrict, which will increase your pressure. So cocaine as a stimulant could, in fact, actually help the situation because it's causing the blood vessels to be more constricted than they ordinarily would be, which is going to increase his blood pressure, which could theoretically increase his survivability period. But you still have a big hole in your femoral artery, so.
Thank you. Want me to confer, Judge? Yes. No further questions, Judge.
Insufficient cross-examination.
Morning, doctor.
Good morning.
Not to state the obvious, but just to be absolutely clear, we've got 2 entrance wounds and 2 exit wounds on this gentleman.
Correct.
But this is all from one bullet, one shot, correct?
It's consistent with that. So if the circumstances indicate that there's one bullet, one firing, this is the most reasonable way it happened.
There's nothing that you're aware of that would suggest to you or indicate to you that there was more than one shot in this particular instance, correct?
Right. Look, I have 2 through-and-through wounds. So could they have occurred through 2 separate shots? If that's what the scene and the circumstances supported, I'm not going to be able to refute you on that. But my understanding is if there's one shot, one bullet fired, this is how it would occur.
So what we're talking about here.
Okay, let's go ahead and bring in our guest, criminal defense attorney Eric Faddis. All right, Eric, cross-examination getting started right away. He's saying, I'm not going to state the obvious here, but starts questioning him about that. You think that was a good strategy, good question by defense counsel there?
Well, I think it was necessary for defense to establish, hey, this was one shot. Like I said, the defendant didn't unload the whole clip into the guy. It was one single shot. Where he should go next is that it was a shot to the foot. It wasn't a shot to the head. It wasn't a shot to the chest. And that goes to her state of mind, what she was trying to do. On top of that, he needs to also touch on the substances in the alleged victim's body and how that could cause a person to become angry, belligerent, and a threat.
Yeah, absolutely. Okay, so let's talk about that. Heard about the cocaine in his system, but then he was asked, well, was the cocaine his cause of death? No, he went on to say because he had gunshot wound. How did jurors view that? So you have a victim here, and he had cocaine in his system. He had alcohol in his system. How do you view that?
You know, it's tough because ideally you want, as a prosecutor, an alleged victim who is a saint, who is not engaging in any sort of underhanded or unsavory type conduct. But here, the jury might look at that and say, gosh, you know, is a guy has this cocktail of drugs in him, is that consistent with someone who could pose a threat in a domestic violence scenario? And it is. And so I think that is a critical piece of evidence, and I'll be interested to see ultimately how the jury views it.
Yeah, good point. Eric, thank you so much. Coming up, more testimony in the toxic relationship murder trial for the defendant in this case. You're taking a look at her right there. Her name is Daisy Link. We're coming right back. And welcome back to Court TV Live. I'm Kelly Craft. Happy Friday to all of you. We are going to be continuing to cover this case we have been watching out of Miami, Florida. Testimony is underway this afternoon in the toxic relationship murder trial. 30-year-old Daisy Link is accused of fatally shooting her on and off again boyfriend, Pedro Jimenez. This was back in June of 2022. Now, the couple share 2 children together, and by all accounts, they had an extremely toxic relationship. Now, defense says that Jimenez was particularly out of control that day, forcing Link to shoot in self-defense. Let's go into the courtroom now. The medical examiner is testifying.
So what we're talking about here is a bullet that went in through this man's heel, came out of another part of his foot, and then went into his leg and came out of another part of his leg. Is that correct?
Yes, the right thigh and then out the front of the right thigh.
How many autopsies have you done?
Probably is 2,000.
As best you can recollect, have you ever observed or do you have any knowledge of a single gunshot wound taking that particular trajectory?
I've had single gunshot wounds go through both legs. I've had them go through the arm and the chest, through a foot and then the leg, a foot and then the opposite thigh. One does not come to mind.
You would agree that this is a highly unusual trajectory for one bullet, correct?
I wouldn't say unusual. It makes sense. Yeah, I wouldn't say it's unusual. I would say it's not a pathway we encounter every day.
Now, when someone has an injury like this man had and aid is being rendered, am I correct that one of the first things you want to do is put a tourniquet on the person's leg?
Yes, you want to mitigate the blood loss. So that's going to be pressure, tourniquet, stops the blood flow from stop the blood flow above the level of the injury.
And that was done in this case, correct? That was administered?
He came in with a tourniquet on, so at some point one was placed on him.
Now, the amount of cocaine that this man had in his system, you testified earlier that it's not part of the cause of death, correct?
That's correct.
However, that amount, it is a potentially lethal amount, is it not?
Any amount of cocaine is technically potentially lethal.
But this amount, this isn't just any amount. This is
a goodly amount, yes.
Okay.
A goodly amount. It's not just a small amount. It's consistent with recreational use. It's not like somebody you see like a body packer or anything like that. But it's not just, sometimes we'll see people, regular cocaine users, and they're probably coming down and they have just a tiny little bit of cocaine coming along for the ride. He's using, yes.
So this is, we're in Miami. There's cocaine in Miami. But this is not just, like you said, not a little bit. This is a rather significant amount of cocaine that this man took, right?
This is recreational use of cocaine. It's not, like I said, it's not the little bit we see with somebody that's coming down. They're in the active phase of using.
Now, am I correct that that when somebody's using cocaine and they use other substances, particularly alcohol, that increases the toxicity of cocaine, correct?
It can, yes.
Okay. That combination, cocaine and alcohol, it produces a metabolite called cocaethylene, correct?
That's correct.
And in your autopsy, you tested for cocaethylene, correct?
Yes.
And he had 0.150 milligrams per liter of cocaethylene in his blood, correct?
Yes.
And when looking at the alcohol, he had 0.108 blood alcohol level. Is that correct?
Yes, 0.108 in the ocular fluid, 0.107 in the blood.
Right. So if he had been operating a motor vehicle, he would have been driving under the influence.
Correct.
Because the legal limit in this state is 0.08. Correct?
That's correct.
All right. So he had this very high amount of cocaine in his blood, along with this amount of alcohol in his blood, which would have been enough to trigger a DUI had he been driving.
Objection, evidence calls for legal conclusion. Overruled.
Yes.
And he also smoked some weed too, correct?
At some point, he used marijuana. I cannot tell you how he used it, and I cannot tell you when.
Now, doctor, you were asked about whether or not some of these substances delay or could affect how long it takes somebody to bleed out. Can you explain that a little bit more, please?
Yes. So just as I explained before, cocaine is a stimulant, and it, just like the adrenaline rush that will occur when somebody gets an injury, it will increase the blood. It will increase your blood pressure through constricting your arteries, and it will cause your heart to beat faster.
Now, when someone's shot, do you expect them to necessarily start bleeding out right away, or does it take a few moments before blood starts coming out of somebody's body? I mean, usually.
Oh, when they're shot, they'll start bleeding right away. You may not see it on the outside of the body, but trust me, they're bleeding somewhere. So they get shot in the chest. They are bleeding into whatever space is around them. So in the chest, you have a lot of space for the lungs to expand. They're going to bleed into the chest wall. You get shot in the leg, you're going to be bleeding into the muscles, the soft tissues there. Only when the body is in a position where the hole that leads to the outside is lined up with where the blood is will it come out. So oftentimes we'll get to a scene of murder. They've got a bunch of holes in their chest. There's not really that much blood out. When we start to move the body and we've tipped it, then blood will start coming out of the holes.
So it might take a little bit of time before you start seeing blood dripping and landing on the floor from somebody who's been shot.
Correct. It just depends how the hole lines up with where the blood is accumulating.
So if somebody's walking or running or in any type of movement, they get shot, but they're moving, you might not start to see a blood trail until they've taken a few steps, correct?
Correct.
Now, so you were asked about whether certain things are consistent with your findings. I want to give you a scenario, and you can tell me if it's consistent with what you found here. Okay?
Yep.
Right. So let's assume that we have somebody who is very high on cocaine and alcohol and THC. And that person is running around stalking somebody outside their home. Okay?
Yes.
That person is told to leave. They don't leave. At some point, there's a confrontation, and the person is asked again to leave. The person screams and says, "I want to die, I'm ready to die." And then they run towards a house with the intention of breaking into that house, which they have no right to be in. And a person fires a shot in that person's general direction for the sole purpose of getting that person to leave, which they have thus far refused to leave. Are you with me so far?
Yes.
Objection, invading the province of the jury.
He hasn't finished asking his questions. Let me hear the rest of the question.
Fires a gunshot for the purpose of getting that person to leave, which that person has refused to leave up until that point. Once that gunshot is fired, that person starts to leave. You would not expect that person to immediately bleed onto the ground and show where that person was standing at the time he was shot. Is that correct?
He could be bleeding at that time. or he could start to bleed later. I can't tell you one way or the other.
So if blood droplets are found, say, 15 steps away from a front door, give or take, 15 steps away from that front door, would that or could that be consistent with somebody running away from that front door after being shot?
So you have the front there shot. Are you telling me where the person was shot, or?
So the person's running towards the front door with the intent of breaking into this house, which they...
Objection, legal conclusion. Evading the province of the jury.
Overruled. If you can answer the hypothetical, you'll do so. If you can't, you can't.
Correct.
Go ahead and enter the end.
The person was told, leave. I don't want you here. You're not welcome here. Get out.
Okay.
I'm not getting out. You're going to have to kill me. Runs towards the door. Shot is fired for the purpose of getting that person to leave. Shot hits.
Let's go ahead and bring in our guest for this hour to discuss. Joining us now from Santa Fe, New Mexico, criminal defense attorney John Day. John, thank you for being with us. Happy Friday to you. Okay, John, how do you think this cross-examination is going? Defense counsel is really trying to get the medical examiner to talk about he had cocaine in his system, he had alcohol in his system, he was, acting erratic. What's your takeaway? How is the cross going?
Well, thanks for having me. I think the cross, the defense lawyer is doing what he has to do. I kind of like this witness, this medical examiner. He seems pretty unflappable, but what the defense attorney has to do is try to plant in at least 1, 2, 3 jurors' minds the idea that that this was backing up the self-defense claim, backing up the idea that there was no other choice, that this woman felt so cornered and so threatened that this was a reasonable response, even if in hindsight it doesn't look reasonable. So, the medical examiner, these guys, they testify so often, they're so good on the stand usually, and it's hard to get them to look like they don't know what they're talking about, they're not aware of this stuff. They're really good at this, and I like this guy in particular because he comes across as very approachable. I think jurors are going to relate to him. He's a scientist, but he doesn't talk like a scientist. And of course, all these jurors have seen all the CSI shows on TV, and they know that the scientific evidence is coming in. They're interested in it. This is not like a high school science class where they're bored, they're rolling their eyes. This is stuff that's relatable to them, especially in the context of what they've been hearing in this trial. So I think the defense lawyer is doing what he has to do. Whether it's going to get anything across to the jury remains to be seen.
And John, what about the fact that defense counsel was asking there and basically indicating, this isn't a shot, he didn't say these words, but basically was suggesting this wasn't a shot to the head, this wasn't a shot to the chest, talking about the path of the bullet here. And again, trying to go along with his theory that she did this in self-defense.
Yeah, it's significant. I mean, they want the jurors to think if this was some type of non-self-defense situation, why isn't there a shot to the mass of the chest or to the head or something else? I mean, it's consistent with their theory of self-defense in that the placement of the shot is so random, and it gives you the sense, at least they're going to argue in closing, that she was acting out of fear, she was acting out of feeling like she was going to get hurt, that she had some reason to respond the way she did, and it was reasonable. So, yeah, I mean, that goes to the point that it was self-defense. This was not a shot to the chest, shot to the stomach, shot to the head. This was something, in their view, that's consistent with her being really terrified and really scared.
Yeah, good point, John. Okay, more cross-examination is going to continue after a short break. We'll be back.
Tonight on Closing Arguments, the biggest moments from today's testimony in the Toddler Stabbed murder trial. We dive deeper as this case nears its dramatic finish.
Closing Arguments, tonight at 8/7 Central, only on Court TV. Next week.
We're digging deeper into the biggest cases across the country. Join us for all the latest developments with what's trending in true crime.
Opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
Back to court in Miami in just a moment. But first, here's a quick look at some of the other cases that we are tracking here at Court TV. In Ohio, the fate of Bionca Ellis will soon be in the hands of a jury. The defense is currently wrapping up the final witness. Due to a court order, we are unable to show you that testimony until court is done for the day. But we will take you there as soon as we are able to later on today. We are also in Wisconsin, where the state's case continues for a teen accused of killing a young woman who got caught in his gun's crossfire while taking out the garbage. And we are standing by in Florida, where later this hour, a judge will decide whether or not to uphold the jury's recommendation to sentence Jose Soto Escalera to death for the murders of his mistress and their unborn child. We will keep you updated on all these trials throughout the day here on Court TV, but for now, let's head back to Miami. This is the toxic relationship murder trial for Daisy Link. Right now, the jury is hearing from the medical examiner. Let's go back in.
This man is whacked out of his mind on cocaine, alcohol, marijuana. He's been asked to leave. He refuses to leave. He's in a heightened state, very aggressive. Screams, I'm ready to die. I want to die. It's not leaving. It's not welcome in the house. Doesn't have permission to be in the house. Has no license or has no authority, no right to be in that house. He's going to that house, running towards that door. Shots fired for the purpose of getting him to leave, which he has already refused multiple times to do so. Shot goes into his body. Once that happens, he's not going to the house anymore. He's running away. He takes about 15 steps running away from the house, give or take 15 steps before blood starts to drip out and hit the ground. Is that consistent with what you've seen here, with the wounds in this case? Could that have happened?
So you're asking could he have been shot while still inside the house before leaving?
Didn't get inside the house. Okay. He was running towards the front door, is shot, and now the shot is what caused him to abandon his attempt to go into that house.
Okay.
So now he's running away from the house.
Okay.
And he makes it about 15 steps, give or take, 15 steps away from the house before you start seeing a trail of blood on the ground.
Okay.
Is that consistent with this? Does that make sense?
It can happen that way, yes. Okay. Like I said, he could start bleeding immediately, or it could take several steps to begin to start bleeding.
So the scenario that I just laid out for you, this is not a wildly impossible or unlikely or ridiculous scenario. This is consistent with what you've seen here, correct?
Yeah, it's one way it could happen. I can't tell you for sure that he didn't start bleeding for 15 steps. I also can't tell you for sure, he would have started bleeding immediately.
Right. And nobody knows for sure except for the people who would have been there, right?
Correct.
Thank you, Doctor.
New York.
Dr. Mathis, you were asked on cross-examination about if a tourniquet was placed on the victim, it would help slow down the bleeding.
If placed tight enough, yes.
You don't know when a tourniquet was placed on the victim in this case, do you?
No.
So if there was a delay in when the tourniquet was placed, would that slow down the bleeding or cause him not to die?
The delay in the tourniquet, he'll be bleeding the entire time until a tourniquet is put on, tightly. So anytime up until that tourniquet is put on, the pressure's not being applied, the wound's going to be bleeding. You may not be able to see it on the outside, but it'll be bleeding on the inside.
So if a person waits 10 minutes to call 911 and the officers then take some time to get there after, would that contribute to the victim's death as well?
Yes.
Now you were asked about the blood coming out, and they're coming out of holes, and it may not bleed at that time, or it may. If a person is running away, would the blood start coming out?
It should, because now you're moving the leg, you're advancing it forward, you're causing manipulation, just like I told you. When we start flipping the body, the blood starts pouring out of the hole. So as you're moving, the blood should start, you should start leaving a blood trail.
You're also asked about hypotheticals, so I want to pose one to you. If a person goes outside, they're on the steps, they pick up a gun, they point it out of the victim sees the gun, in fear for his life, turns around and runs away, and that person shoots. Is that consistent with what we have here today?
Can you repeat your question?
Yes. A person picks up a gun, aims it at the victim in fear for his life, turns around, runs away, and the person shoots the victim. Is that consistent with what we have here today?
Yes, it could happen that way.
Thank you, Judge. No further questions.
Judge, we agree cross on that question.
Yeah.
Judge, I would ask that we go sidebar.
I haven't heard anything yet, so not at this time. Go ahead.
You were asked about a victim who's in fear for his life running away, right?
Yes.
That's the question she just asked. Would you expect somebody who's in fear of their life to say, "I'm ready to die"?
Objection, Judge. Speculation, debating comments of the jury.
Can you answer that question?
I can't.
Okay, so that's an
Thank you.
Please step down.
All right, thank you.
Let's go ahead and bring in criminal defense attorney John Day. Okay, John, that was a little bit startling from defense counsel there, but I mean, he was trying to make a point.
Yeah, you know, the judge is letting the hypotheticals go. She's giving them pretty free rein. And what the defense simply wants is this witness, words coming out of his mouth that say to the jury, yeah, I mean, this is feasible. This could have happened this way. It's possible. I can't tell you. You know, the medical examiners, of course, they cannot give the final opinion on who did what and what happened and you know, at that moment. But what they can do is they can provide the jury with, you know, basic information with building blocks to get them there. And then the eyes of the defense team, they just wanted this medical examiner to say, yeah, your hypothetical could work. I don't know what really happened, but all they need is to land that one punch with this witness. So they're hoping that at least one or more of these jurors is going to remember that exchange and say, well, it could have happened that way. And is that reasonable doubt? And in closing, they're going to hammer on that. But it was an interesting exchange. The defense lawyer getting very emphatic there, and whether that helped his case or not, who knows?
Yeah. You know, John, the defendant here had said that this was kind of a stand your ground situation. They had filed that motion. The judge ended up denying it. They wanted this murder charge dropped. Of course, that didn't happen. That's why we're here today having the trial. One of the things that the judge cited was some of the ring camera footage. We've had that up before for our viewers, in which they're saying that the defendant in this case, after the shooting, just appeared calm and kind of in a joking manner. So the jury is going to see and has seen a lot of the video that was available. We're taking a look at some of it right now. How do you think that's going to be?
Well, you know, two sides of the same coin. The defense is going to say, look, when something like this happens, people react different ways. There's not one predictable pattern that you're supposed to react this way. Of course, prosecution is saying, you know, this is clear that this is someone who was not acting out of fear, but they were acting out of intent, malicious intent, murderous intent. Whether the jurors buy the defense theory that you cannot say with certainty that someone who is supposedly acting in self-defense is supposed to act this way and she didn't act the way that you think she was supposed to act, you know, they've got to differentiate that. They've got to put in the minds of this jury what took place. And again, each juror is going to be looking at this thinking whether or not, you know, they're supposed to relate their own lives to it. They're going to be thinking, how would I have reacted if I had to act in self-defense? What would I have done? Is this consistent with human nature and things that I've seen in my life? So, you know, the defense is certainly hoping that the jurors are going to say, I can't say how I would react, but this is how this person reacted, and we can't discount that.
John, thank you. Coming up next, we have a witness. It's a sergeant who extracted the defendant's cell phone. We'll be back.
Detective, what did we hear Ms. Link say on video?
I mean, it's very grainy in this video. It's a lot more clear when I watched it, but it talks about hitting a major artery. It talks about Daisy Link saying, "You'll be fine," and then asking, "Are you sure you don't want to go to the hospital?"
I have nothing further on.
Let's go back to Miami, Florida, where our newest live trial is underway for the defendant, Daisy Link. The 30-year-old Homestead woman is accused of shooting and killing her on-again, off-again partner. His name is Pedro Jimenez. This was back in June of 2022. Let's head into the courtroom now. A new witness is on the stand. This is a sergeant with the Miami-Dade Sheriff's Office.
Yes, my name is Sergio Cremacini.
And where do you work?
The Miami-Dade Sheriff's Office.
And what's your title there?
A sergeant at the moment.
How long have you worked at the Sheriff's Office, Lindsay?
I was hired September 16 of 2013.
What unit do you work in currently?
The Homicide Bureau.
And do you have any training or experience on cell phone extractions?
Yes, I do.
Can you please tell the members of the jury what that is, your training and experience there?
Sure. So within my current role within the Homicide Bureau, I'm the supervisor of a specialized unit within the Homicide Bureau. And within that unit, myself as well as some of the detectives that are assigned to me, we've attended various trainings in the areas of digital forensics, specifically cell phones, as well as just general cellular records as well.
And in order to work in that unit, do you have to go through that training?
Yes, in order to conduct the work that we do, there are prerequisite and required trainings.
And I think you already said this already, but specialized training specifically for cell phone extraction, that's something that you have to do?
Yes, so there's a few different trainings in regards to actually conducting the cell phone extractions that I've taken, specifically by a company called Cellbrite, which is the primary, one of the primary softwares that are utilized in conducting these extractions. And with those trainings, they're broken up into a few different areas, but primarily in the actual extracting or downloading the data from a cell phone or an electronic device, and then processing that data that's downloaded as well.
Okay. And generally speaking, how do cases get assigned?
Are you asking in the context of myself or in just a case in general?
Cell phone extraction, I'm sorry.
So in the case of, or in the circumstance of a cell phone extraction, it could be as simple as the detective, whoever it may be, just picking up the phone and calling and just informing us of whatever assistance they may need.
Okay. And generally speaking, is this, let's say a detective calls you up and says, "Hey, Sergeant, I want you to extract a phone," or is it randomly assigned?
So within my unit specifically, it's myself and a detective, one other detective that I supervise that has the training and the equipment to conduct that. So within my unit, the phone call would ultimately end with either myself or that other detective.
Okay. Now, were you involved in a case PD 220625210513?
Yes, I was.
How did you get involved in that case?
So in that case, in this case, I was provided ultimately with 2 cellular telephones to attempt to conduct forensic extractions.
Who provided those to you?
The relevant telephone is from a detective, Daniel Morales.
Okay. Now, you said relevant phone. What are you talking about there?
So of the 2 phones that were provided, one of the phones I was able to obtain a full extraction from due to the password being provided. The other phone was an iPhone that was password protected, and the password was not known. And due to the state of the phone, an extraction was not able to be conducted on that other device.
Now, I want to talk about that for a moment. Did you attempt to extract that cell phone?
Yes, I did.
Were you ever able to extract any data from that cell phone?
No.
Okay. Were you ever provided a password to that cell phone?
I was, but it was unsuccessful.
Okay. Now, when that detective got you the phone, or gave you possession of that phone, was that with a warrant, or did you just unlock it yourself?
No, it was the device with the accompanying property receipt as well as the search warrant.
Now, how do you identify a phone that you are going to extract?
Well, depending on how it's provided, but typically in an instance where a search warrant is provided, it would be whatever is identifying features are explained in the search warrant, and that then in conducting a physical review of the device to ensure that it's the correct device that accompanies the legal process.
Now, after you confirm that you have the correct phone, what do you do, if anything?
So typically you take that device and you just do a visual of it, ensure that it is that it's working, that it's powered on, and then from there take it to a specialized equipment and then begin the extraction of that device.
Okay. Can you explain to the members of the jury what a Faraday room or Faraday box is?
Yes. So pretty much think of it as a large room that any signal cannot get into. So if you were to take your phone inside, it would be completely shielded from any Wi-Fi, any cellular, or any sort of connection that could communicate with the phone. So it isolates it completely from any sort of outside signal.
Okay. And generally speaking, does data change on a phone?
It can, yes.
Okay. How does it change, or what? Is there anything to stop it from changing?
So with any cell phone, there's always going to be things that change on the phone just by the way that phones work. There's always things happening in the background. There's always applications that are open, and there's always things that are continually evolving. That doesn't mean that the files themselves change, but there are additional files and additional logs and records that occur just with the phone being on.
Now, I know that we talked about this briefly, but once you plug a phone into a computer, what happens with that? Do you download the phone? How do you go about that? Is there a program?
Yes, so in this case, I utilized a piece of equipment manufactured by a company called Graykey, and with that, after unlocking the phone and connecting it to the equipment, it downloads a full extraction of the entire file.
All right, coming up, we are going to switch gears, and we're going to head back to Florida, but this is for a different situation. Jose Soto Escalara will soon find out if he will be sentenced to death. That's coming up next.
Tonight on Closing Arguments, the biggest moments from today's testimony in the Toddler Stabbed murder trial. We dive deeper as this case nears its dramatic finish.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
A wife accused of murdering her prominent attorney husband, and the defense involves blaming her own sons?
Victim to verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Is that the last time you ever saw your daughter, Tanya?
Yeah, by the door, yes.
She says it's mine, supposedly. I can't take chances. I lose everything. I'm going to blow her brains out so she doesn't talk.
On that day, I've lost more than a mother. I also lost the chance to have my mother watch me grow.
We, the jury, find Jose Soto Escalera guilty of first-degree murder as charged in the indictment. As we count 2, guilty of first-degree murder of an unborn child. So say we all.
That was last month when a jury voted to recommend the death penalty for Jose Soto Escalera. Soto Escalera was convicted in the murders of his mistress, Tanya Wise, and their unborn child, Josiah. Now we will finally learn whether or not he will be put to death for his crimes. The judge is on the bench. Let's head into the courtroom.
All right, all parties are present. I'm going to read the sentence of the court into the record at this time. In doing so, there are portions of the sentencing order that are case law citations that I will not be reading, but they do appear in the written order. Police found the body of 23-year-old Tanya Wise face down in a culvert ditch on the side of the road in a remote rural area of St. Lucie County. She suffered a significant blunt trauma blow to her skull, fracturing it and causing internal injury to her brain. Her throat had been cut. There were 2 deep lacerations on her neck, going right down to the bone. One from the midpoint of her throat to just under her right ear, and the other from the middle of her throat to her collarbone. The medical examiner could not specify the sequence of the injuries. Therefore, the degree to which Tanya experienced terror from this horrific murder could not be proven. The blow to her head was so devastating that if it was the first blow, it would likely have rendered her unconscious and in and of itself could have caused death. The slashing of her throat was so violent, deep and penetrating that it, in and of itself, was a fatal injury. There were no defensive wounds found on her body. Tanya was in the very late stages of pregnancy of a baby boy whom she was going to name Josiah. DNA analysis proved the defendant to be the boy's father. As a result of her murder, the baby also passed. The defendant, a man in his 40s, plotted and planned her murder for days. His days of planning and plotting were caught on audio and video. Would you please silence your phones? He drove a garbage truck for a living. The trucking company had installed recording devices in all of its trucks for liability purposes. His working companion on the truck was his nephew, Eric Alvarado. As reflected on the recordings, he told his nephew that Tanya Wise was going to destroy his life by exposing their illicit affair and the resulting pregnancy to the defendant's wife. Well in advance of her murder, he chose a location to kill her and dispose of her body. The location was along the street path of his garbage truck work route. After the murder, he recounted the events to his nephew telling him how he covered it up. In planning the murder and recounting it, he did so in a remarkably callous, carefree, and nonchalant way. When police later interviewed him, he feigned surprise to hear of her murder. He claimed he only knew Tanya as an acquaintance and never had sex with her. He completely denied the possibility that the baby boy was his child. The jury convicted the defendant of the first-degree murder of Tanya Wise and the first-degree murder of her unborn child, Josiah. Unanimously, the jury made a written finding of the existence of the following statutory aggravating factors. 1, as to both victims, pursuant to Section 921.1416B, that the defendant was previously or contemporaneously convicted of another capital felony or of a felony involving the use or threat of violence to the person, which, respective to each count, is based on the contemporaneous conviction as to the victim involved in the other count. 2, as to both victims, Section 921.1416I, that the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. 3, as to the unborn child, Section 921.1416L, that the victim of the capital felony was a person less than 12 years of age. By a vote of 8-4, the jury recommended a sentence of death as to the murder of Tanya Wise. Also, by a vote of 8-4, the jury recommended a sentence of death as to the murder of Tanya Wise's unborn child, Josiah. After receiving the jury's recommendation, the court allowed the defendant a separate hearing to allow for an opportunity to argue and present additional mitigating evidence pursuant to Spencer v. State. Weighing of aggravating factors as to the murder of Tanya Wise. Pursuant to Section 921.1416B, the defendant was previously convicted of another capital felony or threat of violence to the person, which, respective to each count, is based on the contemporaneous conviction as to the victim involved in the other count. This aggravating factor was established as a matter of law as to each victim by virtue of the jury's convictions for 2 capital murders. Violent felonies committed contemporaneously with a capital crime can qualify under the prior violent felony aggravator, where, as here, the criminal episode involved multiple victims. The prior violent felony conviction aggravator is one of the most weighty in Florida's sentencing scheme. The court assesses its weight as to Tanya Wise as follows. To understand how weighty this aggravating factor is in this case, it is noteworthy that this aggravating factor could be satisfied if the defendant had premeditated the murder of one person, but simultaneously and spontaneously committed a violent felony upon another person, such as an aggravated assault or aggravated battery. But here, there are 2 simultaneous premeditated murders. This is the much more extreme scenario in which this aggravator can be established. Therefore, it is entitled to very great weight. The court affords it very great weight as to Tanya Wise. Pursuant to Section 921.1416I, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. The cold, calculated, and premeditated aggravating factor focuses on whether the defendant had a careful plan or prearranged design to commit murder before the fatal incident. Calm reflection is often involved. The evidence of calm, cool reflection and planning, well beyond what is required for premeditated murder, is overwhelming in this case, and the court finds it proven beyond a reasonable doubt. To maximize the chances of avoiding detection, the defendant coldly contemplated in advance every aspect of these murders, including the location and method of killing. He did so in a remarkably callous, carefree, and nonchalant way. As to Tanya Wise, the aggravating factor is entitled to very great weight. Weighing of aggravating factors as to the murder of the unborn child of Tanya Wise. Pursuant to Section 921.141(6)b, the defendant was previously convicted of another capital felony or of a felony involving the use or threat of violence to the person, which, respective to each count, is based on the contemporaneous conviction as to the victim involved in the other count. As to the unborn child, the court's analysis of the weight of this aggravating factor is the same as to the murder of Tanya Wise.
Coming up, we're going to have more of the sentencing for Jose Soto Escalera. We'll be right back. You're watching Court TV Live, your front row seat to justice.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott, of course, honored to be with you on this Friday. We begin in Fort Pierce, Florida, where life or death hangs in the balance for convicted killer Jose Soto Escalera. A jury already recommended the death penalty after finding Soto Escalera guilty of first-degree murder. Prosecutors successfully argued that he fatally shot his pregnant mistress, Tanya Wise, and their unborn child in order to conceal the affair from his wife. Today, a judge will decide whether Soto Escalera should spend the rest of his life behind bars or if he will receive the death penalty. Let's get you back inside of the courtroom. We had hit the pause button. The judge is laying out all the details of this case before announcing his decision.
The court affords it very great weight as to the unborn child. Section 921.1416I, the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. As to the unborn child, the court's analysis of the weight of this aggravating factor is the same as it relates to the murder of Tanya Wise. As to the unborn child, the aggravating factor is entitled to very great weight. Section 921.1416L, the victim of the capital felony was a person less than 12 years of age. The court finds this factor proven beyond a reasonable doubt. The child in this case was unborn, yet fully formed and about to be born within days. The premeditated murder of this baby deprived him of ever experiencing life outside of the womb. The premeditated murder of an unborn, fully formed human being still in the mother's womb, about to be born within days, is by its nature extremely abhorrent, reprehensible, and strikingly revealing of a malevolent mind. The court affords this aggravating factor very great weight. Findings regarding mitigating factors reasonably established and weighed. To properly carry out its important duty and to allow for meaningful appellate review, this court must expressly evaluate herein each statutory and non-statutory mitigating circumstance. In addition to the mitigation presented to the jury, the court has also considered any suggested mitigation from the Spencer hearing. Any proposed mitigation, whether statutory or non-statutory, must be reasonably established by the greater weight of the evidence. If a statutorily listed mitigating circumstance is supported by the evidence, it must then be weighed as to its significance. Unlike statutory mitigation, the court must first determine if proven non-statutory suggested mitigating circumstances are truly mitigating in nature. Once truly mitigating non-statutory mitigation is established by the greater weight of the evidence, the court must weigh it. It is within the sentencing judge's discretion to determine the relative weight given to each established mitigator. Because of the overlapping and related nature of many of the mitigators, the court has grouped some of them to ease and clarify the analysis. The court has still individually contemplated and considered the nuances of each of the suggestions in weighing them. The court has carefully applied its reasoned judgment in this regard. Statutory mitigating factors. Considered statutorily listed mitigating factor. The defendant has no significant history of prior criminal activity, and considered related non-statutory mitigating factor. The defendant has no prior history of violence. These circumstances were established by stipulation as to no prior criminal history in general, and by testimony as to the lack of violent history. This included specific instances when the defendant maintained his cool when others might have reacted more aggressively. Adding to this mitigation is that during the defendant's life, he was faced with stressful circumstances similar to those posed by the threat of exposing his infidelity in this case. Specifically, he was on more than one occasion taxed with his self-created predicament of supporting children he fathered out of wedlock. On those occasions, he did not respond with violence or criminal activity. Rather, he responded responsibly. Additionally, during the breakup of his relationship with Madeline Cologne, she put him in a situation where many men might respond aggressively, but he did not. When she discovered his involvement with another woman, she burned his clothes, broke his phone, keyed his truck, and flattened its tires. Despite this, he remained calm and did not act violently. According to her, he handled it perfectly. Childhood reports of the defendant's behavior were consistent with him being non-aggressive. Family members reported that they had to stick up to bullies on the defendant's behalf. This mitigator was established, and it is entitled to moderate to great weight. Non-statutory mitigating factors. Considered related non-statutory mitigating factors. While in jail custody awaiting trial, the defendant has been a peaceful, mostly compliant inmate. The defendant can positively contribute to society as an inmate worker if sentenced to life in prison without parole. The defendant has demonstrated exemplary jail-prison behavior. The defendant will be required to work 60 hours per week in general population at the Florida Department of Corrections if sentenced to life without the possibility of parole, and he would adjust well in that general population setting. He would likely contribute to the prison system. The defendant poses no danger to prison, jail staff, or inmates. The defendant will be completely incapacitated and pose no danger to the community with a sentence of life without the possibility of parole. As listed by the defense, the defendant, quote, can be redeemed, unquote, which the court takes to mean that he would prove to be a good inmate. Since his arrest in 2018 for these murders, while in the county jail, the defendant has only committed 3 disciplinary violations, and they were all minor and virtually insignificant in nature. He's had no fights with other inmates or violent encounters with guards. The testimony did credibly establish a significant probability that the defendant would be a model prisoner if placed in general population. The defendant's personality and work skill set would suit him well in general population. The court finds these mitigators to be proven and affords them moderate weight. Considered non-statutory mitigating factor. During a previous romantic relationship with Lucinda Cook, the defendant acted like a gentleman and was nonviolent in the face of instigating behavior by Ms. Cook. Ms. Cook was a gas station attendant and the mother of 3 young children when she started dating the defendant approximately 10 years before the murders. They dated for a year and then lived together for a short time. When she met the defendant, she had just come out of an abusive relationship and as a result was impatient and verbally abusive to the defendant. There came a time when she decided to end her relationship with the defendant for reasons unknown to the court. During the term of their relationship, she described the defendant as acting gentlemanly to her and her children. Her children were fond of him. The defendant made her and her children feel safe. According to her, despite his model gentlemanly behavior, she found fault with everything he did and argued with him for essentially no reason. She described that during their time together, it was common for other women with whom he was also romantically involved to come around her and cause problems. She went out of her way to emphasize that this was no fault of the defendant. When she decided it was time for him to leave their relationship and presumably their domicile, she pushed and damaged his fancy motorcycle and spat in his face. Despite her aggravating behavior, he never argued, got mad, or did anything to retaliate. She never saw him act violently, even though he was apparently employed at that time as a club bouncer. To the contrary, rather than just
We're going to hold the judge's findings there because we want to take an opportunity to bring in trial attorney and law professor Joe Richardson. Joe, thank you so much for being on with me today. The judge is laying out aggravators and mitigators, and a couple of things stood out to me when he was reciting aggravators, and I want to get your opinion. I felt like he really did focus and put emphasis on, number one, that it was 2 simultaneous premeditated murders, not just another aggravating crime, but another murder, that it was cold, calculated, and premeditated. And then he focused on that reprehensible aggravated factor of killing a child who would have been born shortly. What are your thoughts as he went through the aggravators?
No doubt about it. He really did talk a lot. What really stuck out to me was the talk about the unborn child, right? He absolutely used that, and he gave heavy or significant weight to that, you know, as compared to some other factors. Remember, there's these factors that are aggregating factors, and then he can decide to put minimal or moderate or more serious weight on them. And it sounded like he was giving very serious weight to those factors, including particularly the killing of the unborn child, being a child under the age of 12, etc.
Yeah, and I liked how he then transitioned into the mitigators, pointing out that he would consider those that are statutory, that he must do that, as well as those that were non-statutory. And when he started talking about the prior history of violence, he said that's not statutory, but I heard it in testimony that this defendant doesn't have that. And then he said, and no prior criminal history. Any convictions he does not have. None of that. That was evidence stipulated to. I think those are significant as well, and kind of wild that he went to this level of a crime with no prior history or violent episodes.
It really is amazing. Certainly he had a fidelity problem for sure, because a lot of the aggravating and mitigating factors are considered in context of his other relationships. But that being said, to your point, he seems to have jumped from doing absolutely nothing, not being on the police's radar at all. This is not a domestic abuser. This is not somebody that's convicted of other crimes. But, you know, they are introduced to him effectively when he kills his girlfriend to keep the pregnancy and the relationship from being found out. So it really is quite amazing that after everything he'd gone through, even as a child, and all these other things that are being talked about, and all these other opportunities for him to do something else, he hadn't done anything else. It wasn't on their radar until this. So there's a bit of an irony there.
It is a bit of an irony, and we know the judge is laying everything out before he makes his decision, or tells us his decision, rather, of whether this will be life behind bars or death. A heavy finding for this court to make. That's what he is tasked with. Stand by, Joe. We need to take a break. But before we do that, just moments ago, the defense rested in the murder trial of Bionca Ellis. This is the woman accused of stabbing a 3-year-old boy to death and injuring his mother outside of a grocery store. And we have a quick programming note. In a new episode of On the Record, Court TV's Cody Thomas takes you inside the courtroom, breaking down this heartbreaking trial against Ellis day by day. Watch On the Record, the toddler stabbing trial, now streaming at CourtTV.com under the Shows tab, or on our Court TV YouTube page. Stay tuned. We'll have more of the sentencing for Jose Soto Escalar right after this quick break.
Tonight on Closing Arguments, the biggest moments from today's testimony in the Toddler Stabbed murder trial. We dive deeper as this case nears its dramatic finish.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
A wife accused of murdering her prominent attorney husband, and the defense involves blaming her own sons?
Victim to verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
We are getting you right back into court now in Fort Pierce, Florida, where a judge is expected to render his final decision today on whether convicted killer Jose Soto Escalara should receive life or death for fatally shooting his pregnant mistress and their unborn child. Right now, the judge is just moments away from handing down his sentence. Let's go back in for more.
Mitigating factor. The defendant escaped a high crime, high poverty area, independently moving to Florida when he was just 15 or 16 years old. The defendant exhibited resiliency in overcoming early life challenges. The evidence does establish these circumstances. However, there were no credible direct instances proven of the defendant personally witnessing any extreme violence such as gang violence. There was no strong evidence of the negative effects of living in a low-income environment. The court affords these mitigating factors little weight. Considered non-statutory mitigating factor, the defendant exhibited excellent courtroom behavior. Overall, the defendant was well behaved during the trial process. However, when the court received their sentencing recommendation verdict from the jury, when his conduct counted the most, the undersigned did observe the defendant expressing his disagreement to the jury. He noticeably shook his head in disapproval rather than remaining still and accepting the judgment of his peers. This came after the defendant heard the court admonish all audience members not to react by showing joy or displeasure so that jurors would not have a negative experience and be dissuaded from serving. The defendant did the very thing that he heard the court admonish the audience not to do. The court finds this factor to be proven and affords it extremely little weight. Considered non-statutory mitigating factor. The defendant will continue to offer a positive life influence on his children, other family members, and friends who have become emotionally dependent on him. Given the circumstances of his family's reaction to his conviction by distancing themselves, the degree to which the defendant's family will stay in touch with him is uncertain. However, the court does believe that if given a chance, the defendant would remain in contact with and support his relatives as best he could. The court finds this to be proven and affords it little weight. Considered non-statutory mitigating factor. After the jury recommended the death penalty for him, the defendant expressed empathy for his victims to his mitigation specialist. The court finds this to be proven and affords it very little weight. Suggested and rejected non-statutory mitigating factors. The negative effect of a prolonged appellate process on the victim's family and the dangerousness of general population as opposed to death row. The court does not find that the negative effect of a prolonged appellate process on the victim's family is a proper consideration, nor does the court find that the dangerousness of general population as opposed to death row is a proper consideration. In the defense mitigation expert report, neither of these were connected whatsoever personally to the defendant. Rather, they were framed as general policy arguments. Neither of these circumstances meet the definition of a mitigating factor under the law. That is, matters relevant to the defendant's character or record or the circumstances of the offense proffered as a basis for a sentence less than death. Conclusion after the weighing process. The court has carefully weighed the aggravating and mitigating circumstances as to each murder individually. The court's weighing process can be summarized as follows. As to Tanya Wise, there are 2 aggravating factors that are entitled to very great weight. As to the unborn child, there are 3 aggravating factors that are entitled to very great weight. As to the mitigating factors, the cumulative weight of the mitigation is entitled to moderate to great weight. As to each murder, the court finds that the aggravating factors outweigh the mitigating circumstances. As required by law, this court has given great weight to the jury's recommendation. The court's weight analysis in this case, with its acknowledgement of significant yet outweighed mitigation, is a reflection of the jury's 8-4 vote for death as to each of the murders. The court's independent evaluation of the case herein leads to the conclusion that the death sentence is the appropriate and just sentence as to each victim. Therefore, Jose Soto Escalera, I hereby sentence you to death for the first-degree murder of Tanya Wise. I also independently sentence you to death for the first-degree murder of her unborn child. I hereby order that you be taken by the Sheriff of St. Lucie County to Florida State Prison for close and secure confinement until the date of your execution, at such time as scheduled by the Governor of the State of Florida at the place of execution named in his warrant of execution. You shall be put to death by the means provided by Florida law at that time, and may God have mercy on your soul. You are hereby notified that the sentence of death is subject to automatic review by the Supreme Court of Florida. The court finds you continue to be indigent and hereby appoints the office of the public defender to represent you on appeal. And that is the sentence of the court, and that will end this case. Thank you all.
God have mercy on your soul. That is how the judge concluded his sentence, finding that the aggravating factors outweigh any cumulative mitigating factors for each of the murders, putting great weight on the jury recommendation of death sentencing. This defendant, this convicted felon who committed 2 reprehensible murders as described by the judge, sentencing him to death. Still with me, trial attorney and law professor Joe Richardson. Joe, your thoughts as you heard the judge say he is sentencing the defendant to death.
He was obviously very thoughtful. He says, you know, what he's supposed to say. Here's what the jury's recommendation was. We independently looked at this. It was clear that the aggravating factors were getting major weight and the mitigating factors were getting moderate to slight weight, if any weight at all. And where he ultimately arrived cannot be a surprise based on just what actually happened here, the manner of this death. It just lets you know that how severe this was in the eyes of the jury, everyone else, is that even though he's this relatively nice guy that's not necessarily on law enforcement's radar or the Florida correctional system's radar up to this point, what he did was heinous enough, including to an unborn child, where he deserved the ultimate penalty.
And we know he'll appeal. Anyone with a death sentence appeals. And I appreciated, to your point, that the judge was so deliberate in all of his findings and what he gave moderate weight versus heavy weight. And the other thing I noted is he did say he gave great weight to the jury's recommendation and the 8-4 vote for death as to each of the murders. I think those numbers are significant because I think 8-4 is a little bit on the brink, right? And you have to have at least that many in Florida. It's changed throughout historically in the state of Florida. Some states, as we know, require unanimous. Is that 8-4 vote to which the judge gave great weight, as he just stated, is that something that you think might have an opportunity to prevail in an appellate argument?
Well, he's certainly going to try, right? I don't think that he has a particularly good appellate argument, but of course, as the judge said, he automatically gets an appeal. So yeah, it wasn't 12-0. Okay, yeah, it wasn't 11-1. It wasn't 10-2, but it was 8-4. And so the jury was very thoughtful, and unanimous by the jury doesn't necessarily relate to a successful winner appealable issue. I think that the facts of this case are so heinous and so direct. They know that they've got the right guy. There's none of those issues like that. There's nothing in mitigation. There's no back and forth. There's no thing that makes someone stand outside and say he shouldn't have done it, but I understand. There's nothing like that here. And so ultimately, I think that this will pass muster with the appeals court, and he's on his way to a death sentence.
Appreciate your insight, Joe. Again, the judge sentencing Jose Soto Escalara to death for the murders of a young mother he had an affair with and their unborn child. Joe, stick around, please. After the break, we will head back to our other case out of Florida, the toxic relationship murder trial of Daisy Link. Don't go anywhere. We'll be right back.
Which way?
Twice. No, I didn't. He was walking. I saw him laying there.
There's a pretty large blood test. If you got other units responses.
Yeah, she found him here. Like laying here like this? Yeah. When I got here, this is where he was. I got no pulse.
Welcome back to Court TV Live. I'm Ashley Wilcott. Thanks so much for being with us. That was the chaotic scene at the center of the toxic relationship murder trial taking place in Florida. Defendant Daisy Link is charged with second-degree murder for allegedly shooting and killing her on-again, off-again boyfriend, Pedro Jimenez, on June 25th of 2022. Prosecutors believe that Link was the aggressor in the relationship, but her defense claims that she had been trying to leave Jimenez because he was, quote, out of control, unhinged, and dangerous. Let's get you back inside of that courtroom. The jury is not present, but the judge is on the bench.
But it is being redacted.
Yes, sir.
How are you all going to redact it in time to play? We're doing it right now.
So what?
Are you able to do it from there? No, Judge, but we're asking.
It's going to take some time anyway for me to get to the point in time with Detective Janor, so we can figure that part out. And then I did inform Mr. Tomas there's a jail call that a portion of it I intend to introduce. It is entirely relevant to phase 2. The entirety of it, of that call, it kind of talks about the prior convictions in that call.
What do you mean phase 2?
Should the defendant be found guilty, we would then do a enhancement portion of this. As noted, the state filed its notice of enhanced penalties. In this case, which the jury will have to make the determination whether or not the defendant is a habitual offender. This call is entirely relevant to that because she talks about her prior convictions. The portion that I want to elicit in testimony for during Detective Janor's testimony is a portion of time in which the defendant, there's conversations about what essentially she is facing, that there was a conversation about 15 years, and she says the prosecutors changed their mind and they said no, 25 years. The defendant says, well, if I would have known that, all around court.
Let's just focus right now. Why would I let the jury hear that she admits to her priors?
No, I'm not introducing that portion. Like I said, the only portion that I'm intending to introduce for this portion of the testimony is what I just said. If I knew how much time I was facing, I would have done this. The reason that I want to introduce that is because, number one, it goes directly to her intent and will directly refute the statement that I'm about to introduce as well, that this was a mistake, that this was a misunderstanding, that she was protecting herself. This goes directly to that. And specifically, elements 3, I think, of this crime that the depraved mind act. That goes directly to this.
That's on the jail.
Yes.
Okay, what's your response?
So, Judge, this jail, I don't know exactly when it was, but it's my understanding that it was, what, in the last month?
Last couple of weeks.
Last couple of weeks. So we've got that, a lot of time that has passed. She's talking about what she's facing. So, first of all, this conversation, this very small part of a 15, 20-minute conversation, I would submit that it's far more prejudicial than probative. I don't think it's probative of anything. But if the court were to allow it, then it opens up, or it opens the door for her to explain her state of mind and why she said it. And if you do that, then we're talking about, well, facing life. This other guy got 25 and he was charged with a lot more.
I don't have an objection to that.
Said that in jest, things of that nature. So I think it just opens up. It opens up for a lot of problematic issues.
I don't have an objection to her talking about that. About the time that she's facing and the state of mind in which she said.
You don't have a problem.
I have zero problem.
I have a huge problem with that.
Judge, there's no pending.
When I use the word duty in front of the jury, why did I go through that? And I use that very diplomatic, neutral word instead of prison, minimum mandatories, enhancement.
We talked about that during voir dire, that they would not be a part of the sentencing phase. Your Honor brought it up. I brought it up. I forget the gentleman who mentioned that something about how he would be uncomfortable sitting in judgment of it because he could potentially be taking somebody's life away. And then we discussed that this was not a capital case, that she is not facing the death penalty.
So why would I now allow them to hear that she's potentially facing?
Judge, I'm not making, nobody has made a motion of limine to limit that portion of this case. Normally, the state brings that up in a motion of limine because it is inflaming the passions of the jury to say, well, this woman's life is in your hand, and if you convict her, she's facing this. I do not have a problem, and I am not making a motion in limine to limit that. I don't think that it would be a compelling closing argument to make, but regardless of that, this call is, number one, a business record. Number two, it is the defendant's statement, so it's not being introduced for the truth of the matter asserted. It's for statement by party opponent as well as a business record, so it's admissible as such. And then number two, the reason that it's more probative than prejudicial is because, again, element 3 of this crime is that the defendant committed this act with a depraved mind, which goes directly to this case. The defense's argument, theory of the case, I'm introducing her statement in which she says this is self-defense. Mr. Tomas, during a number of different testimonies, has elicited the testimony, especially with Dr. Mathis, about how the victim was charging at the defendant, screaming at the top of his lungs. I think during opening statement, he said this was a guttural, vicious, almost demonic statement that the victim made, which Ms. Link, in this jail call, in this portion of the jail call, and it's about 30 seconds, says, well, if I knew how much time I was facing, I would have chopped him up and spread him all around Florida. The reason why that's so important is because she says this was an accident. She didn't mean to do this. This wasn't her intention. This goes directly to that and the depravity of her mind at the point in time that this crime was committed. I have zero problem with Ms. Link when she testifies, because I think we're all on the same page here that she is going to be testifying. I have zero problem with her explaining that call, and she should.
Okay, your request is denied. It is highly inflammatory, highly irrelevant. It happened 3 years after she was arrested. The context of which she's making that statement is during a breakdown of plea negotiations. It's also not connected in any way temporally to the commission of the crime or any statements she made post-Miranda.
Well, Judge,
it's also more, nope, pleadings are closed, no more argument. You started first, you went second, you're going third, and that's it. It's also more prejudicial than probative. That's my ruling.
I understand your ruling. I just want to put two things on the record. Number one, during the court's ruling right now, I can see it on the computer screen. Ms. Link is rolling her eyes every time I open my mouth. I would ask the court to admonish Ms. Link once again. I know that we had a conversation sidebar about that in the next of kin. I think that this is becoming a feature of what Ms. Link is doing during this trial and trying to, I don't know, get her 15 minutes of fame. And number two, I think this goes directly to the defendant's consciousness of guilt, of what she would have done.
Thank you. You have asked third. Ms. Link, I cannot go in the mind of the jury. I think they're paying attention. I think they're dedicated. The fact that they're here early almost every day and they come back for lunch. We've been doing the case, not them. You're not allowed to make any facial expressions. Like I said before, this is a tragedy all around. You're allowed to be emotional. You have to control it. Because I literally told the next of kin through Mr. Bonita that I could see their emotions, and I asked him to have them limit their emotions. It was cumulative over a few-day period. I haven't been looking at you. I don't know if you're rolling your eyes or anything of that nature. I know that you got emotional when the body-worn camera was played, just about everyone did. But the jury needs to decide this case based on the evidence and not from any outside influence. It's actually in your best interest to control any facial expressions you may be doing, because if they don't like what they're seeing and they don't tell me, I don't know what's in their heart, and I don't know what's in their mind. Does that make sense? Yes, it does. Okay.
So just the only other thing that I wanted to inquire about is the order that you were able to get a certified copy of. Can I use that, or do we need to get like an original from the...
I don't have an objection to the introduction. I still think that the court needs to take judicial notice that a termination of parental rights does not exist in this
You have
case.
an objection to me doing that? I think I was inclined to do that.
That's fine, and I would seek to admit that order as a certified document.
It's interesting that the prosecutor raised this outside the presence of the jury, which is the proper thing to do, but rather that the judge, and then in spite of it not being in front of a jury, said, stop rolling your eyes. You have to control your facial expressions. It's disrespectful to the next of kin. Let's take a break here. When we come back, we're going to bring you more of the toxic relationship murder trial of Daisy Link. Stay tuned.
You dream about moments like this. My goodness.
The fastest female track and field stars compete in a one-night-only event. Atlas NYC 2025, live from New York City. Tonight at 7, it's on ION.
Tonight on Closing Arguments, the biggest moments from today's testimony in the Toddler Stabbed murder trial. We dive deeper as this case nears its dramatic finish.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Back now to Florida, where day 3 of testimony is underway in the toxic relationship murder trial for Daisy Link. The 30-year-old is accused of fatally shooting her on-again, off-again boyfriend in the leg back in June of 2022. But the defense says that Pedro Jimenez was unhinged and dangerous that day, and that Link had to shoot him in self-defense. Before we go back into court, let's bring back in trial attorney Joe Richardson. Joe, I asked to bring you back in because I wanted to get your thoughts on the fact that the jury was not present. The prosecutor objected to the defendant rolling her eyes whenever he spoke, according to him. And the court said, listen, you're allowed to be emotional, but you need to control it. It's in your best interest to control any facial expressions. It's disrespectful. You know, I was a little surprised because generally I find that judges allow the defense attorney to control their defendant. What are your thoughts?
Yeah, it was a bit interesting, but there was nothing lost because it was out of the presence of the jury, right? So, you know, what do you think? It should have been the defense attorney to do it. The prosecution made this request, etc. You know, no harm done because the jury is dismissed. This happens out of the presence of the jury so that were it to become an issue again, maybe the judge will be a little bit harder, that'll be a little bit more difficult. So maybe it was a bit surprising that it happened one way as opposed to the other, but the fact that it happened out of the presence of the jury, and this is an opportunity, if the defense attorney is wise, to say, hey, listen, this is not something you can do. The judge doesn't like it. We don't want to be worse off for it, so let's straighten that up.
Yeah, good point. And I know when I was a trial attorney, I wouldn't necessarily know what my client representing the Child Welfare Agency was doing because I was focused on presenting the case. And so it may be a good awakening for the defense attorney. All right, Joe, thank you. We want to go back into court together now. The jury has returned from their break and a new witness is on the stand. This is a detective with the Miami-Dade Sheriff's Office.
When we are assigned a homicide investigation, there's always going to be one detective that's the lead investigator. And because the multitude of the cases and the amount of work that needs to be done in a homicide investigation to be thorough, the whole team will assist and handle different leads that are assigned by the lead investigator.
Now, you said that the lead investigator in this case was Detective Cruz, correct?
Yes.
Now, are you making decisions on your own, or is he giving you assignments?
No, all decisions are made by Detective Cruz. Prior to me making any decision, I would advise Detective Cruz what I came across, what I have, and at that point he will guide me in what he would want me to do.
So it's fair to say that everything you learned, Detective Danny Morales, Detective Suyapa Hubbard, everything that they learned is flowing to Detective Cruz?
Yes.
So that he can make a decision on what to do?
Yes.
Now, did you speak to Detective Cruz on scene?
Yes, I did.
Were you given a brief on the investigation and facts as he had them on scene?
Yes.
Did he make any requests of you?
He requested that I respond with him to headquarters to interview Miss Daisy Link.
Okay. Did you respond to headquarters that day?
Yes, I did.
And was that to potentially interview the defendant?
Yes.
Okay. Now, at the point in time that the defendant was transported to headquarters, was she a subject of the investigation?
No.
Why not?
She was merely a very important witness. She was also the wife of our victim, which is very important for us because we believe she would have very relevant information as to what the victim was doing prior to him being shot, if he had any enemies or anything of that sort.
Okay. Did you believe it was a good idea to bring her in?
Yes.
Now, when you first got to headquarters, is that where she was brought in for an interview? Is that recorded in any way?
Yes, it's a video and audio recorded.
Okay. And everything that happens in that room is going to be captured, more or less?
Yes.
Now, when you first interacted with the defendant in the interview room, did you contact anyone to assist you?
Yes, I contacted our Crime Scene and Evidence Bureau so they can have an investigator respond.
Why did you do that?
To take pictures, and also she had clothes that was full of blood. I didn't want her sitting in the interview room for a long period of time in clothes that had blood that was potentially her husband's. So I wanted to make sure I could get her to change and photograph her before that.
Can you explain what the defendant's demeanor was like when you were first interacting with her at headquarters?
She's very defensive during that interaction.
Did she say anything to you?
She said, and not exact quoting, but something along the lines of...
Objection, speculation, if she doesn't remember.
Just the words she said, okay? So the objection is overruled. Why was I treating her as a person that shot the victim?
Okay. In your mind, were you treating her as the person who shot the victim?
No, I simply wanted her to get out of bloody clothing that she had on.
Did you attempt to give her clothing?
I did.
When you attempted to give her those clothing, what was her reaction?
Overruled. Go ahead.
Did you offer her anything to eat or drink at that point in time?
I did multiple times.
Did she accept?
No.
Showing defense counsel has been pre-marked for identification purposes. Permission to move into evidence, Your Honor. Absent objection.
Today, Exhibit 2C, marked for identification, now becomes today Exhibit 25, Judge.
While at headquarters, other than interviewing Ms. Link or attempting to interview Ms. Link, did you do anything else? Thank you.
Yes, I did. I documented a body search warrant.
What is a body search warrant?
A body search warrant is a warrant to gather DNA, clothing, and this particular incident was for the DNA and the clothing.
Okay. What DNA and what clothing?
It was going to be for Miss Link's DNA and for her clothing.
Okay, we briefly talked about this yesterday, but can you explain to us what the process is of obtaining a warrant?
Yes, so us as detectives, we document a statement of facts, which is the facts that are known to us at the time of us writing that search warrant. Once we type that, we submit it to our supervisor who reviews it. Once our supervisor is done reviewing it, we will submit it to a state attorney. The state attorney determines whether or not we have enough probable cause to move forward with that warrant. Once they determine that we do, we submit that warrant to a judge who gives a final approval on it.
Okay. And was a warrant for Ms. Link's DNA approved in this case?
Yes.
Was that executed as well?
Yes, it was.
Okay.
Thank you to Joe Richardson for joining us. Up next, more of the toxic relationship murder trial of Daisy Link. Don't go anywhere, so we'll be right back on Court TV Live. Welcome back to Court TV Live. I'm Judge Ashley Wilcott, of course, honored to be here with you. We are tracking several trials today here at Court TV. In Florida, a judge decided to uphold the jury's recommended sentence for Jose Soto Escalera to death for the murders of his mistress and their unborn child. Also in Florida, it is day 3 of the toxic relationship murder trial against Daisy Link. She is accused of shooting and killing her boyfriend, Pedro, although Link says that it was done in self-defense. We'll take you back there in just a moment. In Wisconsin, the state's case continues for Parise Leary Jr. This is the teen accused of killing a young woman who got caught in his gun's crossfire while she was taking out the trash. We'll bring you highlights from that trial throughout the day today. And in Ohio, the fate of Bionca Ellis will soon be in the hands of a jury. Right now, they are hearing from the state's rebuttal witness after the defense rested earlier today. Now, a reminder that due to a court order, we are unable to show you today's testimony until court has ended for the day. We'll let you know as soon as that happens. Of course, we'll also keep you updated on all the rest of these trials throughout the day. But for now, let's go back to the murder trial of Daisy Link, where a detective remains on direct examination by the state.
Now, at that point in time, after doing the body warrant, what, if anything, did you do next?
Fingerprinting.
Fingerprinting who?
Miss Link.
If Miss Link was not a subject at this point in time, why were you fingerprinting her?
Because we were made aware that she did touch the victim at that time when she found him. So we wanted to make sure we did have her fingerprints, and since we had to rule it out and use it for that case.
Okay. Was she under arrest at this point?
No.
Was she a subject at that point?
No.
Now, if she wasn't a subject, she wasn't under arrest, why are you fingerprinting her?
In case we found fingerprints that she mentioned about touching the subject, his property that was on him. So if we find fingerprints, we have to submit those fingerprints for testing in case it could have been someone else that touched the phone. So having her fingerprints will help us in ruling out, okay, these are Miss Link's fingerprints, and we know that these are her fingerprints because she did touch the victim at the time.
Now, to be clear, the defendant does not have to speak to you at any point, correct?
Correct.
When you were fingerprinting her, were you prompting her to speak to you?
No.
Did she ever speak to you while she was being fingerprinted?
She did.
What, if anything, did she say to you?
She said, I did not mean to kill him.
Okay. What did you say to her in response?
I advised her to please stop talking, that if she wanted to speak to me, we would have to go into the interview room, go over her rights, and at that point, we can determine whether or not she really wanted to speak to me. But I did tell her multiple times to not speak to me.
Can you explain to the jury what Miranda rights are?
Yes, it is a form that we use, and it explains the right to individuals that they have a right to they don't need to speak to us, whether they want an attorney present or not, and that pretty much a little summary of what Miranda rights are.
Okay. Judge, by stipulation of the parties, state moves into evidence which has been pre-marked for identification purposes is 2D.
All right, go ahead.
Today, Exhibit 2D, marked for identification, now becomes today Exhibit 26.
And permission to publish.
Yes.
Thank you. I'm using a demonstrative which is pre-marked for identification purposes as 1J. I know this is very far and the writing is small, so I'll read it. And if I could have that as well. 26? Thank you. So Detective, I'm going to put this in front of you real quick and use the same form here. The top of this, is this the Miranda form that you read to Ms. Link, or Ms. Link read?
Yes.
Okay, let's start at the top. Before you are asked any questions, you must understand the following rights. Let's start at number 1. You have the right to remain silent, and you do not have to talk to me if you do not wish to do so. You do not have to answer any of my questions. You understand that right? There's a yes, there's a no. What appears to be a D and L next to yes. Whose initials are those?
Miss Link's.
Okay, so she responded yes to that question?
Yes.
Number 2, should you talk to me, anything which you might say may be introduced as evidence in court against you, you understand that right. There's a yes, there's a no. Again, a DL on yes. Is that Ms. Link's initials?
Yes.
And she initialed yes?
Yes.
Number 3, if you want a lawyer to be present during questioning at this time or any time hereafter, you are entitled to have the lawyer present. Do you understand that right? Again, yes, no. Again, initials. Is that Ms. Link's initials?
Yes.
Ms. Link understood that right?
Yes.
Number 4, if you cannot afford to pay for a lawyer, one can be provided for you at no cost if you want one. Do you understand that right? Yes, no. Again, a DL. Ms. Link understood that right?
Yes.
Those are her initials?
Yes.
Knowing these rights, are you willing to answer my questions without having a lawyer present? Yes, no. Again, DL. Ms. Link's initials?
Yes.
Ms. Link understood that right?
Yes.
She agreed to speak to you?
Yes.
Did you threaten her in any way?
No.
This statement is signed of my own free will without any threats or promises having been made to me. There's a signature and a date and time. That date is 6/25/2022, and the date appears to be it's either 4 or 6:22 p.m. Is that correct?
4:22 p.m. Yes.
Okay, and whose signature is that?
Miss Link's.
And on the left-hand side of this, it says advising officer. Who was the advising officer?
That was me.
And can you tell us the rest of it? It says 6/25/22 with what appears to be 6567 above it?
That's my badge number.
And then right underneath it, there's a witness, J. Cruz.
Yes, that's Detective Joseph Cruz.
Thank you very much. I can take that. Now, I want to briefly talk about the defendant's statement. What, if anything, did she tell you? Just briefly.
She told me that her and the victim were involved in an argument.
Judge, I want to object best evidence rule. We're going to hear the statement.
This is a summary, correct? Yes, ma'am. Okay. And states that planning on introducing the statement?
Yes.
Go ahead.
Well, here, let me ask you this. Did she advise that she knew who the victim was?
Did she, at the time of the interview, did she advise that she knew who the victim was?
Yes.
Yes, she did.
Who did she say the victim was?
Her husband.
And that would be Pedro Jimenez?
Yes.
Did she advise of any domestic violence between her and Pedro Jimenez, in which Mr. Jimenez was the aggressor?
Yes.
Did she also advise of any domestic violence, prior domestic violence, where she was the aggressor?
Yes.
Did she also advise you of an incident that happened a few days prior?
Yes.
In which Mr. Jimenez, she claimed, pistol whipped her?
Yes.
Did she advise that she picked up Mr. Jimenez that day?
Yes.
What did she say about that?
That she responded to one of his friend's house because it was getting late to go pick him up.
Did she say if he threatened her at that point?
No.
Did she say that he had any weapons on her?
No.
Or him?
No.
And she said she went and picked him up on her own volition?
Yes.
Did she say whether or not he asked her to pick her up?
No.
Did she ever tell you about any conversations that they were having that night?
Yes.
And what was that conversation about?
Conversations about the victim making allegations that Miss Link cheated on him.
Did Miss Link deny that to the victim?
In the beginning, yes.
Okay. Did she advise a little later on about what continued to transpire that night?
Yes.
And what was that?
They continued to argue about the same situation until eventually Miss Link advised the victim that she did cheat on him.
And did Miss Link advise that the defendant had left at that period of time before she admitted to the infidelity?
Yes.
Did Miss Link advise if she had a firearm?
Yes.
And at what point in time did she say she had the firearm?
She was looking for the victim, didn't know where he was at. She grabbed the firearm from inside and then sat outside to smoke a cigarette.
And so the victim was nowhere to be found at that point in time?
No.
Did she say why she grabbed the firearm?
She believed that by grabbing the firearm, it would instill fear in him from confronting her.
Even though he wasn't around?
Yes.
Did she say if the victim showed up later on?
Yes.
And what happened there, did she say?
They continued to argue,
The victim at one point pushed her, which is when she grabbed the firearm. As soon as she grabbed the firearm, the victim began to run away from her. She said that he was running to lock her out of the house, and in order to stop him from locking her out of the house, she discharged the firearm.
Did she say that she was in fear for her children?
No.
Did she say she was in fear for her safety?
No.
Did she merely say that she didn't want to be locked outside?
Yes.
Did Ms. Lincoln advise what, if anything, happened to that firearm?
Judge, at this point, I'd ask best evidence rule. We could hear.
Sustained. We're beyond summary.
Did you ask Ms. Link to draw anything for you?
Yes.
And why'd you do that?
For me to better understand where she was when she discharged the firearm for purposes of attempting to locate a casing on scene.
Okay, state now moves into evidence which has been pre-marked for identification purposes as 1B. 2B, I'm sorry.
State Exhibit 2B, marked for identification, now becomes State Exhibit 27.
And that's our stipulation, right?
Yes, sir. And I also have a demonstrative of this. Detective, if you don't mind just taking this from me, I'm going to give you a couple of markers here. Truthfully, just use whichever one works a little better. Thank you. Or both. If you don't mind just holding that up for the jury. What exactly are we looking at here?
So here we're looking at the street, and these are two duplexes. This one in particular is a duplex where Ms. Link and the victim resided.
Okay. And this is the drawing that Ms. Link made?
Yes.
Okay. Can you just walk us through exactly what Ms. Link told you about this and mark where she was standing and where the victim would have been?
Yes. So she says she was sitting here on the porch where the staircase is. The gun was directly next to her. The victim was standing here in front of her.
And there is a circle at the top of it. What was that?
This is where she said the victim ran towards this way, and she shot the firearm when she was approximately by this circle.
Okay. And there's like a little line right next to that as well. What's that?
That's where the victim continued to run.
Okay. Did you find a casing ever?
I did not.
Do you know if anyone found a casing?
So the court is about to play for the jury a ring camera video, which we are unable to see or hear. So in the meantime, we will bring you body cam footage from the day of the shooting. Stay with us. We'll get that ready and be right back.
Tonight on Closing Arguments, the biggest moments from today's testimony in the Toddler Stabbed murder trial. We dive deeper as this case nears its dramatic finish.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
A wife accused of murdering her prominent attorney husband, and the defense involves blaming her own sons?
Victim to verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Detective, what did we hear Ms. Link say on video?
I mean, it's very grainy in this video. It's a lot more clear when I watched it, but it talks about hitting a major artery. It talks about Daisy Link saying, "You'll be fine," and then asking, "Are you sure you don't want to go to the hospital?"
I have nothing further, Your Honor.
Some of the last words from the defendant, Daisy Link, to her boyfriend just moments after she shot him in June of 2022. Now, Link claims that she shot, Pedro Jimenez in self-defense, arguing that the two were in a tumultuous relationship marred by abuse and domestic violence. But prosecutors say that Link was the aggressor, citing text messages and an alleged attack on Jimenez just days before his death. While court is on a break, let's take a look at some key evidence in the case. Now, this is body cam footage from the Homestead Police Department of an officer responding to the scene. We must warn you, the video is graphic.
5441 road. Don't move! Do not move! Units arrival at 327, all units correct.
We may be having a technical issue bringing that to you. Let's see if we're able to link back in. Again, this is a video of the body cam video.
214 on 327, all units correct. 47, myself, 5441 road.
Don't move! Do not move!
Units arrival at 327, all units correct.
Hey, what's going on, man? I see a hole from the back and a hole from the front. He was shot in the I took off his shirt. He's related to you? No, he's actually my husband.
Oh, okay.
Where is it at? Right here, right here. And you can see all this from the front. You can see the hole from the front.
Hey, just stay right there, boss.
Are you okay? Hello? Stay with me.
439.
It appears to be a GSW. It's going to be into the right leg, into the right thigh, and out the right thigh.
No,
hey, just
stay down,
there, boss.
stay down,
Hey, lay on your back, please. Hey, stay on your back.
Stay down. Stay down.
Go in my trunk, grab right there's my trauma kit. Grab me gauze and all that.
Pedro, what the happened?
Pedro.
Where's the ambulance?
They're coming, Mama. They're coming. Look at
there's a lot of blood there.
Open it up. I got my hands are dirty, bro. Grab me two. There's more.
Check and see if there's anything else.
We're gonna have to cut off this stuff.
Just cut it off. Do what you gotta do.
Just sit down, bro. My hands.
439 is fire arrival.
What's the best way for to come through?
Hey, are you okay? Pedro. Hey. Hello.
I don't see you. I'm in the alleyway.
Did you hit a major artery?
Somehow get you anything, all units correct.
Pedro. Hello. Pedro, stay with me. Hello. Look at me. Pedro. Hello. Look at me. Are you here? Are you with me?
Pedro. Hey, boss.
Oh my God.
Listen, Mama. Listen.
No.
He's all right. He's still. Pedro.
No. Hey.
Mama, I need you to relax. I need you to calm down. Give me a second.
No.
Pedro. Hey, put pressure on that. Edwards, put pressure.
Hey. Pedro. Where the is the ambulance?
They're coming. Hey, I need you to calm down, Mama. I need you to calm
Pedro.
down.
Where's the GSW at?
Right there in the top.
Pedro. Hey. No. Hey. Look at me, please.
439 ET.
Pedro, please. No. Pedro. Hey. Look at me, please.
Pedro,
I need you to get up. Pedro, please.
Shallow breathing at 330, all units correct.
Where the is the ambulance,
They're
please?
coming, ma'am. They're coming.
Hey, stay with me, please. Pedro, please. Pedro, please, stay with me. Oh, my God. No.
Don't.
447.
Hey! No!
Ma'am, I need you to back up, please. I need you to back up. Back up, please. Pedro. Still got pulse. I hear fire.
Yeah, fire's arrival.
Where are they?
It sounds like on 15th Street.
Is he okay? Is there a pulse? No! Pedro, please!
Ma'am, I need you to back up. Pedro.
Don't give up, buddy.
No, please, don't let him go, please! What the
Ma'am, I need you to back up.
447 was that fire over?
Please don't let him go, please!
Back up, please.
CPR.
Pedro.
447, I can't reach you.
Just tell them we were starting CPR.
Got a pulse?
CPR, Father.
Hey, did rescue see where we're at? I heard the truck.
We have an ETA on rescue.
No, I heard the truck.
The truck should be on that side.
Try to run up to them and guide them in here.
Pedro. Pedro. Come on, Pedro. Stay with me. Yeah, relax. There you go, Pedro. Come on.
Don't give up, Pedro. You got this, bro.
Come on, boy. Hey. Pedro.
454 for fire, they're showing arrival.
Pedro.
Please, I'm leaving it now. Kids on fire's arrival in the mail at 333.
Is he?
Pedro. Ma'am, I need you to back up, please.
You have a pulse?
Yes, relax. Back up.
I need you to relax. Look, come over here.
Pedro. Hey, boss. Need you to tell me what happened? Pedro.
Who did this to you, bro?
Come on, Pedro. Pedro. Hey.
Pedro, please!
Pedro.
Do you have a pulse, please?
Pedro.
No, does he have a pulse? Where the is rescue? Where the is rescue?
Hey, he's got a weak pulse. GSW to the right thigh. It looks like a through and through.
What? No, I didn't. Oh, my God. He left about 45 minutes ago. He left my house. I live down the street.
We're going to pause that there. We will be bringing you more of it, but I wanted to bring in our guest, National Trial Attorney Megan Whiteside. Megan, great to see you. I wanted to bring you in because at the very beginning of the body cam footage, the woman who's leaning over him, she seems very calm. She seems to be saying, oh, there's a shot. Here's where it is. She's talking to someone. And I even said, who is that? Oh, it's the defendant. And then the police get there, and then she gets pretty hysterical. It's hard for me to think about the person that we see at the beginning of that video is the same. We know she shot him. It's just, was it self-defense or not? It's hard for me to realize she's the same one who shot him, and she was fairly calm when it first started. Share your thoughts with me.
Your reaction was my exact reaction. The difference in demeanor, in tone, in the type of information and statements the defendant was making, is extremely disturbing and striking because of exactly what you said, the difference in demeanor. When officers responded, she was calm, she was methodical, she was discussing logistics, what she believed to be a through and through. If somebody had shot my husband and I was there waiting for emergency response, there's not any scenario I can imagine where I would be calm as they walked up. Even if you try to remain calm, I would imagine the normal response would be to be overcome with emotion. And the jurors who are watching this are not leaving their common sense at the door. And this, in conjunction with the defendant's behavior initially when speaking with officers, her inconsistent statements, and suddenly a self-defense, these things don't add up. The fact that she was so calm and methodical and only seemed to get upset when she believed that the victim was dying is extremely telling. That's the initial reaction I had to this footage, that you had to this footage, that I imagine the jurors had to this footage. And it's disturbing and really unhelpful to her defense.
Yeah, great information. Now, self-defense, we know that we're going to hear from her. The defense attorney has said she'll testify in this trial. So we'll have to wait and hear from her. But I must ask you this just really quickly. Did you believe her emotional upset? Did you find it credible that that was authentic or not? Just real quickly.
I think it was authentic and self-motivated. My impression was she realized, oh no, he may actually die, knowing she was the one who fired the bullet. And that emotion seemed to be directed at what she was now facing, was my reaction. I'll be curious if we'll get any insight from the jurors in this case with their verdict and if they speak after.
Oh, Megan, I agree with everything you've said. All right, stay tuned. You'll stay with us. Up next, we will have more of the body cam footage in the toxic relationship murder trial. Don't go anywhere. It's Court TV Live. Welcome back to Court TV Live. I'm Ashley Wilcott. It is day 3 of testimony in the toxic relationship murder trial for Daisy Link in Florida. The 30-year-old is accused of fatally shooting her partner, Pedro Jimenez, in the leg in June of 2022. But the defense says it was Jimenez, that he was unhinged and dangerous that day, and that Link had to shoot him in self-defense. Right now, we are getting you caught up on some key evidence in the case. We want to bring you more of that body cam video from an officer who responded to the scene. We must warn you, some of it is graphic.
I still gotta follow.
Where is it, Lee?
I can hear him.
Which way?
Twice. No, I didn't see him. He was walking. I saw him laying there.
There's a pretty large blood test. We got other units response.
Yeah, she found him here.
Like laying here like this?
Yeah. When I got here, this is where he was.
I got no pulse.
Edwards. I'm gonna follow it down.
Okay.
433, 423. 433, that's all. Both units arrival, 33, 16. 447. There is the alleyway that rises in the large military cavity area. 23 reference. Right, units are sorry, moving off the area just in case.
Yeah.
And we're gonna need to find out.
Back her up. Come on. What? Just have her back. Where's she live at? Let's start roping her off.
Just all units to start roping up the area. Right now, LZ. 23, I'll work on LZ. Have a unit trying to rope off the area. You got safe?
Yeah.
Unit attendants is roping out the area.
Hey, Chevy, pull my car back. Pull my car back. Pull it back. Pull it back in this open spot for now.
Open it?
Yes, I'll open it.
Go ahead.
I'll show you assisting in arrival at 336.
Hey, get it back to the opening, Chevy. Watch your feet. He's backing up. Go ahead, Chevy.
So show me this on the route. Northeast 12 mile right now.
Watch out, LT. He's coming back. Go ahead, Chevy, go.
We got a blood trail over here. Okay. 443, you know our 3.
423.
Hey, stop, Chef. Turn your wheel. All the way. You got the tree. Turn the wheel hard this way. This way? Yeah. Back it up.
You found 443.
Go ahead. Hey, pull forward. Right there.
All right, get the ropes.
Yeah.
Let's rope it off over here.
In my passenger seat.
I got blood in my pocket.
In my passenger seat. Right there above my headrest, bro. You hear me? Hey, kill my overheads in.
Alright, then I'm seeing it's gonna be a 45. Yes, all cars over, it's gonna be a 45 at 338. All units correct. And what are you looking for if you're right?
Yes, I'm arrival.
Alright, 38.
What? Right there above my headrest. Passenger side. Hey, I think he... Hey, we'll start here, I guess, roping this off. I am.
439.
I'm just roping off this whole area, Chef. Yeah, we're gonna probably have to go out to the road.
If we could.
We'll walk back that way. See.
Yeah, just do off.
We'll have to put a car on that end, LT. I am.
Do we have any basics?
No, I don't know nothing. She said he left out. He hadn't come home, so she went looking for him. She found him in the alleyway, and she seen that he had the in and out in the thigh, right thigh. I was at 17. I was at 17 and 14, and I heard like a pop, and I started driving this way. But I didn't hear, like it sounded more like a firework. So I started driving down 14, and then that's when they gave me the call. You got more this way?
And there you just heard him tell somebody else with law enforcement that Daisy Link said at the scene that she shot him in the alleyway. So again, it's not contested that she is the one who shot him. Was it self-defense or not? We'll have to see what the jury decides. We'll take a break. When we come back, we're going to get you back for more of the body cam video from the scene. Stay tuned.
You dream about moments like this. My goodness.
The fastest female track and field stars compete in a one-night-only event. Atlos NYC 2025, live from New York City. Tonight at 7, it's on Ion.
Tonight on Closing Arguments, the biggest moments from today's testimony in the Toddler Stabbed murder trial. We dive deeper as this case nears its dramatic finish.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Back to court in Florida in just a moment. But first, we have an update out of Wisconsin and the caught in crossfire murder trial. Parise Leary Jr. was just 14 when police say he and another teen shot and killed 20-year-old Tatiana Zek as she was taking out the garbage. 3 others were injured during that shooting. Now, today, the defense raised an issue about a conversation that a detective had in the hallway with a witness during this trial, potentially violating an order not to discuss the case outside of the courtroom. The judge called the detective to the stand to get her side of the story.
As to those discussions, did you at any time share any information with Mr. Stewart about any of the testimony that you have heard or that has been provided in these court proceedings?
Absolutely not.
Okay, as to that last statement that we were just talking about, where he said, well, you know, she said that would cause problems. How did that arise?
When Namarian initially began discussing Cam with me, he advised Cam was walking past him in the hallway. I had concerns that there were some intimidation things. That's where our conversation started about Cam. As he was advising who Cam was, he said he was in the hallway and he's part of Parise's gang. And I said, I don't think we can use the word gang to describe it, maybe group, because it might cause problems. And that was a conversation that we had with him during trial prep.
After hearing the details, the judge ruled that the sequestration order had not been violated. Of course, Court TV will continue to bring you updates throughout the day. Now let's go back to the toxic relationship murder trial of Daisy Link in Florida. Link is charged with second-degree murder in the shooting death of her partner, Pedro Jimenez. Link claims self-defense, saying she was in an abusive relationship and feared for her life. But prosecutors say no, Link, she was the aggressor. Right now in court, they're watching ring videos that we can't see or hear. So we are showing you body cam video of first responders trying to revive the victim. We must warn you, the video is graphic.
Yeah, we got blood there. LT, you walk. Hey, watch. Chevy, just don't step on it. Yeah.
27670.
Tachos on a 2004 grade 4 to Vida Lopez Perez, 2 gauge of 12.
We need to take this off. All this.
Looks like you got out of time.
Somebody must have been driving, bro. If he was in the passenger.
Walk off the street.
Hey, give me, hey, somebody got a car?
Hey, 323.
Grab the car. Ma'am, rescue's out with him, ma'am.
423. 423,
Disregard, I see a mark unit. We're gonna need,
Yeah, complete blockage of the street. Yeah. Yo. Yeah, it wasn't even that long ago, bro. I was at 17 and 14, and I heard a pop, so I started driving down, and then they gave me the call. Yo. What? Hey, bro, I'm gonna use your fence. Appreciate you. Everyone's crazy.
What's the TPH? They said they found a possible scene.
Verifying at 1289 Northwest 4th Street in the driveway.
2011 reference.
2011
According to the blood trail, he seems to be walking around in circles, so we're blocking off the entire street.
I'll do that for you. You need it more west, or is that fine? No, that's good there.
That's good. Yeah, I'm going to 3 for me.
11, keep on to 3.
Yes, sir.
Try to get his info.
Yeah.
Send a quick email.
Hey, Chevy.
Let's get some rope to get to. We need rope here, too.
He's got it.
The whole front of
Hey, Chevy, you got a whip it on? I don't know, ma'am. He's out with rescue. Give me a second. Hey, can you get her info and then his info from her?
Yeah.
Please.
Yeah, this rope's gonna have to come all the way through here.
We're just gonna rope. We roped off the whole road.
No, what I'm saying, because these houses right here.
Yeah, so we'll shut down the whole front of them.
Okay.
And then also in the back. Somebody else got tape? Is their car close?
My car's all the way across.
Yeah, rope off this backside for now till we figure out what we got.
I get more rope.
All right. In the alley, where he's at now. Huh? Possibly. I don't know. It's hard to tell. They're getting his info and her info. Hey, man. Why they keep asking? Yeah.
439.
Okay.
Have you been up to 433? You gonna check?
In the alleyway?
433, are you in the alleyway? Yes, sir. 39.
I'm coming to her. She didn't, fire didn't give us a... Okay. All right, then.
He came out of this car.
Okay.
There's blood on the driver's seat. Like if she was sitting on it.
Yo.
More blood right here, bro.
There's
blood everywhere, bro. We're gonna block off this whole, alleyway, bro.
Yeah, there's a big puddle right there.
Yeah, he's been all over, bro.
Look. Let's see if we can do a call off for day shift and see if we can get some units to come in early.
Still with us, National Trial Attorney Megan Whiteside. Megan, I don't know if you remember when body cam video first became available, became a thing, a lot of people argued against it and said it's going to interfere with their policing and justice. I love it because it shows us everything. It's better than a description. But tell me your thoughts as you're watching this unfold.
It is like pieces to a puzzle that are all starting to come into view, and obviously now with the benefit of hindsight and we understand the investigation uncovered a whole lot more, but it is fascinating. I agree to watch the officers in real time observing blood trails and trying to piece together what happened, and we get glimpses of the defendant again very calm. We just talked about this, how she was calm and then she was very animated and distraught, and now she's calm again. And I think, like you said, it is so much better than a description to watch this like a movie. It's extremely compelling, extremely powerful, and very harmful to the defendant's self-defense.
And I can't wait to hear her testify because there's so many different pieces, parts of her, what we've already talked about in the video, and then we know she had to be admonished by the court when the jury wasn't in the courtroom for rolling her eyes whenever the prosecutor was speaking and controlling her facial expressions. We know from law enforcement on the stand that, hey, when she asked her to put different clothes on so that she could take the clothes with the blood, she was like, nope, I'm not doing it. I'm not putting those blank clothes on. So combative, seemingly angry. The other thing I have to say, though, is you're right. She seems calm. But on parts of that video, you can hear her screaming in the background. I don't know if that's because, to your point earlier, she realizes, uh-oh, he's dead or he's dying. He's not dead when we see him in that video, so maybe she thinks that. Those little screams and acting out are going to be noticed by the jury.
I agree. I think that they are going to examine her demeanor with a fine examination. And that's going to be not only from the body cam footage and the audio, the ring footage. This is going to be from her statements and how she treats everyone she encounters with, whether it's police, neighbors, the behavior in the days and weeks leading up to this that is relevant to her defense. And what is very striking, and I think that the jurors will pick up on, is the inconsistencies in her demeanor, her behavior, her statements, right? Between different officers, she made different statements. Her kindness and respect to different people, it varies widely moment to moment. And I don't think that's going to sit well with a jury, again, who doesn't leave their common sense at the door. If she was, in fact, abused in a relationship, or this toxic relationship made her fear for her life, you would expect a very different behaving individual.
Yeah, it's going to be an interesting one as it continues to unfold. Thank you so much, of course, for joining us today. Coming up next, Michael Ayala joining for more of the body cam video and the toxic relationship murder trial.
There's no obligation. 1-800-422-7955. Call now.
Daisy Link cringes at the sights and sounds from a sergeant's body-worn camera captured during the wee hours of June 25, 2022, when Homestead police responded to a call about a man bleeding out. The state says Link made that call herself moments after she fired the single shot that killed Pedro Jimenez, her on and off partner and father to 2 of her children.
Welcome back to Court TV Live. I'm Ashley Wilcott.
And I'm Michael Ayala. We're both here today giving you your front row seat to justice. And a Florida woman is standing trial this afternoon on charges that she murdered her boyfriend, but she says she was acting in self-defense.
Daisy Link is charged with second-degree murder for allegedly shooting and killing her on-again, off-again partner, Pedro Jimenez, on June 25th of 2022.
Prosecutors believe that Link was the aggressor in the relationship, but her defense claims that she had been trying to leave Jimenez because he was, quote, out of control, unhinged, and dangerous.
Right now, the court is watching the defendant's police interview, but we are unable to hear that. So we are bringing you body cam footage from the night of the shooting. Let's go back to that to see more.
We have it here.
Bro, he's been all over. I'm sure if we go back a little bit more. Just doesn't make sense, bro. Yeah, we're just gonna shut the whole alleyway down.
I'll get it all the way.
Yeah, somebody, who's this?
That's me, but how do you want to block out these people that want to come out to the back?
No, they ain't coming out.
QSL, is there anybody on this that we can clear? I believe we should have maybe 5 to hold the scene.
They ain't coming out. It is what it is. It's a homicide investigation.
No, I understand. It's that they're going to come up with a back little car that's walking.
No.
43, give me a
You're
second.
going to have someone in the alleyway.
No, just put the tape on their stuff. They just use their tape. Hey, they didn't give you a blanket for this guy? Fire didn't leave a blanket?
Right. They have to.
Let me see if I got one in my car.
You can show me a knife and I'll be in route.
Charting route 157 North 8th Street, reference to 4 males that were previously arrested. No weapons.
347. Apparently he just walked around the house.
Bro, he didn't just walk around the house, bro. He walked all over there.
Yeah, there's blood all around the car.
Bro, there's blood everywhere.
In the truck, though.
There's blood in the SUV.
Oh, there's an SUV over there?
Yeah. Hey! Kern! Is rescue out there? Is rescue out there? Can you get their info?
She's been walking back and forth for the last several hours. At one point, she said last time she saw him was like 45 minutes ago, he was walking in circles all over the street. She said earlier today he left in a white van. I know make a mom, I don't know if it's a passenger van or a work van. She said it was a white van with a couple of his friends. When he got back, he seemed agitated. That's when he started walking around in circles, walking all over the place. And then she didn't see him for about 45 minutes, so she started driving around. That's when she found him back.
That's all his info there?
Yeah.
You know, Judge, it's interesting because I'm very sensitive to domestic violence claims. It's clear that there was some domestic violence in this relationship.
Yeah.
But seeing this video, it's having a little bit of a different effect in terms of what happened that night anyway. What do you think?
Well, there's not a lot on that video that does make me think or believe it's domestic violence other than her own words. And part of my concern for her defense is her behavior when they first get there and she's kind of leaning over him, and then as it progresses and she gets exceedingly emotional, makes me question if it was really self-defense. I think if it was self-defense, she wouldn't be that calm. She'd be freaking out a little bit.
Yeah, there's a calmness there. There's an approach to the situation by the defendant that belies that claim that she was, you know, in fear for her life. But there's another part of me that says, you know, again, we talk about this many times, you know, judging people on how they respond to tragedy or how they respond to threats is difficult, you know, when you talk about someone's liberty being taken away. So there's more we need to see. But this certainly raises questions.
And you're right. You can't tell what you would do in a situation, what they are doing in a situation. You're absolutely right. I think we now have defense attorney, former prosecutor Bob Bionca to help break all this down. Bob, tell us, I mean, body cam video, best evidence, right, of the scene, of her demeanor. And I think her demeanor is going to be a huge part of this case for the jury.
Gosh, I was hoping you weren't going to ask me an open-ended question because I was unable to listen to that while we were trying to get ourselves hooked up with the technology problems. But in general speaking, Judge, body cam, like I always go back today and think about, gosh, I wish I had this 30 years ago when I was trying murder cases and we had no DNA capabilities and no phones and no body cams. Yeah, the demeanor is so important because a picture is worth 1,000 words. And let's be honest, I mean, when I look back on it today, 30 years later, there was a lot of creativeness in terms of how people testified when they would testify about somebody's demeanor and how they were acting. I myself, as the prosecutor, when we would investigate a homicide case, I'd be listening to someone telling me how the demeanor of a person was. But then when you saw it on video, I had a different opinion than the person who was interpreting it for me. So I think that these things are just tremendous insights for the jury not to have to listen to how someone else viewed how the person reacted, but literally to see it themselves. So I hope that answers your question. I think it's very powerful.
Yeah, it's a great answer to the question. And just in general, were there any caveats that you would have in looking at someone's reaction to a situation or the way they responded to what they claim is a threat? For instance, some people respond to threats by getting angry and sort of they turn on, and that could, you know, have to do with how they were raised, situations they were in. So I'm always a little loath to sort of put my own interpretations on what I see as to how someone responds to any given situation.
I think it's a great point, Michael. I really think that is a deeply profound and mature way of seeing it, at least certainly with myself. I'm never ashamed of any case I prosecuted ever. And I believe that every single person that I prosecuted was guilty of the offense. It was very important to me to have that solid sensibility, despite how difficult the evidence may be. But I have learned as I've gotten older to be careful to supplant my feeling about how a person should react or would react, as opposed to how other people who have different life's experiences, grew up in a different way, different race perhaps, different socioeconomic background, different mental health history, different education level, so on and so forth than the other. We are all very unique. So I am use the word loathe, very careful, much more circumspect now that I don't jump to a conclusion to say, well, I wouldn't have responded that way. Just like when I first started out, if I may use an example, who would ever confess to a crime they didn't commit? Well, the fact is, it happens, and it happens with a greater degree of frequency than we would care to believe or admit.
That's true. Yeah. For me, just speaking of myself, gentlemen, with age comes wisdom, that I'm now able to have that perspective, because I did not have that younger either. I would say this is what they thought, or, you know, whatever it was. Okay, let's do this, Bob. We want to show a little bit more. This is of some of the bloody items. Let's take a look at this together.
Where was there also blood-stained money when you photographed in the alleyway? Where was also money?
There was also a blood-stained bill on the alleyway, pretty close to where the victim was located.
And were these the items that were located in the driver's side of the vehicle detector?
Excuse me. Yes, those are the items.
And this credit card, whose name is on it?
The victim, Pedro Jimenez Gonzalez.
All right, if we're looking at self-defense, domestic violence claims by the defendant, and you hear that there was a blood-stained bill, a blood-stained credit card belonging to the victim, does that give you enough to start painting any kind of picture in your mind, evidence-wise, or not really?
Not really, at least taken alone, right? It's like, in other words, I guess like I best put it is, it's not a smoking gun piece of evidence, but it is a piece of evidence, and like prosecutors would typically be doing when you're trying to develop this history is put lots of pieces and lots of dots and then ask the jury to circumstantially infer what those things mean. So it's very, I think that we also jump a lot of times on a particular piece of evidence and say it means this, or it's the and what are those TV shows? I don't even watch them with all the letters. That is the killer piece of evidence there. It's very unusual that happens at a trial.
Good point.
All right, Bob, stand by. We're going to take a break here, folks. Coming up, we're going to hear unaired testimony from a detective who describes Link's behavior at the scene. So stay with us. We'll be right back right after this show.
Tonight on Closing Arguments, the biggest moments from today's testimony in the Toddler Stabbed murder trial. We dive deeper as this case nears its dramatic finish.
Closing Arguments, tonight at 8/7 Central, only on Court TV. Next week.
We're digging deeper into the biggest cases across the country. Join us for all the latest developments with what's trending in true crime.
Opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
Pedro, what the happened?
Pedro.
Where's the ambulance?
They're coming, Mama. They're coming.
Hey, no, hey, look at me, please.
439 please.
No, Pedro, hey, look at me, please. Pedro, I need you to get up. Pedro, please.
Shallow breathing at 330.
Tragic situation, but was it self-defense or murder? That's the question in the toxic relationship murder trial of defendant Daisy Link.
The prosecutors say the Florida woman murdered her boyfriend, Pedro Jimenez, but Link says she was acting in self-defense.
Now, before we get you back, we bring back in our guest, I want to listen back to some unaired testimony from yesterday where responding officer Danny Morales, he testifies about Link's behavior caught on a Ring camera just moments after that fatal shooting.
Going back to when you arrived on scene, when you first arrived on scene, there were police officers there?
Homestead police officers.
Okay. And Daisy Link was on scene. Is that correct?
That's correct.
Where exactly was she on scene, if you remember?
So directly in front of 1237 Northwest 14th Street.
Right in her residence?
The residence, yes. Right in front of the door.
Did you approach her?
I did.
How was her demeanor when you approached?
So originally she's sitting down, so from a distance you just see a woman sitting down, but once I came up to her, it's when she became a little aggressive, in my opinion.
Okay. Were you concerned with her presence on scene?
100%, yes.
Why?
It's not normal to have somebody sitting in the middle of a crime scene. Regardless, this crime scene was a little larger than normal, and she was sitting right in the middle of it.
When you first approached her, was she a person of interest?
At that point, no. I had just gotten there. All I knew was that she had a relationship with the victim, and that's from what Officer Nicholson told me.
Did you attempt to remove her from the scene so that way you can do your police work?
Yes, I did.
Okay, and what did that entail?
So, interacting with her and trying to verify her information, and I like to respect the person I'm speaking to, so I asked her her name and whatnot. That's when she became a little aggressive, ultimately trying to,
So before we get to that, tell me exactly what you mean by she was being aggressive.
It was more of her demeanor, just lack of wanting to cooperate, lack of wanting...
Improper comments and speculation on part of this witness.
To be clear, though, she does not have to cooperate with you.
She does not, no.
Now, moving forward, what, if anything, happened with Miss Link between you and her?
So Miss Link, when I went to detain her and put handcuffs on her, attempted to grab a white chair that was next to me, or next to her, and tried to swing it. That time I was able to detain her, and with the help of Homestead police officer that came and helped me as well.
When you were detaining her, what did you specifically do?
I put handcuffs on her, held her arms as any other arrest would take place.
Why were you detaining her at that point?
At that point, one, she's in the middle of the crime scene. Two, she became a person of interest, and we wanted to just remove that person from the crime scene. That way there's no evidence that was tampered with. That way she would be monitored inside of a police vehicle, and we can transport her to our headquarters for an interview.
Let's talk about if you contacted anybody other than the other homicide detectives. Did you speak to anybody?
Yeah, so there was 2 children at the residence. I learned that their grandmother was local. I contacted the grandmother to have them come get picked up.
And did she respond to the scene?
She did, yes.
Was anybody else with her?
Crystal Barreto, which ends up being, I believe, if I'm not mistaken, Daisy Link's sister, which was the daughter of the grandmother.
Okay. Now, when they responded to the scene, both the defendant's grandmother, Josephina Perez, as well as Crystal Barreto, did you approach them?
Yeah, so they weren't allowed to the immediate scene. Obviously, it's cordoned off by crime scene tape, so I walked to them at the intersection, and at that point, that's when I kind of informed them of everything that was going on.
And what was either of their reaction when you informed them what was going on?
So Crystal Barreto immediately, spontaneously stated the words, "If he is dead, Daisy must have shot him."
When you approached Crystal Barreto and you identified yourself and what you were there for, did she do anything in response?
She made a statement to me.
Okay, did you prompt her for a statement?
No, it was a spontaneous statement.
And what was that statement?
If he is dead, Daisy must have shot him.
And he being the victim in this case?
Correct.
Okay. Now, at this point in time that Crystal and her mother and you were on scene, had you identified any shooters?
No, at that point, no.
Did you have any subjects?
No.
So this was essentially the first information that you're getting that there was somebody who may be a person of interest.
Yeah, at that point, it kind of built a storyline for me.
Okay.
I'm sorry, at that point,
It kind of built like a storyline for me.
it built like a...
Storyline?
Thank you.
Now, again, Ms. Barreto, her mother, even the defendant don't have to cooperate with you, right?
That's correct.
Did you seek to obtain any additional information from Ms. Barreto?
Yeah, I attempted to speak to her and figure out what her relationship was and what information she may have to provide us. And at that point, she didn't.
Objection, there's no question pending on that topic.
So the answer is yes, you tried to obtain information, and now Mr. Bermuda is going to ask another question.
Did she provide any information?
She did not provide any information.
Did she refuse to provide information?
Yes.
What was her demeanor when you were trying to obtain this information?
Just a normal conversation, but they didn't want to provide information.
Now, let's back up. I know you mentioned how homicide works a little bit, but can you explain how homicide teams themselves works in your unit?
Okay, so there's essentially 8 homicide teams, 4 in the day shift, 4 in the afternoon shift. Each team has a supervisor, and under that supervisor, normally 4 to 5 detectives within that team.
And when there is a homicide, is there a lead appointed, or you guys kind of just do your own thing?
No, so there's a rotation of teams, and then within your team, there's also a rotation of who gets cases, so that way the same detective doesn't get multiple cases back to back.
Were you the lead on this case?
I was not the lead.
Who was?
Detective Joseph Cruz.
Now, when leads are appointed, are you relaying all the information that you learned to the lead?
Yes, we provide any information that we learn to the lead detective.
Are you also given assignments by the lead?
Yes.
Now, what if any assignments did Detective Cruz give you?
I was given the task of authoring a search warrant for the residence.
And the residence being that 1237 address that you mentioned earlier?
Yes.
Okay. Now, let's talk about warrants for a second. What actually is a search warrant?
So, essentially, it's a document that is requesting to go and receive, obtain property from a location or a vehicle, even a device that is reviewed by myself, a supervisor, an attorney, ultimately the judge either granting it or denying it, and allowing us to enter that structure.
Now, I know you kind of mentioned the process in which, whether no judge grants it or not, but I want to back up even further. Is this something that you just write up and then walk into a house, or is there actually a process for that?
No, it's a very lengthy process.
Okay, and you mentioned an attorney. What attorney has to review a search warrant?
The state attorney, whoever's on call for that week.
Okay, and a judge also has to review that?
Correct.
And they have the choice whether or not they can grant it or not?
Correct.
Was a search warrant granted in this case?
Yes.
And that search warrant was for that residence?
Yes.
Was that warrant executed?
Yes.
Okay. What, if anything, did you, well, let me ask you this. Did you execute that warrant?
I was part of the team that executed it, yes.
And what does it mean when you execute it?
So essentially, documentation of that location that we have a warrant for, searching that residence for any items of evidentiary value. That's the gist of it, yeah.
Did you walk into that residence?
Yes.
What, if anything, did you see there?
So the house is, there's obviously children items in there, female items in there, and adult male clothing and shoes.
Was that the only warrant that was executed in this case?
No, there was other warrants.
Can you tell us what other warrants?
I had authored a vehicle warrant for a Chevy Trax, and also a cellular device that I obtained from Miss Link when I detained her.
Let's talk about that cell phone warrant, and we'll go to the Chevy Trax warrant in a moment, but that cell phone belonged to the defendant?
It belonged to the defendant, yes.
And do you know what number was associated with that cell phone?
So, I know it's. I can't remember the last four. I'm sorry.
If your report will refresh your recollection, please refer to your report.
The cell phone number's not on here.
Okay. I'll move on then.
Okay.
Was that warrant executed?
Yes, it was.
And why did you obtain a search warrant for the defendant's cell phone?
So when we were doing the residential search warrant, there was Ring camera, so we believe that there was a Ring camera app on the cell phone.
In real time, the jury is actually watching the defendant's police interviews, so we will get to take you back inside of that courtroom once testimony resumes. But coming up next, Donna Adelson is due back in court on Monday, where she'll be sentenced for the death of her ex-son-in-law, Dan Markell. We'll have a recap of Donna's murder trial after the break, so stay tuned. could be right for you.
We, the jury, find as follows as to count 1 of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself. Count 2. We, the jury, find as follows as to count 2 of the indictment, conspiracy to commit first-degree murder. The defendant is guilty of conspiracy to commit first-degree murder. Count 3. We, the jury, find as follows as to count 3 of the indictment, solicitation to commit first-degree murder. The defendant is guilty of solicitation to commit first-degree murder. And it is signed and dated by the foreperson.
Michael, let's turn our attention now, shall we, to Tallahassee, Florida, where convicted killer Donna Adelson is expected to be sentenced next week.
The matriarch mastermind returns to the Leon County Courthouse on Monday. She faces a mandatory life sentence for first-degree murder, conspiracy to commit murder, and solicitation, all in the death of Dan Markell, her former son-in-law.
Markell was shot just outside his home back in 2014. I can't believe it's been that long, more than 10 years ago. The Florida State University law professor and father of 2 young boys would have turned 53 years old yesterday.
Let's take a look back now at some of the biggest moments from Donna's murder trial.
Who in Dan Markell's life would hate him enough to hire a professional killer?
They put her at the top of this pyramid behind Danny being killed.
Did you say my parents have more reason to dislike Danny than almost anyone else?
At that point, I was sitting with law enforcement for 6 hours and had just been told that Danny had been shot.
She called him a lot of bad names.
Yes.
She said ugly things about him.
Yes.
But not one single time did she ever suggest that Danny deserved to be harmed, did she?
Never.
She had said, you know, I don't know and I don't care, it doesn't concern me.
Was that out of character for her to not be curious?
Yeah, I mean, it was an unsolved murder of my former brother-in-law.
She's the matriarch. She's the matriarch mastermind. They don't have evidence of that.
Did we have it right? Were you the middleman between the shooter and Charlie Adelson?
Yes, ma'am.
He did tell you that his mother washed the money.
Yes, ma'am.
We took an undercover agent.
Excuse me, Mrs. Adelson? How you doing? Just want to give you this.
And who is the first person that the defendant calls?
Charlie Adelson.
As it relates to your right to remain silent and your right to testify, what is your decision?
This time I don't want to testify.
The undercover approaches Donna and hands her a piece of paper. When Charlie asked Donna, does it involve me or other people? Well, probably both of us.
She called Danny a major. She called him a royal, a piece of. You call somebody some bad names and that means you wanted him dead?
Catherine McBanoa admits she was in a plot to kill Dan Markell, and she got 44 checks and they were all signed by this woman.
They cannot prove she had him killed. At the time that he was killed, she had paid anybody or asked anybody to do it.
We, the jury, find the defendant is guilty of first-degree murder. Mrs. Adelson, control yourself.
Still with us, defense attorney, former prosecutor Bob Bionca. You know, Bob, I wonder if she lays awake at night and thinks, what if I had testified? If I had testified, would I have gotten an acquittal or, in the alternative, a mistrial for a hung jury? What do you think? Could that have made a significant difference?
Gosh, Judge, I mean, I can't imagine after the ultimately worst thing that could happen to you, a conviction, is that at the most monumental and pivotal part of a trial, one of the most, maybe the most, is a decision of a defendant to take the stand or not take the stand. And given the fact that she lost completely, of course she's going to visit in her mind, if I had gotten up there, maybe the result would have been different. Now, of course, the traditional model of lawyering, defense lawyering, is you never really want your client up on the stand unless you absolutely have to, and less times if it's a circumstantial evidence case like this one was. So I don't think that the advice, if the lawyer gave it not to take the stand, would have been bad advice, but certainly there's going to be second guessing because it couldn't have gotten any worse, right?
Yeah. That's the truth.
That's how I see it. I mean, I felt like there were things she needed to explain.
I did
You know
too.
what I mean? Because I didn't think there was a tremendous amount of evidence, Bob, that she was actually involved in the planning of it, et cetera, et cetera. But I think it was clear she certainly knew. My problem was when. When did she know? And that whole thing with the bump, I think, was key. And she needed to explain her response to that. Again, I don't know if it was a good one, but I think she needed to explain it. Do you think they're done with the Adelson family at this point?
I mean, for our sake, I wish they would be done, but no, I don't think that they are. And I think we know where you know, this is headed. And I feel like this case, like you said, Judge, just like it keeps going, you know, on and on and on. And Michael, I just want to get back to a point you raised, because I think it's so important. This prosecution of the mother was unsettling to me. I agree. I would have liked to have heard what she had to say, because I personally, I know it's going to be controversial, did not think that this was the strongest case. There was a feel to it based on my experience that sometimes we're putting a square peg in a round hole here. We were just talking about this earlier in the previous segment. We need to be careful at how we're interpreting how people say things in the context of these kind of relationships. But no, I think we're going to hear more. And by the way, may I add, from a prosecutorial standpoint, the methodical nature of how prosecutors went about this is impressive. I just hope that they got it right.
Yeah, and will they go after Wendy? I think they probably will, but that's what I know you were alluding to.
I clearly think she knew, right? The question is when, the question is how involved, and what kind of evidence can they present against her.
And I just don't see them letting go if they think they have the evidence.
I agree.
I don't think they will. All right, when we come back, we're going to switch gears and take you to the Toddler Stabbed murder trial of Bionca Ellis. She's pleading not guilty by reason of insanity, and coming up, hear what the forensic psychologist who examined Ellis has to say about the defendant's mental state.
Tonight on Closing Arguments, the biggest moments from today's testimony in the Toddler Stabbed murder trial. We dive deeper as this case nears its dramatic finish.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
A wife accused of murdering her prominent attorney husband, and the defense involves blaming her own sons?
Victim to verdict with Ted Rollins. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Turning our attention now to Ohio, where it is day 5 of the Toddler Stabbed murder trial against defendant Bionca Ellis.
She is accused of fatally stabbing 3-year-old Julian Wood and injuring his mother, Margot, at a grocery store in June of last year.
Surveillance video moments before the stabbing shows Ellis passing the Wood family inside the store before turning around and following them outside.
The defense claims that Ellis suffers from schizophrenia and that she was insane at the time. Now, she is facing life behind bars if she's convicted.
Now, yesterday, jurors heard testimony from the medical examiner, Dr. Elizabeth Mooney. She testified about her autopsy on Julian and talked about the 2 primary stab wounds that eventually killed the little boy.
The first injury that I note is a stab wound to the left side of the decedent's face. And this is depicted here in the photograph. Here, as you can see on the right side, that margin or edge looks more kind of squared off, and the left side is more pointed. So I can tell it's a single edge instrument that was used to inflict the injury. After taking these photographs, we do look internally to see what is damaged. So with the instance of the stab wound to the cheek, it did go through the mandible, the bone of the jaw on that left side. After it passed through the bone of the jaw, it transected a branch of the carotid artery. So there's the artery that you can feel your pulse. It's quite a large artery. It splits into 2 portions, and one of those portions was severed. The stab wound continued to go back behind the airway and behind kind of the oral cavity and downward, and nicked the right side of the cervical vertebrae, or the neck spinal column. It didn't hurt the spinal cord, but there was a lot of bleeding in the airway and throughout that wound path. This is the second injury and other stab wound that I documented. So he has a stab wound to the upper left side of his back. This injury passes behind the scapula, but into the chest cavity. It goes through the 3rd and 4th rib in the back on the left side, and then it punctures the left lung. So it extends deep enough that it goes through the large artery that's giving blood to the lung. And so there was quite a bit of blood that will then go into the chest cavity. So in addition to inhaling blood and not being able to breathe that way, there's blood that fills up that chest cavity. I always kind of describe it as trying to blow up a balloon underwater. There's just too much tension on that, and it collapses the lung, so there's not a way to breathe. This is a photograph of the left lung once I removed it. So this is the wound that goes through the lung itself and into that artery.
And with regards to State's Exhibit 111, what is the depth of that incision?
Both of the stab wounds, the one to the cheek and to the back, are both 4 inches deep.
What is that cause of death?
Stab wounds of the face and back.
What is the manner of death?
Homicide.
Yesterday, jurors also heard from a forensic psychiatrist. Now, she is Dr. Megan Testa. She was ordered by the court to talk to Ellis as part of a 20-day competency evaluation, and she was called by the defense. Let's watch as she describes her results.
My occasion to see Miss Ellis was a part of my work at North Coast Behavioral. I was assigned to evaluate her case when she was admitted for a 20-day competency evaluation. She was admitted in August of 2024, and that's when I first evaluated her. When I saw her in September, in August, for the September report, she did have a response. Her response, in part, was bizarre. She asked me about Jesus Christ and where he was crucified, and she made some other bizarre statements about Matthew and Jesus and taxes. I did repeat to her, explaining the purpose of my evaluation, and explained non-confidentiality and asked her if she was willing to proceed with the interview, and she did shake her head yes, that she had understanding and agreed to proceed. There are records from a community mental health center. It's called Murtis Taylor. They specialize in treatment of severe and persistent mental illness. She has been a client with them since November of 2014. And typically, individuals with mental illness don't necessarily get treatment when they first develop symptoms. Sometimes it takes a minute. So I would I would say definitely she had that illness in November 2014, but probably before.
So she's been diagnosed with schizophrenia and schizoaffective disorder in multiple hospital settings?
That's correct. Those records show that she was hospitalized in November of 2015. At that time, she was taken to the emergency department at Lutheran Hospital. Her mother had taken her there because she was not taking medications at the time. She had not slept for 5 days. She was hearing voices. She was expressing suicidal thoughts. She was experiencing these voices raping her and wanting to impregnate her. She thought there was a prophet involved. She had been taken to the Fairview Emergency Department. She had called 911 at that time. She stated that she didn't feel safe. She had been out of medications for about a month. She was unable to obtain refills in the community. She was seeing visions of people coming out of her walls to try to kill her at night. She was talking about Albert Einstein and a bowl of ants. She had been able to sleep. This record stated that she was visibly hallucinating at that time. They admitted her to Marymount Hospital, and she required an 11-day hospitalization and was stabilized on antipsychotic medication at that time.
She still carries an active diagnosis of schizophrenia?
Yes, schizophrenia is a brain disorder. So once you have it, it's a lifelong brain disorder. It does not go away. It's chronic illness.
Without medication, would her symptoms likely return?
Absolutely. I mean, we know it for most people, that's true. But we know it as a fact for Miss Ellis because we have her records. It's very clear from her records when she stops medication or when she runs out, her symptoms return.
Did you have the occasion to watch any video of Miss Ellis at her arraignment for her legal proceedings?
Yes, I saw that.
And the observations that you made when you first met her in person and what you saw in those videos, was that consistent with your observations at North Coast?
Yes, her presentation in the arraignments is similar to her presentation at North Coast with the disengaging, leaning down, the bizarre affect. That is all consistent.
Dr. Testa, to the ordinary person, she looks like she's laughing.
Correct.
While the judge is identifying the most serious of charges. Is there an explanation for that?
Well, as a psychiatrist looking at that behavior does not fit the setting. That does not fit the occasion. It's what we would call an incongruent affect or an incongruent emotional expression. The behavior is just not appropriate for the setting. She also looks to the side at points or looks up. That could indicate that she's perceiving something that none of us can perceive, that is in fact funny or is in fact amusing, but we cannot perceive that. That's another explanation for that behavior. What I can say is that is the behavior that we observed at North Coast while she was off medications. When she got onto medications, that behavior stopped. That symptom is not controllable. So if that indeed is a symptom of schizophrenia, that affective inappropriateness, that is not controllable.
All right, let's bring back in our guest with us, defense attorney and former prosecutor Bob Bionca. And Bob, that was the first witness called by the defense, and I thought it was a great start for them. Certainly, this particular witness was not evaluating her at the time of the incident, but just evaluating her in terms of her competency to stand trial, but clearly talking about the fact that she had schizophrenia and her descriptions of what things she was dealing with, I think very helpful for the defense's case.
Yes. Guys, you know I'm an EMT, and just yesterday I had to go on a call with a 6-month-old that was having difficulty breathing, and I can tell you that your blood pressure, your personal, going on a call like that is ratcheted up 1,000% because it's a little one, vulnerable, innocent, in your hands, just pure innocence. And in this situation, I'm thinking of this child. An innocent child stabbed to death. I'm getting goosebumps thinking about it, and I've been doing this a long time. This is as bad a nightmarish situation, and the person in me wants to just jump out, and can only imagine what those EMTs and police officers, as well as the family, have to deal with this innocent child stabbed to death to no fault of their own. And I'm outraged listening to this testimony. It just gets me so angry. And yet, at the other side of this equation, this woman with her previous psychiatric history, her schizophrenia, as far as the law is concerned, is a classic not guilty by reason of insanity defendant, from what we are listening to right now. And that is a significant psychiatric disorder that's recognized in the medical community, which she has, a previous history, the typical affect as this doctor is testifying. And of course here, there's no motive, there's no relationship, there's no connection between these people. It's a maniac walking around, nobody's even noticing, with a butcher knife in her hand. So I think this strikes fear in our hearts as good people, as mentally healthy people, that a vulnerable, innocent, beautiful, wonderful child came to the end because of a mentally ill and significantly depreciated human being. So the human in me wants to see her go away for as long as humanly possible. By the way, I should say, if she is found not guilty by reason of insanity, that may very well be what happens when she's institutionalized.
And she will be institutionalized, if that's the finding of the jury. Thank you, Bob Bionca, as always.
Folks, coming up, we're going to be able to bring you key testimony you heard in court today in the murder trial against Bionca Ellis. Court has ended there for the day. You don't want to miss it, so stay with us here on Court TV, your front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala. Our Court TV cameras are in Ohio for day 5 of the Toddler Stabbed murder trial of Bionca Ellis. The trial is nearing its end after the defense called its last witness, another forensic psychiatrist. The defense argues that Ellis is not guilty of murdering a 3-year-old boy by reason of insanity, saying she was schizophrenic and had been off her meds at the time of the stabbing and couldn't really appreciate the nature of her actions. However, the prosecution claims that Ellis knew what she was doing when she followed Margot Wood and her son, Julian Wood, out of a grocery store and stabbed them, both killing Julian. Well, today the defense called another forensic psychiatrist who testified